a seasoned voting rights lawyer with 20 years of experience, to debate a little-known academic who'd published one major article on the VRA in an obscure journal. Ironically, Thernstrom benefited from a form of ideological affirmative action that elevated previously liberal critics of civil rights as prominent conservative spokespersons. Thernstrom ultimately declined to testify for fear of upsetting the liberal voting rights lawyers she needed to interview for her book, although she had published a Washington Post op-ed in August 1981 critiquing the VRA despite vowing to stay neutral. But Hatch called scores of neoconservative law and public policy professors like Michael Levin of the City University of New York and James Blumstein of Vanderbilt University to testify against the House bill in her stead. "Those who have been long-time supporters of the Voting Rights Act," said John Bunsell of Stanford's Hoover Institution, "are in retreat because we are troubled by the efforts of some of the sponsors of a new extension to redefine in a major way the meaning and direction of equal electoral opportunity by creating an artificial mix of race and politics." On an overcast, sticky afternoon in June 1981, Jesse Jackson led 2,000 civil rights supporters on a 4-hour march from Strom Thurmond High School, home of the Fighting Rebels, to the Edgefield County Town Square, where a statue of Thurmond stood outside the courthouse. They marched two abreast on Highway 23 through the peach fields of western South Carolina, along the Savannah River, singing "Ain't Gonna Let Strom Thurmond Turn Me Around," as they passed the stately White House where Thurmond had grown up. "To blacks in Edgefield County, the Voting Rights Act has been an Indian treaty," said Jackson, who had grown up 100 miles away in Greenville. "Everybody signed it, but nobody follows it." It was the largest march of black people in Edgefield County since 1881, when 5,000 black residents fled for Arkansas after the end of Reconstruction in the greatest single exodus in South Carolina history. Accompanying Jackson at the head of the line was Tom McCain, a professor of mathematics at Payne College with a Ph.D. in Education Administration from Ohio State University. In 1974, McCain asked Laughlin McDonald of the ACLU's Voting Rights Project in Atlanta, who was from Winsboro, South Carolina, to challenge the at-large structure of the Edgefield County Town Council, which had long been controlled by 5 white men. McDonald retained Durfner as his co-counsel. Though Edgefield was 44% black, as in Mobile, no black had ever been elected to the county council. McCain, who attended segregated schools but had become perhaps the best-educated man in Edgefield County, had run for the council in 1972 and 1974, carrying what would have been his district, but losing county-wide because no white would vote for him. That was just the start of the adversity he faced. His church was burned to the ground. His residence was drawn out of his local voting precinct. The county attorney tried to remove his name from the voting rolls. Judge Robert Chapman, a conservative Nixon appointee on the district court, first heard the case in 1975. He took 5 years to rule, unexpectedly announcing on April 17, 1980, that Edgefield's at-large council violated Section 2 of the VRA. "There is block voting by the whites on a scale that this court has never before observed," Chapman wrote. "Whites absolutely refused to vote for a black." Defner had never been so surprised in his life. Chapman had only once ruled for the plaintiffs in a civil rights case. Then, 5 days later, after the Supreme Court released its decision in Mobile, Chapman was forced to reverse his opinion. It was a familiar story for blacks in Strom Thurmond's hometown, a place that epitomized the savagery of the post-Reconstruction South, where whites seized power violently in 1876 and refused to give it up. "It was the most unrepresentative place you'd ever seen in your life," Durfner said. "Blacks had nothing, and yet they were a huge part of the population. Whites owned stately antebellum mansions surrounded by lush peach fields, while blacks lived in tar-paper shacks with no sewage systems, paved roads, or playgrounds." Following Judge Chapman's ruling, McCain's lawyers discovered that Edgefield had not cleared its shift to at-large elections in 1966 with the federal government as required under Section 5. The DOJ did approve a subsequent change of the size of the council in 1971, but had been kept in the dark about Edgefield's adoption of a new electoral system. McDonald and Durfner sued the county under Section 5. The Civil Rights Division drafted a friend of the court brief backing the black plaintiffs in August 1981. Reynolds signed off on it, then received a call from Thurmond, and pulled the brief 24 hours before the case was to be heard in South Carolina District Court. Reynolds based his decision on new information, but declined to say what it was. "I do it all the time," Reynolds said, of overruling the division's recommendation. "That's a routine kind of experience I have these days." It was yet another setback for Edgefield's black voters. McDonald said it would have been enormously helpful for somebody from the Justice Department to affirm their position that the use of at-large voting had never been pre-cleared. A three-judge court in South Carolina subsequently ruled against McCain. What McDonald called this seemingly interminable lawsuit dragged on. As the Senate debated the VRA reauthorization, Edgefield had still not elected a black county representative in over 100 years. Without extension, McCain told the Senate, there is no hope of ever getting a black elected to county government in Edgefield. There is no hope, in fact, of blacks in my county ever achieving true racial equality. Events in Edgefield County showed the absurdity of the Reynolds-Roberts-Thernstrom-Hatch argument that the House version of Section 2 of the VRA would lead to quotas or proportional representation. It was a scare tactic, Dürfner said. It was a fear that was not justified. In a lot of cases we were talking about, there were no blacks elected. We were trying to get from none to some. In the 7 southern states originally covered by Section 5, blacks made up 25% of the population, but held only 5% of elected seats. 12 of South Carolina's 46 counties had black voting majorities, but the at-large elected state Senate had no black members, making it the only all-white legislative body in the South. 17 years after the passage of the VRA, blacks and other minorities remained severely underrepresented across the country. It was next to impossible to find the inverse of Edgefield, a county where whites made up 44% of the population but had no elected voice. On March 1, 1982, following Reynolds' testimony, the Reagan administration won a major victory when the Senate Subcommittee on the Constitution passed a 10-year extension of the VRA that preserved the Supreme Court's intent test for Section 2. The Senate Judiciary Committee deadlocked on how to proceed. Hatch and Thurmond appeared to be on the verge of killing the House bill. Senator Bob Dole of Kansas, the powerful chairman of the Finance Committee, stepped in to broker a compromise. Dole advised fellow Republicans to make the extra effort to erase the lingering image of our party as the cadre of the elite, the wealthy, the insensitive. Our job now is to demonstrate concern to blacks and others who doubt our sincerity. Dole adopted the House-backed effects test for Section 2, but inserted language quoting the Supreme Court's totality of circumstances standard from White v. Register, and added a disclaimer that a lack of proportional representation was not enough to justify a Section 2 violation. Joe Rao dubbed Dole the Dirksen of the 80s. The critical Republican moderate who at a pivotal moment in the debate embraced the cause of civil rights. It was no compromise at all, Rao said. We got everything we wanted. Opponents of the law could hardly disagree. Reynolds attended an all-night meeting where Kennedy and Dole hammered out the final language of the bill. It was a compromise we were not pleased with, Reynolds said. Roberts was furious. There is no reason to change the permanent nationwide provisions of the Voting Rights Act from an intent test to a results test, he wrote in response to an editorial praising the bill. Colorblind critiques of Dole's compromise quickly emerged from conservative commentators. In 40 years of covering politics, I cannot recall a more lamentable legislative error, wrote the syndicated columnist James Kilpatrick, a longtime defender of segregation. For the first time since the days of Reconstruction, the Dole Amendment would institutionalize racist policies at the very core of our public life. Kilpatrick asked rhetorically, what is this verb dilute? We are creating by this language a protected class of citizens, that is, black citizens, whose block power must not be diluted. The Senate Judiciary Committee passed the Dole Compromise 14-4 on May 4th. A dozen new co-sponsors signed on within 24 hours. Thurmond voted against it, but VRA supporters lobbied him to support the final bill. Every member of the South Carolina House delegation had signed on, as had the South Carolina Senator Fritz Hollings and South Carolina's Governor Richard Riley. Dürfner knew Thurmond was meeting with black mayors to query their votes on the law. Whatever Senator Thurmond says to you, he told Mayor Charlie Ross of Lincolnville, tell him you like the Kennedy-Dole compromise. Dole sold the bill to the upper echelons of the Reagan administration. White House is on board, he told Nees on May 3rd. The North Carolina Senator Jesse Helms, who had replaced Thurman as the Senate's leading civil rights critic, vowed to filibuster until the cows came home. After Helms rallied for 5 days against Big Brother in Washington, the Senate voted 97-0 to silence him. The Senate passed the Dole Compromise on June 18th by a vote of 85-8, the largest margin for the VRA in the body's history. Only 4 of 22 senators from the South, Helms and John East of North Carolina, Jeremiah Denton of Alabama, and Harry Byrd of Virginia, opposed the bill. When the Louisiana Senator Russell Long walked in to cast his yes vote, a reporter asked why he opposed an intent test for Section 2. "The road to hell is paved with good intentions," Long responded. Even Thurman, who didn't want to antagonize his state's growing bloc of black voters, backed the VRA for the first time in his life. The House passed the Senate bill on a nearly unanimous voice vote 5 days later. The extension lasted for 25 years, 3.5 times longer than the 1975 reauthorization. Despite the most conservative president since Herbert Hoover and the most conservative Congress since the 1950s, it was the strongest and most bipartisan Voting Rights Act ever enacted. Reagan signed the bill in the Rose Garden on June 29th. "The right to vote is the crown jewel of American liberties," the president said, "and we will not see its luster diminished." In sharp contrast with LBJ in 1965, who spoke for 20 minutes and handed out 50 pens, Reagan used only 4 minutes and 1 pen, although he did attend a posh reception in the East Room afterward with civil rights leaders like Jackson and Coretta Scott King. Rao, the liberal lion, had been right in early 1981. The civil rights community had challenged Reagan on voting rights, and it had won. "Our fondest hopes in 1981 were exceeded," he said. On October 31st, 1983, Tom McCain and 50 blacks from Edgefield County traveled to Washington for Supreme Court oral arguments in McCain v. Librand. They sat at the front of the courtroom, hoping for a long overdue resolution to their case. 9 years after filing the original lawsuit, the ACLU lawyer Laughlin McDonald argued for the black plaintiffs. The Department of Justice didn't submit a brief until the Supreme Court asked for one, and this time Reynolds did not overrule his Civil Rights Division staff, which maintained the at-large county council plan had never been properly cleared by the DOJ. The Supreme Court unanimously agreed 4 months later, requiring the county to adopt 5 single-member districts. In the 1984 election, 3 blacks, Willie Bright, an AT&T technician, Sarah Williams, a school teacher and dry cleaners owner, and Albert Talbert, a barber, were elected to the council for the first time since Reconstruction. The swearing-in ceremony took place at the Edgefield County Courthouse next to Thurman's statue. "We were able to get representation only because of the Voting Rights Act," McCain said. As its first official action on New Year's Day 1985, the council hired McCain as its county administrator. "The change in the method of elections had a tremendous impact on everything, on all walks of life," said the council's chairman, Willie Bright, who served for 22 years. "We showed we could run the government and do it effectively and fairly. We paved roads for the first time in the black communities, improved garbage collection, changed road signs, got blacks in every office in the courthouse, changed the landfill, got a black magistrate, and started a rural fire department. We made a lot of changes, and it was all new." Following the 1982 reauthorization, similar transformations occurred throughout the country, especially in the South. "The amendment really started things up again," said McDonald. "Cases are being filed. Cases are being won. Cases that have languished are being resurrected." That included Mobile, where a retrial in Judge Pittman's courtroom showed that the city's at-large elections were adopted not as part of a progressive-era reform, as its defenders claimed, but for far more nefarious racial reasons. Peyton McCrary, a professor of history at the University of South Alabama, found the smoking gun, a 1909 letter from the former Mobile Congressman Frederick Bromberg in the Mobile Register, explaining the change from district to at-large elections. "We have always, as you know, falsely pretended that our main purpose was to exclude the ignorant vote," Bromberg wrote, "when in fact we were trying to exclude not the ignorant vote, but the Negro vote." Pittman, for a second time, abolished the city's at-large elections in 1982, this time for good. In July 1985, for the first time in the port city's history, 3 African Americans were elected to the 7-member city council. Herbertine Watson, a pharmacist, and 2 ministers, Charles Tunstall and Clinton Johnson. The former commissioner, Arthur Outlaw, a racial moderate who had opposed the city's decision to appeal the original Mobile ruling, became the new mayor. 2,500 Mobilians attended the swearing-in ceremony. A year later, 93-year-old Wiley Bolden addressed a meeting of the council. A decade after filing the Mobile case, seeing the 3 African-American commissioners gratifies me more than you can know, Bolden said. 6. Challenging the consensus. On a sweltering afternoon in June 1983, Brad Reynolds, Jesse Jackson, and half a dozen lawyers from the Civil Rights Division barreled through the Mississippi Delta in a 26-foot Winnebago that Jackson called the Justice Buggy. The much-maligned civil rights czar had made the trip on Jackson's invitation to investigate violations of the VRA before Mississippi's statewide elections that fall. As was often the case with the loquacious Jackson, they were running behind schedule. Their driver from Memphis, who had a fuzzbuster radar detector, sped along the desolate 2-lane highway between Greenville and Jackson. It was raining ferociously, and the sky above the cotton fields turned a disquieting purple. Jackson and Reynolds were at the front of the bus arguing passionately about affirmative action. It was like an old buddy sitcom. Suddenly, lightning and thunder hit at the same time. The bus shook and nearly skidded off the road. "See, Brad," Jackson responded, "God don't like that shit you're saying." Even the tightly coiled Reynolds had to laugh. He was deep behind enemy lines with Jackson in the Delta. Jackson kept saying, "If we would accompany him to Mississippi, he would show us," said the Deputy Attorney General for Civil Rights, Jim Turner, and by golly, he did. 18 years after the VRA's passage, Mississippi remained a center of massive resistance. At every stop on the 2-day tour, from Greenwood to Belzoni to Canton, black voters approached Reynolds with horror stories about contemporary voting discrimination. White neighborhoods were annexed to dilute black representation. County supervisor districts were gerrymandered to fragment black voters. White plantation bosses and factory owners forced black employees to work overtime on Election Day. Voters had to register twice for county and municipal elections. Polling places were moved from black to white neighborhoods. A black attorney said a local white man had even posed as a Justice Department official to intimidate black voters. "I never heard of anything like that before," Reynolds responded over eggs and grits in a diner in Belzoni. It was an eye-opening experience for Reynolds. "I've heard the difficulties you have in access to registers," he said to Amens at the Pleasant Green Holiness Church in Canton. "I've heard about the polling places that were moved and intimidation at the ballot box. I urge you to step forward so I can hear your story." He called the VRA the most precious of the civil rights statutes on the books and pledged that "we are going to enforce the Voting Rights Act as vigorously as you expect it to be enforced." Reynolds' critics dismissed the trip as a ploy by the Reagan administration to court black voters ahead of the 1984 presidential election. At the end of every stop, he and Jackson, the aristocratic lawyer in a shirt and tie and the country preacher in a beige leisure suit, joined hands and sang, "We Shall Overcome." A day after returning to Washington, Reynolds dispatched 10 federal registrars to 5 counties in Mississippi, former civil rights battlegrounds like Canton, Greenwood, and Ruleville, for the first time in 8 years. Examiner Nealon Burns, a retired federal employee from Atlanta, who had been deputized as an examiner, opened a makeshift office in Ruleville's tiny post office in Sunflower County, the home of Fannie Lou Hamer and the segregationist Mississippi Senator James Eastland. "Do you solemnly swear to faithfully support the Constitution of the United States and the state of Mississippi, so help you God?" he asked Tommy Lee Petty, a black farmhand who had worked for a white plantation owner. "Yes, sir," Petty responded. It was just like the old days in August 1965, when federal officials signed up black voters in droves. In June 1983, the examiners enrolled over 1,000 new voters in one weekend. Jackson's Southern Crusade signed up 40,000 blacks from May to July. In 1967, Petty had registered in the county seat of Indianola, 27 miles away, but had not registered separately for city elections under Mississippi's dual registration law. The law was challenged in the late 1980s under Section 2. "We weren't allowed to vote in Mississippi for a long time," he said. Never been allowed here to do too much. He'd still never voted. Figured it wouldn't do no good. They whites gonna get who they want anyhow. Though Sunflower County was 65% black, the County Board of Supervisors, the most powerful local officials, was all white. Such was the case across Mississippi. Blacks made up 35% of the population, but only 7% of elected officials. Of the 410 county supervisors in 82 counties, just 27 were black. Under Section 5, Mississippi counties were required to submit new redistricting maps for the Board of Supervisors before the 1983 election. The DOJ objected to an unprecedented 36 plans that discriminated against black voters in places like Starkville, where Oktibbeha County officials intentionally fragmented Mississippi State University into 3 districts to prevent black office holders from getting elected with student support. Federal courts postponed elections in 14 counties while non-discriminatory districts were drafted. During the first round of balloting that August, more than 300 federal observers monitored voting in 11 counties. 14 observers were sent to tiny Tunica County on the Mississippi River near the Tennessee border, one of the poorest areas in the country, which Jackson called America's Ethiopia. On August 2nd, the teacher James Dunn became the first black county supervisor in Tunica history. Elsewhere in Mississippi, blacks took control of supervisor boards in Humphreys County, where Lewis and Bond once embraced the white mayor of Belzoni, and Holmes County, the home of the state representative Robert Clark. In total, the number of black supervisors nearly doubled in 1983 and 1984, from 27 to 50. The flurry of activity showed what was possible when the VRA was vigorously enforced. That's what civil rights activists had been trying to tell Reynolds and Reagan for the past 3 years. Just to focus on Mississippi is selective enforcement, Jackson said after the trip. We need comprehensive enforcement of the Voting Rights Act. If Mississippi briefly spotlighted the pro-VRA side of Reynolds, Louisiana showcased the civil rights skeptic that the public was more accustomed to seeing. In late December 1981, Louisiana submitted its redistricting plan for Congress following the 1980 census for DOJ approval. The department had 60 days to decide whether to accept or reject the plan. The submission sent up a lot of alarm bells in Civil Rights Division, Reynolds admitted. The original plan, overwhelmingly passed by the Louisiana legislature, created a majority black congressional district in New Orleans, which was 55% black, and in 1978 had elected Ernest Dutch Morial as its first black mayor. The new district would give voters in New Orleans the opportunity to elect the first black congressman in the state's history. At the time, there were only 2 black members of Congress from the entire South, Harold Ford Sr. from Memphis and Mickey Leland from Houston. Louisiana's Republican governor, David Treen, quickly expressed his displeasure with the legislature, stating, "Any bill in that form is unacceptable and without question will be vetoed." Treen had started out in politics as a member of the States' Rights Party of Louisiana, whose main political platform was the defense of segregation. He had run unsuccessfully for Congress 3 times as a Republican in the 1960s, opposing civil rights laws in voting, education, and housing. He was finally elected in 1972 and served until 1980, voting against nearly every piece of civil rights legislation, including the VRA extension of 1975. Treen defended his veto threat in Reynolds-esque colorblind terms. "What I did do was to question the appropriateness of a deliberate, conscious drawing of congressional district lines for the deliberate purpose of achieving a majority black district," he told DOJ lawyers. "I observed that such motives were inconsistent with our goal of a homogeneous society. In fact, it is demeaning to blacks to suggest that they must be in an absolute majority in order to effect the election of a member of their race. It is also demeaning to them that they will always vote along racial lines. It was a fact in Louisiana, however, that few whites could vote for a black candidate, and that explained why African Americans made up 29% of the population but held no elected statewide posts. The legislature had not overridden a veto by the governor since the 19th century. The 2 most powerful entities in Louisiana, local Pauls joked, were God and the governor, and even that was debatable. In response to Treen's threat, a small group of legislators and state officials secretly met in the sub-basement of the state capitol to draft a new congressional map without a majority black district. No black legislators or officials were part of the process. Representative Pepe Bruno of New Orleans, the chairman of the subcommittee in charge of redistricting, told Lawrence Chihardy, the tax assessor of Jefferson Parish, "We already have a nigger mayor, and we don't need another nigger big shot." Governor Treen stayed until late in the night to review the plan. The new maps fragmented black voters in New Orleans into two congressional districts where they would be a distinct minority, one in liberal urban Orleans Parish and the other in conservative suburban Jefferson Parish, two places with little in common. Whites retained decisive control in both. The effort to marginalize black voters by strategically removing black wards but not white ones left the districts horrifically misshapen. The 2nd Congressional District, represented by the Democrat Lindy Boggs, the widow of the former House Majority Leader Hale Boggs, became known as the Donald Duck gerrymander, with its head and tail on one side of the Mississippi River and its fat body on the other. Robert Quan, a staff attorney in the Civil Rights Division, sent Reynolds a 29-page single-spaced memo explaining why the DOJ should object to the plan. "It is clear in our view that the governor was acutely aware of the racial consequences of his actions, and those racial considerations formed the basis of his actions," Quan wrote. "We conclude that the state has not met its burden of proving the lack of a racial purpose and recommend the interposition of a Section 5 objection." But Treen had one important thing going for him, a close friendship with Reynolds. Reynolds spoke to Treen 9 times on the phone about the plan and paid a personal visit to Louisiana, where he stayed in the governor's mansion and took a helicopter tour of New Orleans with Treen, who assured him the state had done nothing improper. Though the DOJ received over 100 letters from black legislators and community leaders opposing the plan, Reynolds didn't speak with any of them. In the spring of 1982, top officials in the Civil Rights Division, Jim Turner, Jerry Hebert, the voting section chief, Jerry Jones, and the litigation director, Paul Hancock, met with Reynolds to discuss the case. The staffers all agreed with Quan's assessment, urging an objection. But it was clear that Reynolds had been influenced by his friendship with Treen, who'd convinced him that the plan was based on political considerations, protecting the Republican Congressman Bob Livingston in Jefferson Parish, not racial ones. "Your problem, Brad, is that you are biased because you have a friendship with Treen, and you're not going to believe that he could be a product of this intentionally discriminatory plan," said Hebert, the supervising attorney on the case. Turner walked to the chalkboard and said, "I'm going to say this one time." He wrote down the factors DOJ lawyers considered when analyzing a potentially discriminatory redistricting plan: the racial views of the decision-makers, irregularities in the legislative process that disadvantage minorities, deviation from normal map-drawing procedures, the discriminatory effect of the plan, the burden of proof on the submitting authority. "All these factors are present," he told Reynolds. "You should object. I'm going home." Turner threw the chalk at the board and stormed out of the meeting. Reynolds overruled the advice of his attorneys and declined to object. "If you can't convince people to stop even intentional discrimination, that says a lot," Hebert said. The NAACP Legal Defense Fund filed suit against the plan under Section 2 in the Eastern District of Louisiana. Barbara Major, a black community activist in New Orleans, became the lead plaintiff in Major v. Treen. Lanny Grenier, a 33-year-old LDF lawyer from New York, who'd previously worked as a special assistant to Drew Days at the DOJ, produced an 8-foot map of the Duck District, which she displayed prominently in the courtroom. The LDF retained Jerris Leonard, the former Assistant Attorney General for Civil Rights under Nixon, as an expert witness. Leonard called the legislature's plan one of the most egregious and blatant racial gerrymanders that I have seen, and one of only 2 cases that I can think of where legislative bodies overtly intentionally, went out of its way to disenfranchise black voters. In October 1983, the 3-judge district court unanimously ruled for the plaintiffs, concluding that the contours of the 1st and 2nd congressional districts operate to deny or abridge the rights of minority voters, who are accorded less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. It was the first time since 1965 that a congressional redistricting plan approved by the Justice Department had been struck down in court. The legislature subsequently drew a majority black district, which Lindy Boggs continued to represent until her retirement in 1990, when Louisiana elected its first black member of Congress. A year later, Grenier gave a presentation about the case at her office in New York, inviting all the chiefs of the Civil Rights Division. She brought the large map of the Duck District that she had used in court. "Thank you for inviting me to lunch," Reynolds said when Grenier finished her presentation. "I didn't know I was to be the main course." After his landslide re-election in 1984, Reagan named Ed Meese, who had been his ideological alter ego as White House counselor, as his new Attorney General. In his first press conference at the Justice Department in March 1985, Meese announced that he was promoting Reynolds to Associate Attorney General, the number 3 position at the DOJ, which required Senate confirmation. Room 228 of the Dirksen office building was packed when Thurman's Judiciary Committee began hearings on Reynolds' nomination on June 4, 1985. Never had a nomination for Associate Attorney General attracted so much attention. "Mr. Chairman, it is no secret that many of us have serious reservations about this nomination," said Ted Kennedy. "Mr. Reynolds has been the architect of most, if not all, of the administration's retreat on civil rights." Reynolds' hearings became a referendum on Reagan's civil rights policies. The long list of complaints by civil rights activists against the administration included pushing for tax exemptions for segregated schools, fighting tooth and nail against the VRA reauthorization, firing the longtime Republican head of the Civil Rights Commission and 3 commissioners who criticized Reagan's colorblind policies, prosecuting black civil rights activists in Alabama for voter fraud, siding with North Carolina over black plaintiffs in the first Supreme Court challenge to Section 2, and opposing consent decrees in 50 cities for minority and women hiring in government jobs. Civil Rights Division lawyers often celebrated when they lost cases in court because Reynolds had forced them to make arguments at odds with the previous positions of the division. "It's like through the looking glass," said Muriel Spence, a division lawyer who left in 1983 to join the ACLU. "Everything is exactly the opposite of the way it's supposed to be." The NAACP even asked Congress to abolish the Civil Rights Division. "I have difficulty thinking of a single civil rights matter in which I would welcome participation of the U.S. Justice Department," said the NAACP counsel Thomas Atkins. "Under Mr. Reynolds, the Civil Rights Division has changed sides," said LBJ's Attorney General Nick Katzenbach. "It no longer is an advocate for blacks and minorities. It has never happened before under a Democratic or Republican president. It didn't happen under Nixon, or before that under Eisenhower. It's a total change of policy." Reynolds' mentor, Erwin Griswold, distanced himself from his former protege. "I must say I find him more ideological and more rigid and more unforgiving than I would have anticipated," he told the Washington Post. Under Meese, the Justice Department had become even more reactionary. Reynolds' chief deputy, Chuck Cooper, became head of the Office of Legal Counsel, the top lawyer for all government agencies, and chose as his top aide a former assistant to the Solicitor General named Samuel Alito. Stephen Markman, Orrin Hatch's counsel on the Judiciary Committee, took charge of judicial selection as head of the Office of Legal Policy. All 3 young founders of the Federalist Society were hired by the DOJ. John Roberts moved to the White House counsel's office. "This was not the traditional Republican Party," said Meese. "This was a new breed. This was the beginning of the radical right." The same coalition behind the VRA reauthorization of 1982, Nice's Leadership Conference on Civil Rights, mobilized to oppose Reynolds. It dubbed him the Scrooge of the Justice Department. His lax enforcement of the VRA became the centerpiece of the case against Reynolds. "What we tried to do was demonstrate that the DOJ, with Brad Reynolds in the lead, was trying to repudiate what had been a bipartisan consensus on civil rights that went back to the mid-1950s, Nice said. They were not just repudiating, but upending how these civil rights laws had been enforced. Lonnie Grenier and Jerry Hebert urged Senator Joe Biden of Delaware, the ranking Democrat on the committee, who was known for his aggressive prosecutorial style, to focus on the Major v. Treen case. Biden was the same age as Reynolds and from the same state. "I happen to agree with you on busing," he told Reynolds. "I happen to agree with you on your view of quotas. What I have questions about is the degree to which you think that the entire civil rights agenda has been promoted too much by this country." Biden brought up Major v. Treen early in his questioning and returned to it often. "Do you recall whether or not this issue was discussed by you with the voting section staff?" Biden asked. "I certainly discussed the Louisiana redistricting on a number of occasions with people in the voting section," Reynolds said. And would it be fair to characterize the disagreement you had with the voting section staff as one of the more serious disagreements you have had in your tenure there with your staff? Biden followed up. Well, Senator, there was serious disagreement on it, Reynolds responded. I would say that. The reason why I am focusing on that case rather than on all the different cases, Biden said, is because I want to make sure I get a pretty good idea of how you approach these things, what your thought process is. Because your critics suggest, as you well know, not that you are not intellectually competent to hold the post, not that you are not by background qualified to hold the post, and not that you are unfair, but simply that you are very insensitive to the concerns of minority persons. Voting rights lawyers like Grenier and the LDF and Frank Parker of the Lawyers Committee for Civil Rights Under Law supplied the most damning testimony against Reynolds. The Assistant Attorney General speaks in lofty tones about the need for color blindness, Grenier said. Yet where a race-conscious effort is taken to assure re-election of white incumbents, he declines to act. Major V. Treen was one of 30 cases in which Reynolds ignored the recommendation of the Civil Rights Division to object to a discriminatory voting change, and one of 5 cases in which a voting change cleared by the department was later overturned in court. The Section 2 unit of the voting section had filed only 10 new lawsuits from 1982 to 1985, Parker told the committee, and none in Louisiana, Mississippi, South Carolina, Texas, or Virginia. Voting rights lawyers grumbled that the ACLU Voting Rights Project in Atlanta, which had 3 lawyers, filed more new cases than the 27 lawyers at the DOJ's voting section. Whereas the Nixon and Ford administrations had blocked over 5% of voting submissions under Section 5, that figure fell to 1% under Reagan. Parker later estimated that private lawyers filed 10 times as many voting cases as the Justice Department during the Reagan years. Of the 1,792 voting rights cases filed in federal court between 1981 and 1988, the U.S. government initiated only 4% of new lawsuits. You have been active in the voting rights litigation. You were at the Justice Department. You are very familiar with voting rights cases, the Ohio Democratic Senator Howard Metzenbaum told Grenier. You know Mr. Reynolds' testimony in this area. Do you agree that he has provided strong advocacy in the voting rights area, or are you in disagreement with his position? My brief answer is that I disagree strongly as I possibly could, with his statement that he is vigorously enforcing the Voting Rights Act, Grenier responded. Metzenbaum then asked her, I wonder if you would rate Mr. Reynolds in your own mind. A, he is against discrimination of all kinds. B, he is reasonable. C, he is objective and impartial in racial cases. D, he is somewhat prejudicial against black rights. And E, he is a bigot. Where would you rate him, because I am having trouble? F, she responded. In an attempt to portray himself as a champion of the VRA, Reynolds repeatedly told Congress one thing when he'd done another. He said that he'd discussed the Louisiana redistricting case with black officials and their lawyers, but Bill Quigley, the principal lawyer representing the black plaintiffs, said that neither I nor any of the people that objected were ever allowed to meet with Mr. Reynolds. The committee held 2 days of contentious hearings in early June 1985. After a 2-week break, Thurman reconvened on June 18th to give Reynolds a chance to clarify his statements. Instead, he dug himself a deeper hole. During the VRA reauthorization hearings in 1982, Reynolds had told Senator Arlen Specter of Pennsylvania that he believed the DOJ should not intervene in a case challenging at-large elections in Burke County, Georgia, which had a black population of 53% but no black county commissioners. In the lower courts, the DOJ had filed a lengthy amicus brief supporting the black plaintiffs. Specter obtained a memo during Reynolds' confirmation hearings showing that Reynolds had urged Solicitor General Rex Lee to intervene against the black plaintiffs in Georgia, contradicting his testimony in 1982. The Supreme Court subsequently ruled 6-3 in Rogers v. Lodge in July 1982 that the election system was intentionally discriminatory. Wasn't your response to me deceptive? Specter asked Reynolds. I apologize to you if I left an impression otherwise, Reynolds responded. Well, Mr. Reynolds, I find that hard to accept, Specter said. Toward the end of the last day of hearings, Biden asked Reynolds, maybe you could answer for me why, if you believe as you do, that you have been so vigorous in the support of and the concern for minorities in this country, they don't seem to like you very much. Reynolds responded, I think that what we are talking about here is a difference of opinion on fundamental principles that are highly emotional, and I have, for whatever reasons, become the personification of those issues. In a sign of just how important the nomination was for the administration, Reagan devoted his weekly radio address to defending Reynolds, whom he called a tireless fighter against discrimination and a brilliant and dedicated lawyer. Reagan called the GOP senators Specter and Mathias to urge them to back Reynolds. But 10 days after the hearings ended, Specter and Mathias joined 8 Democrats in defeating Reynolds' nomination 10-8. It is now clear that Mr. Reynolds does not support the approach that Congress for the past 20 years has taken to the problem of assuring civil rights, Mathias said. Thurmond tried and failed 3 times to advance the nomination to the full Senate, despite the committee's no vote. The chairman has railroaded the vote, Metzenbaum said. I have not railroaded anything, Thurmond angrily responded. Reynolds blamed the vote on the pro-busing, pro-quota lobby, but it was his opposition to voting rights and his contradictory testimony about his actions in that area that sank his nomination. The detailed attention to cases like Major v. Treen helped shift the focus of Reynolds' confirmation hearings from the murky political ground of busing and quotas to the moral high ground of voting rights, noted the Washington Post. Reynolds' defeat reaffirmed the bipartisan consensus in Congress for civil rights and voting rights in particular. The traditionalists won. The radical revisionists of the Reagan administration are, for the present, routed, wrote the Los Angeles Times. Reynolds dismissed his defeat as partisan politics and vowed to continue as head of the Civil Rights Division. Reagan told him, "Don't you go anywhere. I'm counting on you to stay." I got battered around quite a bit, Reynolds said afterward. The lines were always drawn on the politics of it. The Democrats were ready to bash the administration and play the race card as much as they could because they thought it was politically advantageous for them to do that. So anything and everything that I did was labeled racist by the other party. But the civil rights lawyers who worked under Reynolds, Democrats and Republicans, shared the Senate's bipartisan critique. The basic criticisms of Brad were substantial and correct, Jim Turner said. The irony was that without his promotion, Reynolds would still be their boss, and under Meese he'd become more powerful than ever. Following his defeat, the National Review called Reynolds one of the heroes of the Reagan Revolution. In the early 1960s, 2 black teenagers, Milton F. Fitch, Jr. and George K. Butterfield, Jr., jumped into the large segregated swimming pool in their hometown of Wilson, North Carolina. After they were caught, the city drained the entire pool before reopening it for whites. Fitch was tall and dark-skinned, Butterfield short and exceptionally light-skinned. He looked Italian, with an olive complexion and black hair, and in most places could have easily passed for white. But not in Wilson, an eastern North Carolina tobacco town of 100,000, where the railroad track separated the white mansions on the west side from the shotgun houses on the historically black east side, where Fitch and Butterfield lived. Thanks to the tobacco harvest, the west side of Wilson had the highest number of millionaires per capita in North Carolina. The east side had few paved roads and such a poor sewer system that the streets flooded whenever it rained. The 2 boys came from prominent activist families. Fitch's father became the city's first black postman since Reconstruction and the North Carolina coordinator for the SCLC. Butterfield's father, a dentist, served as Wilson's first black elected official in the 20th century. Nonetheless, their sons attended segregated schools. In 1953, G.K. Butterfield Sr. joined the Wilson City Council. He was re-elected in 1955, and after supporting the white mayor, was put in charge of the city's budget committee. Butterfield traveled to Raleigh to present the city's budget to the state legislature, as was the custom. After the presentation, the white state representative from Wilson sponsored an act changing the city's elections from ward districts like Butterfield's on the east side to at-large. Butterfield lost the next election. Another African-American wouldn't be elected to the city council for the next 2 decades. After attending college and law school together at North Carolina Central University, a historically black college in Durham, Fitch and Butterfield opened a small law firm in Wilson on the east side of the tracks. They tried repeatedly to integrate the city's political system. Butterfield ran for the city council in 1977 and lost. So did Fitch Sr. in 1979. Fitch Jr. lost by 8 votes in 1981. Winning election to the state legislature wasn't any easier. State representatives hailed from multi-member districts where black voters were submerged in large white areas to prevent black candidates from getting elected. House District 8 consisted of Wilson, Edgefield, and Nash counties, where blacks made up 40% of the population, but all 4 state representatives were white. The same was true of major cities like Charlotte, Durham, Raleigh, and Winston-Salem, where few, if any, blacks had been elected to the state legislature as late as 1980. In the early 1980s, Butterfield talked with Julius Chambers, the leading civil rights lawyer in North Carolina, about challenging the state legislature's multi-member districts under Section 2. The Supreme Court had invalidated similar districts in the Texas legislature in White v. Register in 1973. Chambers had been born a decade before Butterfield, 150 miles west of Wilson, in the small rural town of Mount Gilead. His father, Shine, worked as a car mechanic and had saved up to send Julius to a prestigious private school before a white customer refused to pay for $2,000 of work on his 18-wheel rig. No white lawyer would take Shine's case, and Julius had to attend the dilapidated segregated public school 12 miles away, which lacked even a library. That's when he decided he wanted to become a lawyer. Chambers finished high school in May 1954, the same month as Brown v. Board of Education, became student body president of North Carolina College in Durham, got a master's in history from the University of Michigan, and then served as the first black editor of the Law Review at the University of North Carolina, Chapel Hill. Despite having graduated at the top of his class, Chambers was not invited to the year-end banquet at the segregated Chapel Hill Country Club. In early 1965, after opening the state's first integrated law firm, Chambers filed suit to desegregate Charlotte's public schools. While speaking at a mass meeting at a church in the coastal town of New Bern, Chambers heard a loud boom. He went outside to find his car in flames. "What are we going to do?" asked his law partner, Geraldine Sumter. "We're going to go back inside and finish the meeting," Chambers said. "There's nothing we can do about that car." Later that year, after Chambers filed suit to desegregate the Shrine Bowl, an all-star game between high school football players from North Carolina and South Carolina, dynamite blew out the window in his front bedroom while Chambers and his wife were in bed. After Chambers won landmark discrimination cases in education and employment in the early 1970s, his Charlotte law office was firebombed, forcing him to relocate the practice to a hotel. His stoic persistence and religious sense of drive made him the state's most effective civil rights lawyer. Chambers eagerly took on the case challenging the North Carolina legislature in 1981, targeting 6 multi-member districts in large urban areas where few blacks had been elected. There were parallels between this case and Major Vitrine, said Guinier, who worked with Chambers. The state was trying to bury the power of black voters. Ralph Jingles, a lawyer in Gastonia, who had worked for Chambers as a law student one summer, became the lead plaintiff. At the beginning of 1984, a 3-judge district court in North Carolina unanimously ruled in Chambers' favor. In Wilson's House District 8, for example, Butterfield testified that 90% of whites refused to vote for a black candidate. The racial polarization in voting was so extreme, the court said, that all other factors aside, no black has any chance of winning election in the district as it is presently constituted. After Chambers filed the lawsuit, 11 new black representatives were elected to the state legislature in 1982. They included 6 from the challenge districts. North Carolina said that was proof that multi-member districts were not discriminatory. The court disagreed. The success that has been achieved by black candidates to date is, standing alone, too minimal in total numbers and too recent in relation to the long history of complete denial of any elective opportunities to compel or even arguably to support an ultimate finding that a black candidate's race is no longer a significant adverse factor in the political processes of the state, either generally or specifically in the areas of the challenged districts, wrote Judge James Dixon Phillips, a Carter appointee. North Carolina, backed by the Reagan administration, appealed to the Supreme Court in the first major test of the 1982 reauthorization of the VRA. In its brief before the court, the federal government supported a southern state over minority plaintiffs in a voting case for the first time since 1965. The administration hopes to win in court the fight it had lost in Congress in 1982 over Section 2. If left undisturbed, said the Solicitor General's brief, which had been written by Brad Reynolds and Chuck Cooper, the lower court's decision means that wherever there has been discrimination in the past and some measure of racial polarization in voting in the present, district courts will be free to strike down virtually any scheme that does not, or even those that do, deliver electoral successes proportional to minority voting strength. Reduced to its essentials, the argument is the familiar one emanating from Reagan officials these days, responded Laughlin MacDonald of the ACLU, that anything more than tokenism in civil rights is a quota or a form of prohibited affirmative action. The 10 major co-sponsors of the 1982 reauthorization in Congress, 5 Democrats and 5 Republicans, led by Bob Dole, filed a response before the Supreme Court rebuking the government's position. The administration's interpretation of the law would pose as significant an impediment to the enforcement of Section 2 as the specific intent rule of City of Mobile v. Bolden, 1980, rejected by Congress in 1982, they wrote. The RNC and the North Carolina Republican Party, believing that multi-member districts also deprived Republicans of fair representation, backed the members of Congress. The oral arguments before the court in late December 1985 mirrored the debate over Section 5 in the Allen case 17 years earlier. North Carolina and the Reagan administration maintained that because blacks participated in the political process without hindrance in North Carolina, there could be no violation of the VRA. We contend that by applying the law as the court did, and by fashioning the remedy in the manner in which it did, that it expanded the scope far beyond the intent of Congress in the passing of this act, said North Carolina's Attorney General Lacey Thornburg. Chambers, who had become the third director counsel of the LDF in 1984, following in the footsteps of legendary civil rights lawyers Thurgood Marshall and Jack Greenberg, argued for the black plaintiffs. He was used to battling southern states, but this was the first time he faced the federal government as the enemy before the Supreme Court. Chambers contended that the totality of circumstances in North Carolina clearly showed that blacks were disadvantaged when it came to electing candidates from multi-member districts. We have substantial racial block voting, he said. We have substantial racial appeal. We have substantial submergence of blacks in each of the districts. We have all the factors that make for dilution of black votes. The Supreme Court unanimously agreed on June 30, 1986, in Thornburg v. Jingles. The language of Section 2 and its legislative history plainly demonstrate that proof that some minority candidates have been elected does not foreclose a Section 2 claim, wrote Justice William Brennan. Where an electoral system generally works to dilute the minority vote, it cannot be defended on the ground that it sporadically and serendipitously benefits minority voters. Brennan devoted half of his 47-page opinion to rebuking the Reagan administration's brief point by point. In a highly publicized speech at the University of Missouri that year, Reynolds had called Brennan's radical egalitarianism perhaps the major threat to individual liberty in the United States. In a sign of the growing voting rights divide on the court, 4 justices, Sandra Day O'Connor, William Rehnquist, Lewis Powell, and Warren Burger, joined the court's judgment but not its opinion. Wrote O'Connor, in my view, the court's test for measuring minority voting strength and its test for vote dilution operating in tandem come closer to an absolute requirement of proportional representation than Congress intended when it codified the results test in Section 2. She was referring to the 3 factors that Brennan deemed necessary to win a vote dilution suit under Section 2. First, the minority group must be able to demonstrate that it is sufficiently large and geographically compact to constitute a majority in a single-member district. Second, the minority group must be able to show that it is politically cohesive. Third, the minority group must demonstrate that the white majority votes sufficiently as a bloc to enable it, in the absence of special circumstances, usually to defeat the minority's preferred candidate. The 1982 reauthorization of the VRA and the new Jingles test facilitated a great increase in minority voting power. The number of successful Section 2 cases skyrocketed from 3 in 1981, after the Mobile decision, to 175 in 1988, according to the California Institute of Technology historian Morgan Kauser. Section 2 became the sword of the VRA, the offensive weapon used to strike down discriminatory electoral schemes, while Section 5 became the shield, the defensive mechanism preemptively protecting minority voters from discriminatory voting changes. The Jingles case had an enormous immediate impact across the South, including in North Carolina. As a result of newly drawn single-member districts, the number of blacks in the state legislature increased from 4 in 1981 to 19 by 1990. Toby Fitch was elected to represent Wilson. He was to become House Majority Leader, the second most powerful position in the body, serving for 19 years. Butterfield filed suit against the Wilson County Commission and School Board to redraw their district lines, helping to elect 3 black office holders to each of the previously all-white institutions. After facing another lawsuit based on Jingles, North Carolina also drew new judicial districts, which resulted in the election of 8 new black judges in 1988. One of them was Butterfield. He took up residence as a state superior court judge on the 3rd floor of the Wilson County Courthouse, overlooking the white marble steps where he had protested Jim Crow laws 25 years earlier. "I never thought I'd have a key to the courthouse," he said. In the 1980s, the courts and Congress, with the prodding of determined local activists and lawyers, repeatedly prevented the Reagan administration from enacting its most extreme civil rights policies, especially in the field of voting rights. Despite these setbacks, the administration developed a long-term strategy for implementing its vision, which centered on changing the courts. Starting in 1981, Bruce Fine, an assistant to the Deputy Attorney General, organized the White House Justice Department Judicial Selection Committee, chaired by Meese, to interview and screen prospective candidates for the bench. The effort grew in prominence during Reagan's second term, when Stephen Markman, after serving as Senator Hatch's counsel and the Washington director of the Federalist Society, became head of the Office of Legal Policy. Reagan put in place the most thorough and comprehensive system for recruiting and screening federal judicial candidates of any administration ever, Markman said. He worked closely with Reynolds and Cooper to make sure ideologically committed conservative justices were appointed. "I'm convinced that the right decided in 1982-1983 with the Federalist Society that the judiciary was their strategy," Nees said. "If they were going to remake civil rights laws, they would have to stack the courts." In 1986, when Chief Justice Burger announced his retirement, Reynolds persuaded Meese and Reagan to nominate Rehnquist as his replacement. As with his initial nomination in 1971, Rehnquist's past and present views on voting rights became a major topic of debate during his second round of confirmation hearings in July and August 1986. His challenges to minority voters in Phoenix in the 1960s attracted renewed scrutiny. James Brosnahan, the assistant U.S. attorney in Phoenix from 1961 to 1963, traveled to Washington to testify against Rehnquist. In 1971, Rehnquist told Congress, "In none of these years did I personally engage in challenging the qualifications of any voters." Brosnahan testified, "This does not comport with my recollection of the events I witnessed in 1962, when Mr. Rehnquist did serve as a challenger." On Election Day 1962, the U.S. Attorney's Office in Phoenix received numerous complaints that voters at predominantly black and Hispanic precincts in South Phoenix were being challenged aggressively, without cause, at the polls. It was my opinion in 1962 that the challenging effort was designed to reduce the number of black and Hispanic voters by confrontation and intimidation, Brosnahan said. After receiving a complaint from the FBI, Brosnahan went to investigate at the Mary McLeod Bethune School. "At that polling place I saw William Rehnquist, who was known to me as an attorney practicing in the city of Phoenix," he said. "He was serving on that day as a challenger of voters. That is to say, the complaints had to do with his conduct." Multiple witnesses, the Arizona State Senator Manuel Peña, the former Democratic Party Chair Charles Pine, the Democratic activist Michael Merkin, relayed similar accounts to the Senate Judiciary Committee. Sidney Smith, a clinical psychologist, said he saw Rehnquist approach 2 black men and tell them, "You are not able to read, are you? You have no business being in this line trying to vote. I would ask you to leave." Kennedy asked Rehnquist directly about the allegations. Kennedy: "Have you ever personally challenged any individual in any precinct?" Rehnquist: "I do not think so." Kennedy: "Well, you would know it, would you not, if you did?" Rehnquist: "I am not entirely sure. I cannot recall ever challenging any person, but if you are asking me about whether over a period from 1953 to 1969 I ever challenged a voter at any precinct in any election, I am just not sure my memory is that good. Rehnquist's alleged conduct toward minority voters heightened anxiety about his voting rights record on the court. Consistent with Rehnquist's harassment of black Phoenix voters, Justice Rehnquist has repeatedly voted against racial minorities in cases concerning the right to vote, testified Julius Chambers. On 18 occasions, Rehnquist had written or joined opinions trying to limit the scope of the VRA. Kennedy filibustered the nomination. Imagine what America would be like if Mr. Rehnquist had been the Chief Justice and his cramped and narrow view of the Constitution had prevailed in the critical years since World War II, the Massachusetts senator said. The schools of America would still be segregated. Millions of citizens would be denied the right to vote. But the Senate had become familiar with Rehnquist over his 15 years on the court, and he was well liked by his colleagues. Bob Dole, who had partnered with Kennedy on the VRA, led the effort to end the filibuster. Rehnquist was confirmed 65-33 on September 17, 1986. The former Lone Ranger, whom the New York Times called once a lonely dissenter on the court's extreme right wing, had become its new leader. 10 minutes after Rehnquist's confirmation, the state unanimously confirmed the Court of Appeals Judge Antonin Scalia as Rehnquist's replacement. Scalia was even more conservative than Rehnquist, but attracted little scrutiny because of the Rehnquist nomination. We couldn't fight on two fronts at once, Nees said. Nominating Scalia immediately after Rehnquist was a brilliant strategic move by the Reagan administration. In the span of 10 minutes, the Supreme Court shifted significantly to the right. Emboldened by the confirmations of Rehnquist and Scalia, the President nominated Robert Bork, the Solicitor General from 1973 to 1977, and a Court of Appeals judge under Reagan, to fill a third vacancy in the Supreme Court after Justice Powell retired in 1987. Like Rehnquist, Bork took a dim view of the civil rights laws of the 1960s. Like Scalia, he subscribed to an originalist interpretation of the Constitution, believing that the courts should defer to the views of the founders rather than base their decisions on contemporary circumstances, an ideology that Mies popularized in a series of high-profile speeches beginning in 1985. The originalist philosophy advocated a passive approach to the problem of racial discrimination. As a Yale law professor in the early 1960s, Bork opposed the Civil Rights Act of 1964. The principle of such legislation is that if I find your behavior ugly by my standards, moral or aesthetic, and if you prove stubborn about adopting my view of the situation, I am justified in having the state coerce you into more righteous paths, he explained. That is itself a principle of unsurpassed ugliness. As a professor, government advocate, and judge, Bork also defended the poll tax in Texas and the literacy test in Virginia, questioned the constitutionality of the VRA in 1965 and 1970, and criticized the court's one-person, one-vote doctrine. The first black Democrats elected to Congress from the South since Reconstruction, Barbara Jordan and Andrew Young, testified against Bork on the first day of his confirmation hearings on September 21, 1987. Thanks to C-SPAN, it was the first time that many Americans had ever watched a judicial confirmation hearing. Had Judge Bork's truncated view of the First Amendment prevailed, Young, who had been elected mayor of Atlanta in 1981, told Congress, Dr. Martin Luther King, Jr. would not be a venerated national hero. He would instead be serving a jail sentence in Alabama, and the nonviolent method of social change might never have found root on American soil. The Leadership Conference on Civil Rights organized a formidable Block Bork coalition with a $2 million ad campaign, the most sophisticated effort yet to defeat a Supreme Court nominee. People for the American Way ran TV ads featuring Gregory Peck, best known as Atticus Finch in To Kill a Mockingbird. Robert Bork wants to be a Supreme Court justice, but the record shows that he has a strange idea of what justice is, Peck said. He defended poll taxes and literacy tests, which kept many Americans from voting. Unlike Rehnquist, Bork had a confrontational demeanor that won him no new allies in the Senate. The Reagan administration, with Reynolds in charge of Bork's confirmation, had badly overplayed its hand. On October 23, 1987, 6 Republicans joined 52 Democrats to torpedo Bork's nomination 58-42. The impact of the VRA led to Bork's defeat. In 1965, 16 of 22 Southern senators had opposed the VRA. 23 years later, 16 of 22 Southern senators voted against Bork. That included the crucial swing votes of Senators Terry Sanford of North Carolina, Howell Heflin and Richard Shelby of Alabama, and John Breaux of Louisiana, all of whom were elected in either 1984 or 1986 after losing the white vote but carrying more than 75% of the black vote. The country's growing black electorate helped Democrats regain the Senate in 1986 and defeat Bork a year later. I think, more than anything, the defeat of that nomination was testimony to the effectiveness of the Voting Rights Act, said William Taylor, vice chairman of the Leadership Conference on Civil Rights. There were substantial black constituencies in every one of those 11 states, and the senators representing those states had to take into account those constituencies when they were casting their vote. After Reagan's initial replacement for Bork, the Court of Appeals Judge Douglas Ginsburg withdrew his nomination following the revelation that he had smoked marijuana in college. The president chose Judge Anthony Kennedy of the Ninth Circuit Court of Appeals to fill the vacancy. The Senate unanimously confirmed him in February 1988. Kennedy was less conservative than Bork, but more conservative than his predecessor, Justice Powell. Reagan's 4 Supreme Court appointees, O'Connor, Rehnquist, Scalia, and Kennedy, all were more conservative than the judges they replaced, and soon formed the core of the Rehnquist Court's Federalism 5. The Supreme Court was just one aspect of the administration's judicial strategy. By the end of his time in office, Reagan had appointed half of all federal judges, 78 to the Court of Appeals and 280 to the District Court. To a startling degree, the judges reflected the ideology and makeup of the Reagan administration. Of the appointees, 94% were white, 95% were male, and 95% were Republican. Reagan's judicial appointments became the most enduring legacy of his counter-revolution. Presidents and Congresses come and go, but judges serve for a generation. The new federal judiciary, Nees wrote in 1989, may accomplish what Edwin Meese, William Bradford Reynolds, and their allies were unable to achieve. Reynolds agreed. I think they had a major impact, he said. They were very, very helpful in reshaping civil rights policies from when Reagan first started. Weary of leaving anything to chance, the Justice Department developed comprehensive marching orders for new judicial appointments and future administrations. Markman's Office of Legal Policy on February 19, 1988, issued its Guidelines on Constitutional Litigation, a detailed booklet expressing the Reagan administration's view of the law. The guidelines were deeply influenced by Meese's originalist jurisprudence and Rehnquist's views on federalism. They specifically targeted Congress's powers under the enforcement clauses of the Reconstruction Amendments, which formed the basis of the VRA and the landmark civil rights laws of the 1960s. Supreme Court decisions named as inconsistent with the Reagan administration's views included a series of cases upholding the constitutionality of the VRA and its subsequent reauthorizations. In September 1987, Harvard University Press and the 20th Century Fund published Abigail Thernstrom's long-awaited book, Whose Votes Count? Affirmative Action and Minority Voting Rights, the first substantive book-length critique of the VRA. She argued the law was an emergency measure taken with the expectation that it would be lifted as soon as conditions allowed. Yet as the emergency subsided, emergency powers paradoxically expanded. The more potent the legislation became, the fewer were the objections raised. Thernstrom attributed the VRA's powerful longevity to the myth of moral simplicity, which had largely insulated the voting rights issue from debate. Her targets included Justice Department bureaucrats, opportunistic politicians, voting rights lawyers, the mainstream media, and liberal foundations, all colluding to promote the VRA. Even the Reagan administration, she maintained, had been too meek to take on the civil rights establishment. In the enforcement of minority voting rights, its record has differed little from that of its predecessors, she argued. Thernstrom portrayed herself as one of the few intellectuals brave enough to challenge voting rights orthodoxy. Voting rights has become another immensely complex affirmative action issue, distinctive only in not being acknowledged as such, she wrote. To Thernstrom, the election of the first black officeholders in places like Mobile, Alabama, Edgefield County, South Carolina, Wilson, North Carolina, and Selma, Alabama, were not historic achievements, but examples of pernicious social engineering. It is scarcely an exaggeration to say that affirmative action in the electoral sphere has only adherents, she wrote. The opposition to busing and to affirmative action goals and timetables is loud and clear. Protest against racial gerrymandering to increase minority office holding is too muted to be heard. The book received mixed reviews in the mainstream press. She argues what she thinks, not what she can prove, Adam Clymer wrote in the New York Times, and it was skewered mercilessly by voting rights experts. The book so distorts the evidence that it cannot be taken seriously as scholarship, wrote Pam Carlin, Associate Counsel at the LDF, and Peyton McCrary, Professor of History at the University of South Alabama, in a detailed critique in the University of Virginia Journal of Law and Politics. Thernstrom's work, however, is not only careless, Carlin and McCrary wrote, rather it is crafted to serve a conservative political agenda. Judicial acceptance of her interpretation would cripple the Voting Rights Act as a tool for enabling minorities to elect representatives of their choice. But the book won a hero's embrace in conservative and neoconservative political circles. She has shown an unusual degree of intellectual courage in challenging the acceptable wisdom on the Voting Rights Act, wrote John Fund in the Wall Street Journal. Her book is a first-rate contribution on an issue of enormous significance, equal electoral opportunity, and her analysis is all the more welcome since the goal of proportional representation has occasioned so little public debate, seconded Harold Stanley in the New Republic. Despite her criticism of the Reagan administration as too friendly to voting rights, which civil rights activists who'd been battling the administration since day one viewed as laughable, top officials in Reagan's DOJ embraced Thurman's book. The political appointees were reading it, said Jerry Hebert. The rest of us read it and thought it was nonsense. A lot of the arguments she raised were arguments we had to knock down with John Roberts and Brad Reynolds and Chuck Cooper. Whose Vote Counts appeared at the perfect moment for Thernstrom. Like her public interest essay, which came out at the dawn of the Reagan era, her book was published just as Reagan's disciples took control of the courts. The book became a virtual Bible among conservative jurists, wrote Adam Schatz in the American Prospect. The judges and advocates embracing Thernstrom's arguments were to shape the direction of voting rights law for decades to come. 7. The Realignment. On October 31, 1985, John Lewis and Julian Bond had lunch at the Marriott Hotel in downtown Atlanta. Congressman Wyche Fowler, a liberal white Democrat who had represented Georgia's 5th District since Andrew Young became UN ambassador in 1977, had privately announced he was going to run for the Senate. That left an opening for the coveted congressional seat in Metro Atlanta. Bond and Lewis met at noon to discuss the impending vacancy. They both were 46, close friends since the first SNCC convention in Raleigh during Easter weekend in April 1960. When Lewis was beaten and hospitalized on Bloody Sunday, Bond coordinated SNCC's press response from Atlanta. He still called Lewis Mr. Chairman from his days as leader of SNCC. Mr. Chairman, what are you going to do? Bond asked Lewis. I'm going to run for Congress, Lewis replied. What are you going to do? I'm going to run for Congress, Bond responded. It was a very short lunch. I'll see you on the campaign trail, Lewis said. The Bond versus Lewis contest symbolized how few opportunities there were for black politicians 20 years after the passage of the VRA. In 1986, there were only 4 majority black districts in the entire South and a mere 2 African Americans from the region in Congress. Outside Atlanta, there was no place a black person could be expected to be elected to the Congress, Bond said, so it was this seat or none. That's how 2 icons of the civil rights movement, who had been best friends in the 1960s and 1970s, ended up as fierce opponents on the campaign trail. After heading the voter education project for 7 years, Lewis had first run for the 5th District in 1977 against Fowler. I was drawn to it because of my work with VEP and SNCC, but also because of the assassination of Dr. King and Bobby Kennedy, he said. I just felt like I had to pick up where they left off. After losing badly, he followed Young to Washington, working as the Associate Director of Action, which directed federal volunteer programs. He traveled 200,000 miles in 3 years to 42 states, writing long memos to the White House urging the Carter administration to boost anti-poverty funding for beleaguered communities like poor whites in Appalachia. The Washington bureaucracy was not for him. In Washington, I have found so many people unwilling to take a chance, to take a risk, he said. I really want to be out there agitating. He returned to Atlanta and won an at-large seat on the city council in 1981, representing the entire city. I had strong biracial support in the city, he said, so I felt like if we had the necessary resources and we got out there with Julian one-on-one, I would prevail. Bond had his own reasons for wanting to run. Indeed, Lewis had urged Bond to run for Congress in 1972 before Young got in. As a state senator in 1980, Bond introduced legislation increasing the black population in the 5th District from 50% to 69%, which would virtually guarantee his victory. The Georgia legislature, which was still dominated by whites, blocked Bond's bill. "I'm not going to draw a nigger district if I can help it," said Representative Joe Mack Wilson, a Democrat from Marietta who was chair of the House Redistricting Committee. Instead, the legislature increased the black population of the 5th District to 57%, but whites remained 54% of registered voters. As in 1972, when the legislature tried to remove black voters from the district before Young ran, the Justice Department once again refused to approve the plan under Section 5. A federal court found it was enacted with intentional discrimination. In response, the legislature increased the district's black voting age population to 65%, making it a majority black district for the first time. Bond began as a huge favorite. He'd been a household name since the Georgia legislature refused to seat him in 1966. He'd been nominated for vice president at the Democratic Convention in 1968 at 28, hosted Saturday Night Live in 1977, and earned $150,000 a year on the lecture circuit. The Temptations performed at a lavish fundraiser for his campaign. Endorsements came from Rosa Parks and Ted Kennedy, and checks rolled in from Hugh Hefner, Bill Cosby, Frank Zappa, and Paul Simon. Andrew Young, Atlanta's mayor, officially stayed neutral, but his closest advisers backed Bond. Bond drove a Peugeot, Lewis a blue Chevy. Bond opened a campaign office in a spacious tire dealership featuring a 5-foot-tall replica of his face on the cover of Ebony. Lewis worked out of a dingy storefront 6 blocks away next to the Gospel Light Rescue Mission. Lewis couldn't match Bond's celebrity and sex appeal, so he instead emphasized his blue-collar roots. "It's time to send a tugboat to Washington and not a showboat," he said. The Morehouse College political scientist Professor Toby Johnson dubbed the race Julian the Patrician against John the Plebeian. A cartoon in the Atlanta Journal-Constitution depicted Bond as Goliath and Lewis as David. "I wonder what power is behind that shepherd boy," asked the towering Bond, outfitted with sword and armor. Lewis, crouching in a loincloth, clutched a bone and a rock. "One more chance to save the 5th District voters," he said. Bond bested Lewis 47 to 35% in the first round of voting. Bond won the black vote by 2-1. Lewis won the white vote by 2-1. Because neither candidate garnered over 50%, the race went to a runoff. As he'd done his entire life, Lewis outworked Bond in the runoff, going through 2 pairs of shoes on the campaign trail. He'd start the day at the crack of dawn, shaking hands at MARTA train stations, and end late in the night at 24-hour grocery stores. "I went from door to door, literally running," he said. "I think it's paying off." "Beat City Hall! Beat City Hall!" his supporters chanted outside his small storefront headquarters on election night. The crowd fell silent as Lewis's staff recorded the vote. Then came a deafening cheer as the results were announced. Lewis had recorded a stunning upset, narrowly defeating Bond by 2,000 votes, 52 to 48%. He'd won 84% of the white vote and 41% of the black vote, uniting moderate whites and working-class blacks in his own version of Jesse Jackson's Rainbow Coalition. At 10:50 p.m., Lewis stepped up to the microphones to announce his victory. "For a boy who grew up poor in Alabama, son of a sharecropper, we have come a distance," he said. "We have witnessed a nonviolent revolution. Today we sent a message." John Lewis got his voters to the polls. "I think a lot of Julian's people were so busy getting dressed for the victory party that they forgot to vote," quipped the SCLC's chairman, Joe Lowry. The Washington Post columnist David Broder dubbed it a victory for all the infantry grunts in the world over the Air Force glamour boys. Lewis easily defeated the Republican Portia Scott, editor of the Atlantic Daily World, in the general election. He took a 13-hour train ride to Washington for his inauguration in the 100th Congress. He was accompanied by 40 friends who carried red, white, and blue balloons, cold champagne, and cartons of jambalaya. Lewis was only the second African American to represent Georgia in Congress in the 20th century after Young. At the swearing-in at the U.S. Capitol, he stood next to the newly elected Congressman Joseph Kennedy of Massachusetts, the son of his idol RFK. Mike Espy, a 32-year-old attorney, joined Lewis as the first black congressman from Mississippi since Reconstruction. "This is a long way from the red clay hills of Alabama," Lewis marveled. "I've traveled a lot of miles from Troy, Alabama, and from the Edmund Pettus Bridge." The arrival of Lewis and Espy doubled the number of black Southern congressmen from 2 to 4, which showed how woefully underrepresented African Americans remained in Congress. They constituted 17% of eligible voters in Dixie, but held only 3% of House seats. Jesse Jackson ran for president in 1984 and 1988 on a platform of greater minority representation. "We're locked out of the Congress, the Senate, and the governor's mansion," Jackson said in his keynote speech at the Democratic Convention in San Francisco in 1984. "If you want a change in this nation, you enforce that Voting Rights Act. We can save the cotton, but we've got to fight the boll weevils." This demand for representation grew louder as the 1990 census and the crucial decennial redistricting cycle approached. According to the historian Morgan Kuser, there were more Southern black state legislators in 1870, nearly 300, than in 1990, roughly 200. After spending 8 years battling the Reagan administration, minority voters found an unlikely ally in the incoming Bush administration. During the 1988 presidential campaign, a group called Americans for Bush ran an infamous television ad featuring Willie Horton, a black convicted murderer who during a weekend furlough in Massachusetts twice raped a white woman. The ad attacked Bush's opponent, Michael Dukakis, governor of Massachusetts at the time, for opposing the death penalty and allowing first-degree murderers to have weekend passes from prison. The racist overtones of the ad were hard to miss. Though the ad was not officially broadcast by the Bush campaign, it was widely believed to be the brainchild of the Bush campaign manager, Lee Atwater, a blues-playing bad boy from South Carolina. After Bush's election, Atwater became the chairman of the RNC. "Do something about redistricting," were his first words to the RNC counsel, Ben Ginsberg, a red-headed Jewish Republican from Pennsylvania. Despite the racial appeals of the 1988 campaign, Atwater wanted Ginsberg to form an improbable partnership with black Democrats in the South to overthrow the white Democrats who had controlled the region since the end of Reconstruction. The creation of new majority black districts, Atwater believed, would siphon black voters away from adjoining white Democratic districts, making those districts whiter and more conservative, giving Republicans their best chance at breaking the South's one-party stranglehold. The fact is that minorities remain grossly underrepresented in Congress, state legislatures, and local boards and commissions, Ginsberg told the Congressional Black Caucus Foundation in September 1990. "The culprit is the gerrymander. It has been done to Republicans and to racial minority groups." In 1990, there were 66 Democrats from the South in the House of Representatives, compared with 40 Republicans. Despite the region's increasing conservatism at the presidential level, white Southern Democrats retained a decisive majority in the House, in part by strategically dispersing black voters, who voted heavily Democratic, across white Democratic districts so that each district had just enough black voters to help elect white Democratic candidates. Creating new majority black districts, Ginsberg believed, would concentrate black voters in a few predominantly urban and rural districts, allowing Republicans to pick up a large number of seats in rural and suburban areas where the party performed strongly but was underrepresented. Under his strategy, minorities won new seats and Republicans did too. Ginsberg viewed the 1982 amendments to the VRA and the Thornburg v. Jingles decision, which prevented the continued dilution of minority votes, as a powerful new tool. As passed by Congress and interpreted by the courts, the Voting Rights Act now requires the drawing of majority-minority districts wherever possible, he said. Of course, the notion of Republicans aiding racial minorities cuts against political stereotypes, but it is a natural alliance born of the gerrymander. Ginsberg worried that he would get the living hell beat out of me before the Black Caucus. Instead, he spoke to polite applause. On the 25th anniversary of the VRA, John Lewis, now in Congress, endorsed the unholy alliance between black Democrats and the GOP. One GOP tactic, working with black Democrats to create majority black congressional districts during the 1992 reapportionment is viewed with concern by many Democrats, black and white, Lewis wrote in the Washington Post. A particular worry is that such overtures to black Democrats will threaten Democratic biracial coalitions. No one, though, should fear the prospect of minority-led biracial and multiracial coalitions. The prospect is a natural development of American politics and society, which have come a long way since Bloody Sunday. We should embrace the consequences of the Voting Rights Act. The RNC set up a tax-exempt foundation called Fairness for the 90s, funded by some of the biggest donors in the conservative movement, to deliver technical expertise and, in Ginsburg's words, truly space-age computer software to aid black and Hispanic civil rights organizations in the drawing of new districts. The GOP pundit Peter Brown called it the ultimate political one-night stand. Democrats controlled the state legislatures, which drew new maps for themselves and Congress in every southern state. Thus, Ginsburg needed either black Democrats to persuade their white colleagues to adopt new majority-minority districts, or failing that, for the courts or the Department of Justice to step in. The Bush Civil Rights Division was prepared to do just that. George H.W. Bush had initially nominated William Lucas, a black Republican with no civil rights experience, to be his Assistant Attorney General for Civil Rights. After the Senate Judiciary Committee rejected Lucas's nomination, Bush nominated John Dunn, a moderate Republican state senator from New York, who was close friends with Attorney General Dick Thornburgh, to run the Civil Rights Division. He was easily confirmed. Dunn adopted a very different approach to civil rights enforcement from his predecessor, Brad Reynolds. I came to the department with the view that I should attempt to enforce the law in the spirit of those who made the law, Dunn said. Dunn traveled to Selma early in his tenure to show his support for the VRA and made a point of meeting regularly with the career lawyers in the Civil Rights Division who had been alienated under Reagan. Dunn supported the creation of new majority-minority districts. I thought it was the correct strategy and in keeping with the spirit of the Voting Rights Act, he said. So did attorneys in the Civil Rights Division. What happened in 1991 and 1992, and I was one of the people responsible for this, was we went out and gave speeches to the National Conference of State Legislatures, the National Urban League, the NAACP, the Southern Legislative Conference, and said, if you can draw a majority black district even if it's bizarre in shape, you're going to have to justify your failure not to draw that district, explained Jerry Hebert, who was deputy chief of the voting section. We were not concerned about the political ramifications of the districts. If it helped Republicans, so be it. Our job was to help blacks and Latinos get elected. Few in the department realized just how controversial this position would be. North Carolina became the epicenter of the 1990s redistricting fight. Following the Jingles decision, the number of black elected officials in the state had increased dramatically from 245 in 1980 to 453 in 1990. In 1991, Dan Blue, Jr., a lawyer and mathematician from Raleigh, had been elected the Speaker of the North Carolina House of Representatives, becoming the first black leader of any Southern legislative chamber since Reconstruction. He appointed Toby Fitch from Wilson as one of the co-chairs of the House Redistricting Committee. As a result, black politicians enjoyed unprecedented influence during the redistricting process in North Carolina. They resolved early on to balance demands for greater black representation. There had been no black members of Congress from North Carolina since 1901, with the need to preserve large Democratic majorities in the state legislature and Congress. The initial plan passed by the legislature created a new majority black congressional district in rural eastern North Carolina, which had the highest concentration of black voters and had been the center of black political power in the state after the Civil War. But Blue and Democratic leaders were careful not to concentrate too many black voters in one place. While African Americans constituted 51% of registered voters in the 1st Congressional District, they still made up more than 20% of registered voters in 6 of the state's 11 other districts, which protected the white Democrats who depended on black support. Republicans, however, wanted Democrats to draw 2 or even 3 new majority black districts. The GOP representative David Ballmer from Charlotte proposed a new seat stretching from Charlotte to Wilmington that would be 45% black and 7% Lumbee Indian, in which, Ballmer argued, blacks and Native Americans could join together to elect their preferred candidate. The plan faced stiff resistance inside the legislature. One of Ballmer's interns, who drafted the plan, titled a computer file, just dreaming a bit too much. Civil rights groups, including the ACLU and the North Carolina NAACP, which usually sided with Democrats on civil rights issues, backed the GOP's proposal for an additional majority black district. Basically, the NAACP position from the very onset was that we wanted to see a maximization of the black voting strength in North Carolina, said Mary Peeler, executive director of the North Carolina NAACP. Before the legislature had even passed its congressional plan, 4 Republican members of Congress from North Carolina wrote a letter to Dunn urging the Justice Department to intervene in the redistricting process against Democrats by supporting the creation of multiple majority black congressional seats. Democratic leaders, including Blue and Fitch, traveled to Washington to plead their case before the DOJ. If blacks go too far, they will find themselves confined to political reservations with less political influence than they have today, Fitch argued. An intense debate about what to do occurred within the DOJ. Veteran lawyers inside the department, led by Jim Turner, urged Dunn to approve the legislature's plan under Section 5. One majority black district was enough, Turner argued. Dunn's general counsel, David Simon, who had close ties to Ginsburg, urged him to reject it, because Republicans and the civil rights groups had made a persuasive case that an additional majority-minority district could be drawn. Dunn sided with the GOP and civil rights groups. The proposed configuration of the district boundary lines, he wrote to the legislature in December 1991, appears to minimize minority voting strength. North Carolina Democrats were furious. What the Republicans are trying to do, Blue said, is corrupt the Voting Rights Act to the extent they can go beyond what its goal and mission is and use it for their political advantage. Blue and other Democrats believed that Balmer's proposed district would elect a white Republican instead of a black Democrat because blacks and Native Americans in eastern North Carolina had little in common. In the basement of the North Carolina Legislative Building, Jerry Cohen, special counsel to the legislature, drafted up a new map for the state's 12th congressional district. In the 1980s, Cohen had drawn the state's redistricting maps with colored pencils and magic markers. Now he had a state-of-the-art computer that could print color maps and process complex demographic data. The state had purchased 50 megabytes of storage for $500,000. It was the next generation of magic markers, he said. Cohen drew a new majority black district stretching 150 miles from Durham to Charlotte along the I-85 freeway and what had previously been the North Carolina Railroad corridor, where blacks had settled after the Civil War to work in the mills. It surgically picked up concentrations of black voters along the way in cities like Greensboro and Winston-Salem. It had a highly unusual shape, resembling a string of pearls or a serpentine monstrosity, depending on one's perspective. The district was so narrow at points that southbound drivers on I-85 were in one district and northbound drivers in another. I love the district because I can drive down I-85 with both car doors open and hit every person in the district, joked Representative Mickey Michaud, a Democrat from Durham. Despite its odd shape, the district accomplished 2 competing objectives for North Carolina Democrats, creating a new majority black congressional seat while protecting white Democratic incumbents. Democrats once again submitted the maps for DOJ approval. This time, Dunn acquiesced. The North Carolina people really wanted to stick it to us, he said. It was ridiculous, but I figured we just had enough of this. If they wanted to play that game, let them do it. His decision reverberated for years. For critics of the VRA, North Carolina's 12th district symbolized all that was wrong with the law and how it was enforced, a cynical form of affirmative action in the electoral sphere. In the Washington Post, Abigail Thernstrom called it a Republican civil rights conspiracy. The politics of the voting section of the Civil Rights Division are now indistinguishable from those of the NAACP, she wrote dismissively. In 1990, Harvey Gantt, the first black student at Clemson in 1963 and the first black mayor of Charlotte from 1983 to 1987, ran for the U.S. Senate against Jesse Helms. Gantt, a soft-spoken architect, led Helms days before the election until the Helms campaign ran an ad titled White Hands. It featured a pair of white hands crumpling a job rejection letter. You needed that job, and you were the best qualified, but they had to give it to a minority because of a racial quota, said the ominous narration. Is that really fair? Harvey Gantt says it is. Gantt supports Ted Kennedy's racial quota law that makes the color of your skin more important than your qualifications. You'll vote on this issue next Tuesday. For racial quotas, Harvey Gantt. Against racial quotas, Jesse Helms. Helms won the election by 6 points, his racial appeal proving the difference. After the creation of the 12th Congressional District, Gantt's campaign manager Mel Watt called his old boss. "I'm ready to manage your campaign," Watt said. "I'm not running," Gantt responded. "Why don't you run?" So Watt threw his hat in the ring. He had the perfect political pedigree as a partner in Julius Chambers' law firm and Gantt's longtime campaign manager. But his upbringing made him the most improbable of congressional candidates. Watt had grown up literally in Dixie, a rural neighborhood outside Charlotte near the airport. His house had no electricity, plumbing, or running water. You could see the ground through the wooden floor and the stars through the tin roof. Watt's mother, who dropped out of school in the 6th grade, had 3 boys by 18 and was divorced at 22 when Watt was 5. She raised the boys on her own, cleaning homes to get by. Watt, who was born in 1945, attended segregated schools for K through 12, passing 3 white schools on his 15-mile bus ride to York Road High School, the closest black school. He was one of only 17 black students in his incoming freshman class of 2000 at the University of North Carolina. He was assigned 3 white roommates. Before the end of the day, all of them had moved out. "Get the hell out of that room with that nigger," he overheard the father of one of his roommates saying on the phone. Watt's life changed the day before he left for college when he met Chambers, whom he called the godfather of civil rights in North Carolina. Chambers shared an office building with Watt's dentist on East Trade Street in Charlotte. They stayed in touch while Watt attended college. Chambers offered Watt a job after he finished Yale Law School, but he turned it down. When he called back Chambers and said he changed his mind, Chambers said he'd already filled a position. Watt went to New York and worked for the LDF, which Chambers was to run 2 decades later. On the day Watt moved back to Charlotte, Chambers' office was firebombed in the middle of the night. Watt took a job with the firm and never again left home. He specialized in business law and economic development, helping redefine what civil rights was, he said. Chambers became his mentor. They shared a coolness born of their life struggles. "Mel is not flamboyant," said his law partner, Leslie Winter, who argued the Jingles case. "But he's as steady as you go." He was laid back and good-looking with a distinctive black mustache. Watt's conciliatory personality made him an ideal candidate for the fractious 12th Congressional District, which inspired controversy even before it existed. There were upsides to it and downsides to it from a political perspective, he said. From the law firm's perspective, we were interested in maximizing minority representation. It was consistent with what we were trying to do. Watt edged out Durham's Mickey Michaud, a longtime civil rights activist, in the Democratic primary, and defeated Barbara Gore Washington, a black Republican, with 70% of the vote in the general election. Majority black districts in the South, like the 12th, were often oddly shaped and were created in part to help Republicans, but without them, people like Mel Watt would never have made it to Washington. Days before the 1992 election, John Lewis took a 6-day bus tour through the South to campaign for the Clinton-Gore ticket and the unprecedented number of black candidates like Watt running for Congress. "If someone had told me in 1961 that we would have black elected officials across the South, that I would be in Congress, I would have told them they were crazy," he said. "The future of black America is at stake in this election." 10 years after the 1982 extension of the VRA, the Los Angeles Times proclaimed 1992 the year of the minority. On January 5, 1993, the new class of the Congressional Black Caucus, CBC, took their oaths in the courtyard of the Grand National Building Museum in Washington. There were so many new black members they could barely fit on the podium. It was the largest class of African Americans ever to assemble in Congress. 17 black members of Congress, 13 of them from the South, were elected in 1992. All were from newly created majority black districts. The number of Hispanic members of Congress also jumped from 12 to 18. It was the most diverse Congress in U.S. history. "It was transformative," Watt said. "It was a dramatic demonstration of the power of the Voting Rights Act." DOJ objections to statewide redistricting plans in Alabama, Georgia, Louisiana, Mississippi, North Carolina, Texas, and Virginia led to the creation of new majority black districts, which made the dramatic increase in minority representation possible. 5 Southern states elected black members of Congress for the first time in the 20th century. Earl Hilliard of Alabama, Corrine Brown, Alcee Hastings, and Carrie Meek of Florida, Eva Clayton and Mel Watt of North Carolina, Jim Clyburn of South Carolina, and Bobby Scott of Virginia. Judge Leon Higginbotham, the Chief Judge of the U.S. Court of Appeals for the Third Circuit, administered the oath to the black freshmen. He excitedly called the new class members of the most distinguished delegation to ever appear in Washington, as important and more significant than when Thomas Jefferson went to Philadelphia on July 4, 1776. The 40 members of the CBC rose and pledged to champion the rights of those who suffer from discrimination. George H. White of North Carolina had been the last black member of Congress to serve after Reconstruction before he was chased out by a vicious white supremacy campaign in 1901. This, Mr. Chairman, is perhaps the Negro's temporary farewell to the American Congress. But let me say, phoenix-like, he will rise up some day and come again, White had said in his emotional farewell speech on the House floor. The absence was much longer than temporary. It took 90 years for a black Democrat from North Carolina to return to Congress. We are, in fact, that phoenix that he spoke of rising from those ashes, the CBC's chair, Kwesi Mfume, said. The celebration ended abruptly. 2 months after Watt's swearing in, 5 white residents of Durham, led by the Duke University law professor Robinson Everett, filed a lawsuit challenging the 12th District as an unconstitutional racial gerrymander. It was the first of many challenges to come. A few days after the presidential inauguration in 1993, Lani Guinier hosted a dinner party at a friend's house in northwest Washington, D.C., for her Yale Law School classmates Bill and Hillary Clinton. The Clintons had been guests at her wedding, and during her days as a civil rights lawyer, she'd even sued Bill Clinton once when he was governor of Arkansas. The guests at the small gathering included Watt, who discussed voting rights with the new president. The dinner symbolized how a white Southern president who grew up in Jim Crow, Arkansas, had embraced the new wave of black political power. 3 months later, Clinton personally nominated Guinier to be his Assistant Attorney General for Civil Rights with an announcement in the courtyard of the Justice Department. I wanted to set an example in the practice of law and in the protection of civil rights that will make all Americans proud, the president said. Attorney General Janet Reno introduced Guinier to a loud ovation as a remarkable woman who was no stranger to the Justice Department. She had been a special assistant to Drew Days in the Civil Rights Division during the Carter administration before spending the Reagan years at the LDF and the Bush years at the University of Pennsylvania. The tall and striking Guinier wore a checked black blazer with a red pocket square, her frizzy black hair pulled back in a ponytail. If confirmed by the Senate, I eagerly anticipate leading a new and highly regarded Civil Rights Division that works to enforce, not repeal, the civil rights laws as passed by Congress, she said to cheers. She grinned and gave a thumbs up to the crowd. After 12 years of Reagan and Bush, lawyers in the Civil Rights Division were excited to welcome back one of their own. No nominee for the post has ever been better prepared than Lani Guinier, the New Yorker wrote. She'd grown up in the working-class neighborhood of St. Albans, Queens, the daughter of a Jewish mother and a Guyanese father, who became the first chair of Afro-American Studies at Harvard. She'd wanted to be a civil rights lawyer since she was 12, when she watched the LDF lawyer Constance Baker Motley escort James Meredith into the University of Mississippi. Guinier attended Barnard and then Yale Law, where she lived on the 3rd floor of the house where Motley had grown up. As a civil rights lawyer during the 1980s, Guinier had been a fierce opponent of the Reagan Justice Department, defending black voters from bogus voter fraud charges in the Alabama Black Belt and attacking discriminatory electoral systems in states like North Carolina and Louisiana. When asked at a press conference following her nomination who was responsible for damaging the reputation of the Civil Rights Division, Guinier responded, William Bradford Reynolds. She told the story of the Major V. Treen case when Louisiana, with Reynolds' blessing, deliberately avoided drawing the state's first majority black congressional district. Those days were now over. Miss Guinier, the New York Times wrote, is poised to lead a counter-revolution in civil rights. But Guinier and her supporters woefully underestimated just how potent the counter-revolution to the civil rights laws of the 1960s had become. A few weeks before Clinton's announcement, Abigail Thernstrom told her friend Clint Ballot over dinner at the Jefferson Hotel in Washington that the president would nominate the very radical Guinier. Clint, you're going to love her, Thernstrom said. She did not mean love affectionately. Ballot, a 35-year-old Reagan vet, had worked in the Justice Department under Reynolds and in the Equal Employment Opportunity Commission under Clarence Thomas, the godfather to his son. He was now president of the Institute for Justice, one of the many new conservative legal groups to emerge from the Reagan years. Thernstrom had long been a vocal critic of Guinier's civil rights record. When they appeared at a Harvard conference on new ways of allocating political power in the early 1990s, Thernstrom attacked Guinier with such vehemence during her introductory remarks that the audience nearly booed her off the stage. Ballot had never heard of Guinier until that dinner, but 2 days after her nomination, he published a scathing op-ed in the Wall Street Journal calling Guinier one of Clinton's quota queens. Ms. Guinier sets the standard for innovative radicalism, he wrote. Guinier argues that proportional legislative representation for minority groups, which the Voting Rights Act of 1965 presently is constructed to guarantee, is not enough. Instead, she demands equal legislative outcomes, requiring abandonment not only of the one-person, one-vote principle, but majority rule itself. Ms. Guinier would graft onto the existing system a complex racial spoils system that would further polarize an already divided nation. Thernstrom amplified Ballott's critique. Guinier isn't your garden-variety civil rights advocate, she wrote in the New Republic. Her proposals make existing affirmative action programs look tame. She called Guinier the voice of black separatism. Clinton's civil rights nominee had become Angela Davis in a pantsuit. The controversy centered on a series of defense law review articles Guinier had written as she entered academia. Keeping the Faith, Black Voters in the Post-Reagan Era, Harvard Civil Rights, Civil Liberties Law Review, 1989. The Triumph of Tokenism, The Voting Rights Act and the Theory of Black Electoral Success, Michigan Law Review, 1991. And No Two Seats, The Elusive Quest for Political Equality, Virginia Law Review, 1991. Guinier's articles focused on the third generation of voting rights problems facing minority voters. In the first generation of voting rights cases post-1965, the VRA outlawed the literacy tests and poll taxes that prevented blacks from registering to vote. The second generation of cases, in the 1970s and 1980s, dismantled the gerrymandered districts and at-large electoral systems that prevented minority voters, once they registered in large numbers, from electing their preferred candidates. In the third generation of cases, Guinier focused on how minority elected officials could secure not just representation, but a fair share of political power. My point is simple, she wrote. 51% of the people should not always get 100% of the power. She called the American political system the tyranny of the majority. Guinier looked south for unorthodox solutions, drawing on her voting rights work for the LDF. In Alabama, hundreds of jurisdictions had been ordered by the federal courts to adopt single-member districts in the 1980s to boost black representation. But in some counties, black voters were too dispersed to be represented in a single district. One of those places was Chilton County, the peach capital of the world, south of Birmingham, which had long been governed by an all-white county commission and school board. In 1988, the county adopted a system called cumulative voting, by which each voter got 7 votes to cast for the 7-member commission. A voter could use all 7 votes for one candidate or spread them out among multiple candidates. Similar systems were used in corporate board elections to accommodate minority factions. In the first election held under cumulative voting, Bobby Agee, a funeral home director, became the first African-American elected to the county commission. 3 Republicans were also elected to the previously all-Democratic commission. The system has been fair because for the first time you have represented all aspects of the community, Agee said. 2 years later, Agee's peers elected him commission chairman. The one-voter, 7-vote system was confusing at first, but it boosted minority representation without the squabbling and polarization that accompanied the drawing of new majority-minority districts in states like North Carolina, Guinier believed. She urged other places to adopt the reform, which had become known as the Chilton County experience. In Mobile, Guinier saw how black and white office holders could share governing power. Following the landmark Mobile v. Bolden case, 4 whites and 3 blacks sat on the newly integrated city council. To ensure that black interests were not ignored, the Justice Department required that all legislation pass with 5 votes, meaning that the white majority had to secure at least 1 black vote. The supermajority requirement, said the council's Vice President Clinton Johnson, was the best thing to have happened to Mobile, It has created an environment for greater harmony and cooperation between the races. Guinier made clear that the enforcement of this representational right does not require legislative set-asides, color-coded ballots, electoral quotas, or one black, two votes remedies. She had long opposed quotas, which had denied her father a scholarship to Harvard in 1929. Nor would the reform she proposed overtake conventional enforcement of the VRA. I am not articulating a grand moral theory of politics, she wrote, nor do I argue that these proposals are statutorily or constitutionally required. Guinier did not anticipate the vehemence of the attack against her. Within the academic world, my articles had not been controversial, she wrote. They had been widely circulated and warmly received even by dissenting conservative scholars who had substantive, legitimate disagreements with my ideas, but nevertheless respected my efforts. But Washington was not the ivory tower. Few journalists or senators bothered to read Guinier's intricately argued articles or investigate the sources of her ideas. Instead, they relied on Bullock's and Thernstrom's critiques. Meanwhile, the Clinton administration did little to defend her, failing to assign a full-time staffer to her nomination for nearly a month, as she was attacked every day in the press. From a suite of offices across the street from the Justice Department, Bullock ran an around-the-clock war room against Guinier, sending her articles and talking points against her nomination to congressional aides, journalists, editorial writers, and key opinion leaders in Washington. In May and June 1993, the phrase quota queen appeared in 330 different articles. The Q word stuck, Guinier wrote. Democratic senators began to complain to the Clinton administration. Bob Dole, who had personally thanked Guinier for her work on the 1982 VRA reauthorization, claimed on the Senate floor that he'd never met her. If nothing else, Miss Guinier has been consistent in her writings, he said, consistently hostile to the principle of one person, one vote, consistently hostile to majority rule, and a consistent supporter not only of quotas, but of vote-rigging schemes that make quotas look mild. Clinton, who had not read the articles before nominating Guinier, read them on a helicopter trip to Maryland in early June and invited Guinier to the White House to make her case. 24 Senate Democrats had by then asked the president to withdraw her nomination. Guinier met with the president for an hour in the Oval Office, where she described her arguments in minute detail. Shortly after she returned to the Justice Department, the president called. I have decided to withdraw the nomination, he told her. You made the best case I can imagine, but you didn't change my mind. 10 minutes later, Guinier watched on TV as Clinton announced her withdrawal in a hastily planned press conference. At the time of the nomination, I had not read her writings, the president said. In retrospect, I wish I had. Today, as a matter of fairness to her, I read some of them again in good detail. They clearly lend themselves to interpretations that do not represent the views that I expressed on civil rights during my campaign. 120 demonstrators marched outside the White House to protest Clinton's decision, carrying signs that read, Quayle can't spell, Clinton doesn't read, and Reagan backed Bork. Bush backed Thomas, Clinton backed down. Unlike Reynolds, Guinier never got a chance to defend herself before the Senate. In early 1993, Ruth Shaw, a Durham bookkeeper, attended the funeral of a friend's mother. When she reached the casket, the son of the deceased, Robinson Everett, asked her an unusual question given the setting. Would she join a lawsuit he was filing challenging North Carolina's 12th congressional district? Standing by the casket, Shaw said yes. She became the lead plaintiff in Shaw v. Barr, which alleged that Mel Watt's district violated the rights of white voters to participate in a colorblind electoral process. A three-judge district court in North Carolina initially dismissed the case. The plaintiffs here have not alleged, nor could they prove under the circumstances, that the redistricting plan was adopted with the purpose and effect of discriminating against white voters such as plaintiffs on account of their race, wrote Judge James Dixon Phillips, who had written the Jingles decision. Everett and two other plaintiffs didn't even live in the challenged district. Everett, a longtime moderate Democrat whose mother had been the first woman to argue a case before the North Carolina Supreme Court and whose father had been Durham's first city attorney, appealed to the U.S. Supreme Court. It heard the case, now titled Shaw v. Reno, on April 20th, 1993, 9 days before Clinton nominated Guinier. In court, Everett showed a map of the district that he called political pornography. We take the colorblind Constitution to be more than an idle aspiration, particularly under present conditions, he argued. the federal government defended North Carolina. We do not believe that the principle of the colorblind Constitution requires a state to be blind to the fact that its citizens regrettably may vote along racial lines, replied Deputy Solicitor General Edwin Needler. In a contentious 5-4 decision on June 28, 1993, 3 weeks after Clinton withdrew Grenier's nomination, the court sided with Everett. We believe that reapportionment is one area in which appearances do matter, Justice O'Connor wrote for the court's conservative majority. A reapportionment plan that includes in one district individuals who belong to the same race but who are otherwise widely separated by geographical and political boundaries and who may have little in common with one another but the color of their skin bears an uncomfortable resemblance to political apartheid. The opinion read as if Thernstrom had written it. Indeed, O'Connor cited Whose Votes Count on page 8 of her opinion. In the 1977 case, United Jewish Organizations of Williamsburg, Incorporated v. Carey, which inspired Thernstrom to write about voting rights, the court had ruled 7-1 that race-conscious plans can be legitimate if they are intended to make up for past discrimination and are adopted to comply with the Voting Rights Act. O'Connor's opinion essentially overruled UJO, a covered jurisdiction's interest in creating majority-minority districts in order to comply with Section 5 of the Voting Rights Act does not give it carte blanche to engage in racial gerrymandering, she wrote. Such districts must be narrowly tailored to further a compelling governmental interest other than race. 4 irate dissents were filed by Justices White, Blackmun, Stevens, and Souter. It is particularly ironic that the case in which today's majority chooses to abandon settled law, wrote Blackmun, is a challenge by white voters to the plan under which North Carolina has sent black representatives to Congress for the first time since Reconstruction. Black Democrats in Congress were outraged. This is the greatest threat to the Voting Rights Act since it was written in August 6, 1965, said John Lewis. If it wasn't for the Voting Rights Act, it would still be primarily white men in blue suits in Congress. Mel Watt, who had the most to lose in the case, took particular umbrage at O'Connor's description of his district as racial apartheid, a phrase the court had never used before. The opinion suggests that a congressional district which is 53% black, as my congressional district is, and 47% white, is racial apartheid, while a congressional district which is 80% white and 20% black is somehow an integrated congressional district, he said at a news conference on Capitol Hill. It talks about black people not being able to represent the interests of white constituents while assuming that white representatives can adequately represent the interests of black people. The Shaw case turned history on its head, with the court's majority invoking the Equal Protection Clause of the 14th Amendment, adopted in 1868 to protect black citizens, to dismantle districts that benefited black candidates. The Supreme Court discovered an entirely new constitutional right for white voters, Grenier told the annual NAACP convention in Indianapolis. Never before had the Supreme Court objected to a congressional district simply because of its shape. At a congressional hearing, the Massachusetts Congressman Barney Frank showed a map of a district resembling a one-armed crab. "It is a rather bizarre district," he said. "It is mine. I didn't ask for it. It is what the legislature gave to me. And I guess I want to know, is this okay because I am white?" With the exception of the Mobile v. Bolden case in 1982, the Supreme Court had always taken an expansive view of the VRA since its enactment. That changed in 1993 with Shaw v. Reno. The replacement in 1991 of Thurgood Marshall with Clarence Thomas, 2 men with diametrically opposed views on racial equality, with nothing in common other than the color of their skin, decisively shifted the Rehnquist court to the right on civil rights issues. The Supreme Court, and lower courts as well, now filled with Reagan and Bush appointees, exhibited a new kind of hostility to the VRA. In the years following Shaw, 8 of 17 majority black congressional districts in the South would be redrawn. The legal and political backlash against the VRA and the law's supporters continued to grow. On January 4, 1995, Newt Gingrich ascended from the back of the House of Representatives, where he'd sat for 16 years as a lonely member of the minority party, to take his new position on the rostrum as Speaker of the House. "It's a whole new world," a Republican congressman shouted from the floor. Republicans picked up 54 seats in the House in the 1994 election, retaking the chamber for the first time in 40 years. The Republican Party and the country's political landscape, most notably in the South, had transformed suddenly and dramatically. The year of the minority gave way to the year of the angry white male. Few states illustrated this shift better than Gingrich's home state of Georgia. In 1990, Gingrich was the only Republican and Lewis the only minority in Georgia's 9-member House delegation. The rest were white male Democrats. In 1992, the Georgia legislature, under pressure from the DOJ, created 2 new majority black districts. Black voters were moved out of surrounding white Democratic districts to create the new seats. As a result, 2 black Democrats, Sanford Bishop and Cynthia McKinney, joined Lewis in Congress, and 3 white Republicans from adjoining districts joined Gingrich's side. Democrats still controlled the House delegation 7-4. 2 years later, Georgia elected 8 Republicans and 3 Democrats to the House, a stunning change from 1990 and 1992. All 3 Democrats were African American. In the span of 4 years, every white Democratic congressman in Georgia had lost or retired. Racial gerrymandering, wrote the Newsweek columnist George Will, is one reason that Newt Gingrich is Speaker. The same phenomenon occurred throughout the South, including in North Carolina. In 1992, Democrats controlled the North Carolina delegation 8-4. 2 years later, those numbers had flipped. Even the craftiest of gerrymanders failed to protect white Democratic incumbents. Before the 1990 redistricting cycle, 44% of white Democratic districts in the South were at least 20% black. After the creation of 13 new black Democratic districts in 1992, only 25% of white Democrats had as many black constituents, making them far more vulnerable to a Republican challenge. In 1990, the North Carolina Democrat Tim Valentine's 2nd District was 37% black. In 1992, the black population of his district shrank to 20% after black voters were shifted to the majority black districts of Mel Watt and Eva Clayton. The 6-time incumbent was narrowly re-elected that year, but in 1994 he lost by 12 points to the Republican David Funderburk, Reagan's ambassador to Romania, whom Valentine described as to the right of Jesse Helms. In 1992, Democrats controlled 28 more House seats than Republicans in the South. After the Republican Revolution of 1994, Republicans held a majority of Southern House districts for the first time since Reconstruction. They constituted the largest bloc of House Republicans. The Speaker of the House, Majority Leader Dick Armey, and Majority Whip Tom DeLay all were hard-edged Southern conservatives. With the Southern Republicans, you get a more aggressive, assertive conservatism, said the GOP pollster Whit Ayers of Atlanta. This is a conservatism that has been built on confronting Democrats and liberals, not accommodating them. 20 members of the Congressional Black Caucus lost committee or subcommittee chairmanships after 1994. 36 of 38 black House members found themselves in the minority. Proponents of black voting rights have won the ballot, Guinier wrote shortly after Gingrich's swearing in, but may be losing the war. Republicans also won control of 17 state legislative bodies, including in Florida, South Carolina, and North Carolina for the first time in the 20th century. What has long been apparent is only now fully understood. Herding black voters into their own majority-minority districts is a boon to the GOP, Thernstrom wrote in the New York Times. Many commentators, like Thernstrom, overstated the impact of racial gerrymandering on the Democrats' collapse. Democrats lost 24 House seats in states without any majority-minority districts. Clinton's unpopularity, a series of corruption scandals in the White House, the failure of health care reform, and the passage of an assault weapons ban all contributed to the GOP's takeover. Racial redistricting alone does not explain Republican gains in 1994, but it played an important subsidiary role, concluded the American University political scientist David Lublin. The South had been voting Republican at the presidential level since Nixon's Southern strategy in 1968. But the 1994 congressional results definitely confirmed LBJ's prediction that he'd lost the South for a generation by signing the Civil Rights Act and the VRA. Maintenance of Negro voting rights is essential to the GOP, Nixon's Machiavellian strategist Kevin Phillips had written in the emerging Republican majority in 1969. Negroes are slowly but surely taking over the apparatus of the Democratic Party in a growing number of deep Southern Black Belt counties, and this cannot help but push whites into the alternative major party structure, that of the GOP. Phillips' prediction became a reality in 1994 when Democratic congressional candidates in the South received 91% of black votes but only 35% of white votes. Southern whites shifted to the GOP in larger numbers than any other demographic group. The 26 majority-minority districts in the South elected 24 minority members of Congress. The 99 majority white districts elected 99 white members. 20 years after Phillips' book, Ben Ginsberg had followed his blueprint at the RNC, advocating the drawing of new political maps that turned the Democratic Party into a predominantly black party in the South and thereby shifted the region to the GOP. He jokingly called his master plan Project Ratfuck. 8. The Counter-Revolution, 2. On November 7, 2000, Willie Steen, a Navy vet who served in the Persian Gulf during Desert Storm, went to cast his ballot for president at the St. Francis Episcopal Church in Tampa, Florida. He brought his 10-year-old son, Willie Jr., to the polls for the first time. They waited a half hour to reach a poll worker. When Steen gave the poll worker his name, she searched a list of registered voters in the precinct and told him, "You can't vote. You're a convicted felon." "You must be mistaken," a shocked Steen replied. "I've never been arrested in my life." He worked at a hospital, the Tampa Orthopedic Center, that wouldn't employ anyone with a felony conviction. The poll worker gave him a number to call at the Board of Elections, but no one picked up. The 75 people behind him in the line grew antsy. Few would look him in the eye. He left in embarrassment, struggling to explain to his son what had just happened. After fighting for his country abroad, he wasn't able to exercise his most fundamental right at home. "I felt I was shafted," Steen said. "I think there were a lot of things that weren't done properly. My name was dragged through the mud." He later found out he'd been confused with a convict named Willie O'Steen, who had committed a felony between 1991 and 1993 when Steen was in the Persian Gulf. Little did Steen know that the same thing was happening to voters across the state of Florida, particularly to voters like him who were African American. Before the election, Florida sent its 67 county election supervisors a list of 58,000 alleged felons to purge from the voting rolls. Florida was one of 8 states that prevented ex-felons from voting. Blacks made up only 15% of registered voters in the state, but 44% of those on the purge list, which turned out to be littered with errors. Elsewhere in Tampa, Wallace McDonald was one of 3,258 alleged felons who received a letter from the Hillsborough County Supervisor of Elections, Pam Iorio, telling him he was ineligible to vote. In 1959, when he was 23, McDonald fell asleep on a bench while waiting for a bus and was arrested for vagrancy. He was ordered to work on a municipal garbage truck for his sentence. He was fined $30 when he walked off the job in protest. But he'd never been accused of a felony until he received the state's notification 41 years later. "I could not believe it after voting for all these years since the 50s without a problem," McDonald said. He hired a lawyer who confirmed he was not a felon, but Iorio refused to reinstate him to the voter rolls. In St. Petersburg, Floredia Walker showed up at her usual polling place at Pleasant Grove Church. She too appeared on the felon list and was told she couldn't vote. Walker worked for the Department of Corrections, where she was subject to background checks and, like Steen, couldn't hold her job with a criminal record. 15 years earlier, a thief had stolen her purse and used her driver's license. Walker had immediately contacted the Department of Corrections and explained what had happened. "I thought it was all taken care of," she said. She was never told she was ineligible to vote. She'd even received a new voter registration card a month before the election. "I was devastated," she said. "I've voted in every election. I've even worked the polls. There was never a problem in the past." Steen, McDonald, and Walker had little in common except for 2 things. They were African American and were planning to vote for Al Gore. Hanging chads, butterfly ballots, the antics of the Florida Secretary of State, Katherine Harris, and thousands of Jews accidentally voting for Pat Buchanan in Palm Beach were among the stories that captured the headlines during the chaotic 36-day Florida recount between Gore and George W. Bush. The widespread and wrongful purging of registered voters, which disproportionately targeted African American voters, was the most consequential and least discussed aspect of the Florida election. The parties and the candidates did not want to focus on the racial impact of decisions that were made in Florida, said the civil rights lawyer Judith Brown Dianis. It was one of those moments when race was being swept under the rug. Edward Hales, the staff director of the U.S. Commission on Civil Rights, arrived in Florida 2 days after the election to begin investigating reported civil rights violations. crucial details about the state's voter purge emerged only after voters had been turned away from the polls. In 1868, to prevent newly emancipated African Americans from exercising the franchise, Florida passed a law banning anyone with a criminal conviction from voting unless the governor pardoned him or her. During slavery, blacks were far more likely to be arrested than whites for crimes such as looking at a white woman. Following the Civil War, every southern state had a felon disenfranchisement law on the books. The ban had spread to 3/4 of the country by 1920. 17 states restored voting rights for ex-felons in the 1960s and 1970s, but Florida's law remained in effect. The modern impetus for the voter purge occurred in 1997 in Miami, when the former mayor, Javier Suarez, Mayor Loco, faced off against the incumbent Joe Carollo, Crazy Joe. Suarez narrowly defeated Carollo, but evidence soon emerged that hundreds of dead voters and felons illegally voted absentee on his behalf. A court overturned the results and reinstated Carollo as mayor. Weeks later, the Florida legislature passed a law requiring an annual purge of the voter rolls by a private entity. A $4 million contract went to the Boca Raton-based Database Technologies, DBT, a company recommended by a conservative advocacy group called the Voting Integrity Project, which since the early 1990s had advocated aggressive voter purges to prevent fraud. On the orders of state officials, new names were added to the purge list for the 2000 election if there was only a 70% match between a name on the voter rolls and a name on the state's felon database. That meant that voters could be tagged as felons even when middle initials, suffixes, nicknames, and even race and sex data didn't perfectly match. Hence the confusion of Steen with Osteen. DBT warned the state that it was compiling false positives. Bucky Mitchell, a senior attorney for the Division of Elections, told the company, "Obviously, we want to capture more names that possibly aren't matches and let the supervisors make a final determination rather than exclude certain matches altogether." Voters were deemed guilty until proven innocent. The election supervisors became responsible for Florida's intentionally lax record-keeping. Blatant warning signs were ignored by the state. In May 2000, after the first batch of names was released, the election supervisor in Madison County found herself on the purge list. Ian Sancho, the election supervisor for Tallahassee's Leon County, was the only election official to go through the list one by one. "We went for a 5-for-5 match," he said. "Those were criteria such as name, birth date, race, sex, social security number. When we applied that to this list of 697 that we got in 2000, I could verify only 33. Because of these errors, 20 counties disregarded the state's list, but it was still used by a majority of election supervisors, including in heavily populated swing areas like Tampa and St. Petersburg. The NAACP sued Florida after the election for violating the VRA. As a result of the settlement, DBT ran the names on its 2000 purge list using stricter criteria. The exercise turned up 12,000 voters who shouldn't have been labeled felons. That was 22 times the Bush's 537-vote margin of victory, but it was too late for their votes to count. On election night, Bush led Gore by 1,784 votes. Because of the closeness of the election, an automatic recount began 2 days later in every county. Hundreds of lawyers flocked to Florida. Ben Ginsberg, National Counsel for the Bush campaign, called it the Woodstock for constitutional lawyers. Ted Cruz, a 29-year-old domestic policy advisor on the Bush campaign and a former law clerk for Justice Rehnquist, constructed Bush's legal team. One of his first calls was to John Roberts, whom Cruz knew from the close-knit network of former Rehnquist clerks, nicknamed the Cabal. "We started to assemble a team of the best lawyers, and in particular the best Supreme Court lawyers in the country, and John's name naturally came near the top of the list," Cruz said. Roberts, now in private practice, caught the next flight to Tallahassee. Roberts edited legal briefs, including the campaign's 50-page submission to the Supreme Court, and prepared the former Reagan Assistant Attorney General Theodore Olson for oral arguments. He also provided counsel to Florida's Governor Jeb Bush. Roberts' name appeared on no briefs, but his influence was unmistakable. "He is one of the finest legal writers of his generation," Cruz said. "His editing pen was invaluable." The parties had very different objectives. The Bush campaign wanted as few disputed ballots counted as possible. The Gore campaign, which trailed by 327 votes after the automatic recount, wanted as many disputed ballots counted as possible. When the Florida Supreme Court ordered a statewide manual recount on December 8th, which favored Gore, the Bush campaign appealed to the U.S. Supreme Court. John Lewis was among those seated in the packed courtroom on December 11, 2000, for oral arguments. As he watched the news from Florida on television on election night, he thought of how he had almost died on the Edmund Pettus Bridge. "It's important to bear witness," he said. "This day is as important for me as March 7, 1965, when I attempted to march from Selma to Montgomery. We won that battle, and we come back 35 years later and see that people's votes aren't counted." The next day, the Supreme Court halted Florida's recount, thereby declaring Bush the winner of the election. No justice put his name on the unsigned 5-4 opinion. The court asserted that the recount violated the Equal Protection Clause of the 14th Amendment because there was no uniform statewide standard for counting disputed ballots in each county. In a draft of her dissent, Justice Ginsburg noted in a footnote that if there was any equal protection violation in Florida, it was because black voters encountered a disproportionate number of problems voting. Justice Scalia, her closest friend on the court, objected to Ginsburg's Al Sharpton footnote, and she took it out. When one read the Bush v. Gore opinion, it was as if the disenfranchisement of black voters had never occurred. 3 weeks after the court's decision, Gore, as President of the Senate, had the misfortune of presiding over the certification of electors for Bush during a joint session of Congress in the House of Representatives. The Congressional Black Caucus contested the result. "Mr. President, I object to the certificate from Florida," said Representative Al C. Hastings, a former judge from Broward County. "The gentleman from Florida, Mr. Hastings, will present his objection," Gore said. "Is the gentleman's objection in writing and signed by a member of the House of Representatives and by a senator?" "Mr. President," Hastings replied, "and I take great pride in calling you that, I must object because of the overwhelming evidence of official misconduct, deliberate fraud, and an attempt to repress—" "Objection!" Republican members yelled. Gore banged his gavel for order. "No debate is allowed in the joint session," he said. "To answer your question, Mr. President," Hastings said, "the objection is in writing, signed by a number of members of the House of Representatives, but not by a member of the Senate." No senator would join the CBC's challenge of the Florida electors, thus preventing the objection from being heard. "Are there other objections?" Gore asked. One by one, black Democrats from Florida and across the country took to the House floor to object. "Mr. Vice President, I rise to object to the fraudulent 25 Florida electoral votes," said the California Representative Maxine Waters. "Is the objection in writing and signed by a member of the House and a senator?" Gore again asked. "The objection is in writing, and I don't care that it is not signed by a member of the Senate," Waters said to loud Democratic applause. "Mr. Vice President, there are gross violations of the Voting Rights Act from Florida." Republicans shouted Waters down. One by one, Gore surreally ruled out of order the black members of Congress who were protesting his wrongful defeat. "We did all we could," Hastings said. "The chair thanks the gentleman from Florida," Gore said wryly. When Gore officially declared Bush the winner, 271 electoral votes to 266, 20 members of the CBC walked out in protest. "It's going to be very difficult, almost impossible for many of us to forget what happened," Lewis said. In January and February 2001, the Civil Rights Commission listened to 30 hours of testimony from more than 100 witnesses during 3 field hearings on the election in Florida. Those interviewed included Jeb Bush, Katherine Harris, Florida's Attorney General, and numerous county election supervisors. Despite the closeness of the election, it was widespread voter disenfranchisement, not the dead heat contest that was the extraordinary feature in the Florida election, the Commission's final report concluded. After carefully and fully examining all the evidence, the Commission found a strong basis for concluding that violations of Section 2 of the Voting Rights Act occurred in Florida. Black ballots were nearly 10 times as likely to have been rejected as white ballots, the Commission reported. African Americans cast more than half of the 180,000 spoiled ballots. When it came to the voter purge, the Commission found that top officials at the Division of Elections were responsible for encouraging an error-laden strategy that resulted in the removal of a disproportionate number of eligible African American voters from the rolls. No one could ever determine precisely how many legitimately registered voters were prevented from voting. But the commission staff director, Edward Hales, did the math the best he could. If 12,000 voters were wrongly purged from the rolls, and 44% of them were African American, and 90% of African Americans voted for Gore, that meant 4,752 black Gore voters, almost 9 times Bush's margin of victory, could have been barred from the polls. It wasn't a stretch to conclude that the purge cost Gore the election. We did think it was outcome determinative, Hales said. Abigail Thernstrom, who Bush had appointed to the Civil Rights Commission at the beginning of his presidency, filed a strenuous dissenting statement, joined by Commissioner Russell Redenbaugh, a Philadelphia businessman appointed by Bush's father. The obvious explanation for a high number of spoiled ballots among black voters is their lower literacy rate, they wrote. They acknowledge that without question some voters did encounter difficulties at the polls, but the evidence fails to support the claim of systematic disenfranchisement. The Civil Rights Panel had focused on the wrong set of voting problems in Florida, they asserted. The commission should have looked into allegations of voter fraud, the two commissioners wrote, not only with respect to ineligible felons, but allegations involving fraudulent absentee ballots in nursing homes, unregistered voters, and so forth. Across the country in a variety of jurisdictions, serious questions about voter fraud have been raised. Despite the dissenting statement, a majority of commissioners called on the Department of Justice to immediately prepare litigation against Florida under the VRA. By then, however, it was too late. The Bush administration followed Thernstrom's lead and prioritized prosecutions of voter fraud over investigations into voter disenfranchisement. 1,000 miles north of Florida, a similar election fiasco unfolded in St. Louis. On Election Day 2000, Mahina Nightsage, a 41-year-old community organizer, went to her polling place of 20 years at 10:30 a.m. But this time she found that her name was not on the registration rolls. Her local election judge did not have a phone to call the Board of Elections, and the line was busy for over an hour when Nightsage tried to call them herself. She finally reached her alderman, who told her to visit the Elections Board downtown and see what happened. When she arrived at 300 North Tucker Street at 12:30 p.m., Nightsage saw a scene that resembled an election in a third-world country. Hundreds of voters were lined up around the block and packed inside, standing on tables to get the Board of Elections' attention. Nightsage waited 2.5 hours before the board processed her paperwork, and she was able to return to her polling place to vote for Gore. Not everyone was as lucky. There were many people who had been waiting for hours, and they just left, Nightsage said. Only 3 workers from the Board of Elections were on hand to assist voters. The line of jilted voters in the heavily Democratic city was predominantly African American. The sight of hundreds of African Americans waiting for hours upon hours simply to exercise their constitutional right to vote sent shockwaves to the pit of my stomach, wrote Denise Lieberman, a lawyer for the Missouri ACLU, who was stationed at the Board of Elections. As I looked around the room that afternoon, I couldn't help but feel as though I had been transported back in time, back to a time of poll taxes and literacy tests, back to a time not all that long ago, really, when the color of your skin determined whether you had a right to vote. The problem started well before the 2000 election, when the St. Louis Board of Election Commissioners sent voter registration cards to all eligible voters. Those whose mail was returned as attempted, not known, not deliverable as addressed, or forwarding order expired, were labeled inactive and removed from the rolls. More than 50,000 voters in St. Louis were placed on inactive status between November 1996 and November 2000. None of them were notified about the change in their status. Thus, thousands of voters like Nightsage arrived at the polls on Election Day only to learn that they were no longer on the rolls and could not vote until a local election judge received authorization from the Board of Elections by telephone or in writing. Election judges in more than a third of the city's voting precincts had to call the Board of Elections because of voter registration problems. At least half of the election officials couldn't get through to election headquarters because the line was busy. Hence, the flood of angry voters sent downtown. The Gore campaign filed an emergency suit late that afternoon, asking a court to keep the polls open an extra 3 hours so that everyone could vote. Nightsage was among those who testified before the St. Louis Circuit Court Judge Evelyn Baker. Baker ordered the polls open until 10 p.m. in St. Louis. The Bush campaign filed an immediate appeal. 45 minutes later, the Missouri Court of Appeals rescinded Baker's order and closed the polls. Only 100 additional voters had been able to cast ballots during the brief additional time. As of 10 p.m. on Election Day, a Justice Department lawsuit later said, individuals were still standing in line at the downtown headquarters of the Board of Elections. Baker's order infuriated Missouri Republicans, who gathered at an election night party at the St. Louis Marriott West Hotel. The Missouri Senator John Ashcroft watched in disbelief as election returns showed him losing to a dead man. Ashcroft's opponent in the closely watched Senate race, Missouri's Governor Mel Carnahan, had died in a plane crash 3 weeks before the election. His name remained on the ballot, and his wife Jean ran in his stead. "I'm still with Mel" became her campaign slogan. Republicans view the extended poll hours as a last-ditch attempt to illegitimately oust Ashcroft from office. "I know there were very serious allegations of fraud and corruption as it related to the conduct of the election in the city of St. Louis," Ashcroft said. Missouri's senior senator, the Republican Kit Bond, was far more blunt. "Democrats in the city of St. Louis are trying to steal this election," he screamed into the microphone at the Marriott, slamming his right fist on the podium in anger. How else could a sitting senator lose to a dead man? Ashcroft lost by 49,000 votes, a result that would not have been determined by 100 extra people voting from 7 to 7:45 p.m. Nevertheless, Bond sent the FBI and the U.S. Attorney's Office a 250-page report alleging a major criminal enterprise designed to defraud voters. Less than 2 months later, Bush nominated Ashcroft as Attorney General, and a new right-wing voter fraud movement was born. A month before the 2002 election, 300 FBI agents and U.S. attorneys traveled to Washington for the first annual Voting Integrity Symposium, which Ashcroft called an unprecedented gathering of the nation's justice officials. It was the first meeting of the Attorney General's new Voting Access and Integrity Initiative, a major joint project of the DOJ's Civil Rights Division and Public Integrity Unit. Though the initiative was supposed to combat voting discrimination and voter fraud, the latter cause clearly took priority. Voting integrity had become the shorthand for targeting fraud. Deputy Attorney General Larry Thompson described it as an issue that I know is close to the Attorney General's heart. Ashcroft spoke in the ornate Great Hall of the Justice Department. At a cost of $8,000, the devout Attorney General had installed massive navy drapes covering the bare-chested Art Deco statues of Lady Justice and her male counterpart, Majesty of Justice. The dour Ashcroft painted a bleak picture of the country's electoral security. "Votes have been bought, voters intimidated, and ballot boxes stuffed," he said. "The polling process has been disrupted or not completed. Voters have been duped into signing absentee ballots believing they were applications for public relief, and the residents of cemeteries have infamously showed up at the polls on Election Day. Political war stories like these are often told with a grin, but these failures of our democracy are no laughing matter. There is nothing funny about winning an election with stolen votes." Ashcroft called for a new ethic of enforcement of our voting rights, which kicked off a multi-year probe into alleged voter fraud abuses, beginning with 120 new election fraud investigations. The new emphasis on voter fraud represented a major shift in priorities for the Civil Rights Division and its voting section, which had previously focused on reinforcing the Voting Rights Act and protecting minority voters from discrimination. Ashcroft's new initiative was done with absolutely no consultation at all with the voting section, said Joe Rich, chief of the voting section, who had been with the Civil Rights Division since 1968. Rich and the voting section quickly became a target of the department's new conservative political appointees. In late 2001, Ashcroft hired 3 GOP operatives for the Voting Access and Integrity Initiative. Hans von Spakovsky, the former head of the Fulton County Republican Party in Atlanta, became the brains of the operation. Von Spakovsky's unusual name, which sounded like a 19th-century Austrian villain's, came from his Russian father, who met his German mother at a displaced persons camp in Bavaria after World War II, and immigrated to the United States in 1951. They were fierce anti-communists who settled in Huntsville, Alabama. After graduating from MIT and Vanderbilt Law School, von Spakovsky volunteered as a GOP poll watcher at an inner-city housing project in Atlanta. During his first election, he said he observed election officials asking voters which party they belonged to, which was forbidden in a general election. Voter fraud became von Spakovsky's obsession. For too long in this country, we have taken our elections for granted and have assumed that the type of fraud we read about in third world countries could not happen here, he wrote in a letter published in the Wall Street Journal in 1995. Well, it very easily could and does. At the DOJ, von Spakovsky initially worked on the Help America Vote Act, HAVA, Congress's response to the 2000 election. After its passage in 2002, he was promoted to the front office of the Civil Rights Division, the home of the powerful political appointees, as special counsel to the Assistant Attorney General for Civil Rights. He soon became the de facto head of the voting section. 6 former career attorneys in the voting section called him the point person for undermining the Civil Rights Division's mandate to protect voting rights. The first stirrings of a new movement to restrict voting came after the 2000 Florida election fiasco, wrote Wendy Weiser of the Brennan Center for Justice, which taught the unfortunate lesson that even small manipulations of election procedures could affect outcomes in close races. HAVA was supposed to prevent another Florida, but many of the problems that plagued Florida in 2000 resurfaced in Ohio 4 years later. In November 2003, Ebony Malone, a 20-year-old food service cook, registered to vote in downtown Cleveland. She received her voter registration card 3 months later. Shortly thereafter, she moved and updated her registration address, but she never received a new registration card. Then, in October 2004, a worker from the community organizing group Acorn told her she was on a list of voters whose eligibility would be challenged at the polls by the Republican Party. "I am worried that I will be unable to vote on Election Day," she said in a court declaration. Malone's name appeared on the GOP's challenge list because of a mailing the Ohio Republican Party chairman Robert Bennett sent to 232,000 newly registered voters between January and August 2004, urging them to vote Republican. 35,000 letters were returned as undeliverable, which the GOP saw as evidence of impending voter fraud. The potential for these fraudulent registrations to produce fraudulent votes at the ballot box is very real, Bennett said. It just so happened that more than half the challenged voters lived in Ohio's 2 most populous counties, Cuyahoga, Cleveland, and Franklin, Columbus, which were overwhelmingly Democratic and heavily minority. The DNC sued the RNC, claiming that a prior court ruling prohibited the party from engaging in such voter caging. In 1981, during a New Jersey gubernatorial election, the RNC launched a ballot security task force that sent letters to voters in predominantly African American and Hispanic precincts. When 45,000 letters were returned as undeliverable, the RNC tried to remove the voters from the rolls and hired off-duty cops to patrol polling sites in the Black and Hispanic neighborhoods of Newark and Trenton. They posted large signs on Election Day reading, "This area is being patrolled by the National Ballot Security Task Force. It is a crime to falsify a ballot or to violate election laws." After the election, the DNC won a court settlement ordering the RNC to refrain from undertaking any ballot security activities. When the Ohio case went to federal court, the Justice Department, 4 days before the election, sent a highly unusual letter to the District Court Judge Susan Dlott that backed the Ohio GOP's position. Voter challenges, wrote the Assistant Attorney General for Civil Rights, Alex Acosta, struck a balance between ballot access and ballot integrity. This was Ashcroft's strategy in action. Von Spakovsky spearheaded the effort, according to Civil Rights Division lawyers. "Hans wrote the brief," said Joe Rich. "It was done with absolutely no input from the voting section." The intervention raised eyebrows because the DOJ had not been a party to the case, nor had the court asked for its opinion, and the Civil Rights Division didn't like to take sides in a partisan election dispute days before an election. Von Spakovsky's letter amounted to cheerleading for the Republican defendants, said Rich's deputy Bob Kengel. It was doubly outrageous because the allegation in the litigation was that these were overwhelmingly African American voters that were on the challenge list. The court ruled against the RNC, finding that voters like Malone faced irreparable injury in that her constitutional right to vote was threatened. The challenges had to stop. But elsewhere in Ohio, Secretary of State Ken Blackwell, the Bush campaign's co-chair, reprised the role of Katherine Harris, issuing a series of directives limiting the availability of provisional ballots now mandated by HAVA and requiring that voter registration forms be accepted only on 80-pound paper stock. His decisions were immediately challenged in court. Days before the election, hundreds of Democrats, including John Lewis, marched from the state capitol to Blackwell's office in Columbus, carrying signs reading, "Not this time," and chanting, "Count every vote." "We cannot forget what happened in Florida," a fired-up Lewis told the crowd, "and it will not happen here." But on Election Day in 2004, history repeated itself. When Tanya Thivener, a 38-year-old mortgage broker, arrived at her polling place in a majority-black neighborhood of Columbus, she found a line stretching out the door. She waited in line to cast a ballot for 4 hours, including 1 hour in the rain. She watched dozens of voters abandon the polls in disgust. "A lot of people left in the 4 hours I waited," she said. "A lot of them were young black men who were saying over and over, 'We knew this would happen.'" After finally voting for John Kerry, she drove to her mother's house in a white, heavily Republican suburb of Franklin County. How long had she waited to vote? Thivener asked her mom. 15 minutes, she replied. Thivener couldn't believe it. Even though HAVA allocated $3.9 billion for states to modernize their election systems, county election officials in Ohio allocated far fewer voting machines than necessary to accommodate the high voter turnout in the nation's top battleground state. That was especially true in heavily popular Democratic cities like Columbus, Cleveland, Toledo, and Akron, and on college campuses like Kenyon, where students waited in line for up to 10 hours. Overwhelmingly Democratic precincts in Columbus received 17 fewer voting machines in 2004 than 2000, while heavily Republican precincts got 8 more machines. That explained the gaping difference in wait times between Thivener and her mother. The Franklin County Board of Elections, which was narrowly controlled by Republicans, used half as many polling machines as its own analysis recommended. By mid-morning, the Ohio Democratic Party had filed an emergency court appeal asking for additional voting machines in Franklin and Knox counties. The massive lines are deterring voters from waiting to cast their ballots, the lawsuit stated. The situation is dire. The party produced affidavits from 15 election judges and poll watchers describing the long lines. At 12:35, there are approximately 90 voters in line, wrote Josh Schoenberger at Precinct 25F in northeastern Columbus. The wait in line at this precinct is approximately 3 hours. The line has been this long all day. I have personally observed voters leaving without having voted due to the long lines. The precinct is predominantly African American. I am serving as a presiding judge, a position I've held for some 15-plus years in Precinct 40, wrote Richard Frost from his polling place near Ohio State University. In all my years of service, the lines are by far the longest I have seen, with some waiting as long as 4 to 5 hours. I expect the situation to only worsen as the early evening heavy turnout approaches. I have requested additional machines since 6:40 a.m., and no assistance has been offered. The District Court Judge Algernon Marbley finally ordered that voters be given paper ballots in the early evening. By then, however, the damage had been done. A post-election survey by the pollsters Cornell Belcher and Diane Feldman for the DNC estimated that 3% of Ohio voters left their polling places without voting because of the long lines. That number, 174,000, was larger than Bush's 118,000 margin of victory in the Buckeye State. The Election Day experience for most African American voters was starkly different from that of most white voters in Ohio, Belcher and Feldman found. African Americans waited an average of 52 minutes to vote, compared with 18 minutes for white voters. Twice as many black voters reported experiencing problems at the polls. The long lines became known as a time tax. Edward Hales, the former staff director for the Civil Rights Commission, spent the 2004 election in Ohio. There were the same issues in Ohio that we found in Florida in 2000, he said. The CBC once again protested the certification of the presidential electors because of the widespread irregularities in Ohio. This time they found a senator, Barbara Boxer of California, willing to sign on to the challenge, for the first time since 1877. It did little good. The Senate voted 74-1, and the House voted 267-31 to uphold the election results. Get over it, said the GOP Representative Rick Keller of Florida. How can we get over it when people died for the right to vote? Lewis responded. On the 40th anniversary of the VRA, a sticky Saturday in August 2005, Lewis was once again marching. This time, 20,000 people joined him on the streets of Atlanta. They included veterans of the Selma to Montgomery March, like the comedian Dick Gregory and the singer Harry Belafonte. They chanted, "Keep the Vote Alive," the theme of the day, as they marched 1 mile down Martin Luther King Drive from the Richard B. Russell Federal Building downtown to Morris Brown College, blocks away from where Lewis once ran SNCC. 40 years later, we're still marching for the right to vote, Lewis said when the marchers reached Morris Brown's large football stadium. The Voting Rights Act was good in 1965, and it's good in 2005. We're being too quiet with this administration. We've got to talk back to the Bush administration. Keep your eyes on the prize. Lewis didn't want to hear any platitudes about how much racial progress America had made. The manipulation of the electoral system for partisan advantage had been a defining feature of the 2000 election in Florida and the 2004 election in Ohio. The new wave of GOP-led voter disenfranchisement efforts uniquely targeted black voters, who had become the most loyal group of Democratic voters. After the 2004 election, Republicans intensified their drive to restrict access to the ballot by hyping the threat of voter fraud. Atlanta was chosen as the site of the march because 5 months earlier, Georgia had passed the first law requiring government-issued photo identification to cast a ballot. After the 2004 election, Republicans took control of state government in Georgia for the first time since 1871. When the legislature convened in early 2005, the GOP Representative Sue Burmeister of Augusta introduced the voter ID bill. A devout Lutheran from Wisconsin, Burmeister kept a Bible on her desk next to a business card holder with a cross on it and wore a silver pin on her lapel showing tiny feet inside a womb, signifying the sanctity of life. Her inspiration for the law came from reading the Wall Street Journal columnist John Fund's book, Stealing Elections, which claimed that at least 8 of the 19 hijackers who attacked the World Trade Center and the Pentagon were actually able to register to vote in either Virginia or Florida. There was no proof, however, that they did register to vote. If terrorists could register to vote, Burmeister reasoned, what would stop other criminals from manipulating U.S. elections? It's about protecting the security of our elections, she said. The bill does get at the heart of voter fraud. The reason voter fraud isn't caught at the polls is because there is no picture ID requirement. Before 2005, Georgians could vote with 17 different types of identification, including a Social Security card, student ID, and birth certificate. Burmeister's proposal allowed only 6 forms of government-issued photo ID: a Georgia driver's license, a Georgia ID card, a U.S. passport, a government employee ID card, a military ID, and a tribal ID. The debate in the Georgia legislature proved highly contentious. Governor Sonny Perdue admitted that 300,000 registered Georgians did not have driver's licenses or state ID cards. Census data showed that blacks were 5 times more likely than whites to not have cars, and thus not own driver's licenses, and were disproportionately more likely to lack the other forms of required ID. Only 56 of 159 counties in Georgia issued driver's licenses or photo IDs, and none were in metro Atlanta. Moreover, the state planned to charge $20 to $35 for an ID card, which Lewis called a modern-day poll tax. The law's critics pointed out that Georgia Republicans had not provided any evidence of specific cases of voter fraud that the new law would stop. I cannot recall one documented case of voter fraud during my tenure as Secretary of State or Assistant Secretary of State that specifically related to the impersonation of a registered voter at voting polls. Secretary of State Kathy Cox, who'd been in office since 1996, wrote to Governor Perdue. The bill did not require a photo ID for absentee ballots, Cox noted, where the potential for fraud was much greater. Elderly voters and members of the military, 2 heavily GOP voting blocs, often voted absentee. The bill passed on an emotional party line vote in both chambers. Members of the Georgia Legislative Black Caucus walked out of the legislature to protest the final vote. The state representative, Randall Mangum of Decatur, dropped a pair of shackles on Burmeister's desk. "This is wrong," shouted Senator Vincent Fort of Atlanta as he exited. "What's happening today is just an updated form of Jim Crow." Georgia submitted the legislation to the Justice Department for approval under Section 5 on June 13, 2005. Lewis urged the Civil Rights Division to reject it. "We have struggled too long and too hard to see, in Georgia and other parts of our country, people moving to violate the very spirit and letter of the Voting Rights Act of 1965, he said. If the DOJ approved the law, warned Jesse Jackson, it would spread like a virus to other states. Since he was a young activist in Nashville, Lewis had looked to the Civil Rights Division as a sympathetic referee. Those days were now over. In May 2002, the National Review published Fort Liberalism, Can Justice's Civil Rights Division be Bushified? The blueprint for a radical restructuring of the Civil Rights Division. There may be no part of the federal government where liberalism is more deeply entrenched, wrote the national correspondent John J. Miller. Even Brad Reynolds and the Reagan administration had failed to disrupt the bipartisan consensus favoring vigorous enforcement of the country's civil rights laws, particularly the VRA. The second-generation counter-revolutionaries in the Bush administration shouldn't make the same mistake. Republicans should work to gain more control over the Civil Rights Division and its renegade lawyers, Miller wrote. Republican political appointees should seize control of the hiring process. He recommended firing longtime section chiefs and bringing in new lawyers with strong conservative credentials. New hires in the Bush Civil Rights Division, like von Spakovsky, eagerly embarked on the new assignment. Searching for a conservative in the Civil Rights Division prior to 2001 was like Diogenes searching for an honest man in ancient Greece, von Spakovsky wrote. Exactly a year after the National Review article, Ashcroft tapped Brad Schlossman, a 33-year-old Kansan with no prior civil rights litigation experience, to undertake an extreme makeover of the Civil Rights Division as Deputy Assistant Attorney General for Civil Rights. Schlossman had a high-pitched nasal voice and a frat boy persona. He'd previously worked with Reynolds, whom he considered a mentor, at the law firm Howry & Simon, where he bragged to colleagues that he made up a 4-member vast right-wing conspiracy. Schlossman was put in charge of hiring and supervising for the voting, criminal, appellate, special litigation, and employment litigation sections. I, too, get to work with mold spores, but here in civil rights we call them voting section attorneys, he wrote to a former colleague in July 2003. My tentative plans are to gerrymander all of those crazy libs right out of the section. Schlossman embarked on a hiring spree of RTAs, short for right-thinking Americans, recruiting a dozen lawyers from the Federalist Society, the National Republican Lawyers Association, and the Bush-Cheney campaign. 64% of Schlossman's hires were self-identified Republicans or conservatives. Only 19 of 45 lawyers Schlossman hired for the voting, employment, and appellate sections had any civil rights experience, and 9 of them had opposed civil rights enforcement efforts. When we start asking about what is your commitment to civil rights, how do you prove that, he said in a voicemail to the Special Litigation Section Chief, Shanetta Cutler. Usually by membership in some crazy liberal organization or by some partisan in some crazy cause. So I just want to make sure we don't start confining ourselves to, Politburo members, because they happen to be a member of some, psychopathic left-wing organization designed to overthrow the government. An internal Justice Department review subsequently found that Schlossman improperly considered political and ideological affiliations in the recruitment and hiring of career attorneys in the Civil Rights Division, violating DOJ guidelines and civil service laws. Veteran civil rights lawyers with decades of experience began leaving in droves. They included the well-respected chief of the voting section, Joe Rich, and his deputy, Bob Kengel, who took early buyouts. Throughout all their years working for Democratic and Republican administrations from Nixon to Clinton, they'd never been treated with such disdain by political appointees who bitterly opposed the very laws they were meant to enforce. You take an oath to uphold the laws of the United States, Kengel said. These guys didn't believe in the laws of the United States. They came in to work for an institution for which they had the utmost contempt. In May 2005, Schlossman was promoted to acting head of the Civil Rights Division. He handed the keys to the voting section to von Spakovsky. The career lawyers who remained likened the voting section to Vichy France during the Nazi occupation. In June 2005, a week after Georgia submitted its voter ID law for DOJ approval, an article appeared in the Texas Review of Law and Politics, a conservative legal journal, entitled Securing the Integrity of American Elections, The Need for Change. Its author, writing under the pseudonym Publius, the same moniker used by the authors of the Federalist Papers in honor of the Roman consul Publius Valerius Publicola, was identified as an attorney who specializes in election issues. It is unfortunately true that in the great democracy in which we live, voter fraud has had a long and studied role in our elections, the article began. It continued, putting security measures in place, such as requiring identification when voting, does not disenfranchise voters, and there is no evidence to suggest otherwise. Only a year later did the news emerge that Publius was in fact Hans von Spakovsky. The explosive revelation was hardly surprising. Von Spakovsky had been writing in favor of voter ID laws before practically anyone else. Requiring official picture identification such as a driver's license with a current address would immediately cut down on a large amount of fraud, he wrote in the Wall Street Journal in 1995. 2 years later, he recommended Georgia should require all potential voters to present reliable photo identifications at their polling locations to help prevent imposters from voting. DOJ ethics guidelines clearly stated that von Spakovsky, given his long-standing advocacy for voter ID laws and the strong viewpoints in his then anonymous article, should have recused himself from consideration of Georgia's voter ID law. Instead, he became the leading proponent for Georgia Republicans during the Section 5 review. Career lawyers in the voting section suspected he'd also helped the Georgia legislature write the law. The new chief of the voting section, John Tanner, was eager to please Schlossman and von Spakovsky. When Schlossman asked Tanner how he liked his coffee, Tanner replied, "Mary Frances Berry style, black and bitter." Berry had headed the U.S. Commission on Civil Rights from 1993 until 2004. Tanner assigned one of Schlossman's new hires, Joshua Rogers, to work on the 5-member team reviewing the Georgia law. Rogers was a graduate of the University of Mississippi Law School and a member of the Federalist Society and the Christian Legal Society. He knew little about the VRA when he joined the review team. He had no familiarity with Section 5, said Heather Moss, a civil rights analyst in the voting section who worked on the Georgia Review. He would ask me simple questions like, "What is pre-clearance?" Von Spakovsky began secretly emailing Rogers copies of his articles and arguments and analysis in favor of the Georgia ID law. He told him to password protect his computer so that no other attorneys on the team could see their correspondence. They chose to put him on the case because of his political leanings and personal connection with von Spakovsky, Moss said. Von Spakovsky also dismissed concerns about Georgia's law in meetings with the review team. "You can get a voter ID at any Kroger's in Georgia," he told Moss during an early presentation she gave. "How could you not know that?" Tanner angrily asked her afterward. When Moss did more research, she found out that the grocery chain had issued photo IDs at select locations in Georgia during a pilot project in 2000, but that the program was not in place anymore and hadn't been for a while. "We went in with the attitude that we were going to do the traditional civil rights analysis," Moss said. "They were looking for evidence to pre-clear it." Despite von Spakovsky's best efforts, the review did not reflect positively on his home state. Rogers interviewed Burmeister about why she introduced the law. According to the DOJ's records of the conversation, Burmeister said that if there are fewer black voters because of the bill, it will only be because there is less opportunity for fraud. She said when black voters in her precinct are not paid to vote, they do not go to the polls. Her racially inflammatory assertions, indicating that the law may have been enacted with a discriminatory purpose, set off alarm bells among the review team. But Rogers defended Burmeister. He thought that what she said was completely reasonable and not concerning, Moss remembered. "That's what she observed," he said. Atlanta's mayor, Shirley Franklin, presented a very different perspective on the issue, telling the story of her 84-year-old mother who had recently moved from Philadelphia to Atlanta and could not obtain a new photo ID for voting. She visited multiple DMV offices before finding one that was open. Her expired Pennsylvania driver's license was rejected as sufficient documentation to obtain a Georgia ID card, and she was told to produce a copy of her birth certificate. But Franklin's mother had been born at home in North Carolina, and like many elderly African Americans who grew up during Jim Crow, never had a birth certificate. After voting for 40 years, she would be disenfranchised by the new law. Citing the high number of voters without ID, the disparate rates of ID possession among blacks and whites, the number of DMV offices that did not issue IDs, the cost of the ID, and the underlying documents needed to obtain an ID, ranging from $20 for an ID card to $210 for naturalization papers, 4 of 5 members of the Georgia Review team urged that the law be rejected under Section 5. While no single piece of data confirms that blacks will be disparately impacted compared to whites, the totality of evidence points to that conclusion, they wrote in a 51-page analysis. The 4-member majority of the review team presented its recommendation to Tanner on August 25, 2005. The next day, Georgia officials told the voting section lawyers that the state had overstated the number of people with driver's licenses or ID cards by 600,000. The review team asked Tanner for more time to examine this crucial information, which made the case for rejecting the law even stronger. But Tanner said no and told them he'd already decided to approve the law. Rogers had submitted a dissenting memo drafted by von Spakovsky that Tanner used as the basis for his swift approval letter. Contrary to DOJ protocol, the detailed analysis recommending a rejection of the law was never even sent to the political appointees in the Civil Rights Division. Not that it would have made a difference with Schlossman in charge. A few years later, during a speech before a Latino group in Los Angeles, Tanner explained his reasons for approving the law. He cited data showing that elderly voters in Georgia were more likely to lack voter IDs. Anything that disproportionately impacts the elderly has the opposite impact on minorities, he claimed. Minorities don't become elderly the way white people do. They die first. His statement was both racist and factually wrong. Blacks made up 40% of the elderly voters in Georgia who lacked the newly required forms of voter ID. To supporters of the VRA, the Georgia review process epitomized the corruption of the Bush Civil Rights Division. You could ask anyone who's done Section 5 enforcement for 30 years. There's never been anything like that, Joe Rich said. Rogers, von Spakovsky's conduit, received a $450 bonus for his work on the case. Tanner reprimanded the 4 other members of the team. The retribution didn't end there. The deputy chief of the Section 5 unit tried to give Moss a negative performance evaluation, alleging that her personal political views influenced her work. Her supervisor resigned in protest rather than acquiesce. Within a year, all 4 members of the Georgia review team who recommended a Section 5 objection had left the voting section. They were part of a broader exodus from the section, which lost over half of its lawyers during the Bush years. VRA enforcement came to a standstill. From 2001 to 2005, the DOJ objected to only 48 voting changes out of 81,000 submitted, 10 times fewer than during the first 4 years of the Reagan administration. Georgia's wasn't the only controversial voting change the department had approved. 2 years earlier, the political appointees had signed off on an unprecedented mid-year congressional redistricting plan in Texas, engineered by the House Majority Leader Tom DeLay. The plan eliminated the seats of 6 white Democrats and dismantled 2 majority-minority districts, leading the voting section review team to unanimously recommend that it be blocked. As in Georgia, the career staff was overruled. In the first 5 years of the Bush administration, the Civil Rights Division filed only 1 case alleging voting discrimination in the Deep South, on behalf of white voters in Noxubee County, Mississippi, for the first time in the history of the VRA, against a black Democrat accused of voter fraud. Veterans of the voting section could only shake their heads at the irony. During the second Bush administration, said Paul Hancock, who spent 20 years in the Civil Rights Division, people were referring to Brad Reynolds as the good old days. Shortly after the 2006 election, David Iglesias, the U.S. Attorney for New Mexico, received a call from Mike Battle, Director of the Executive Office for U.S. Attorneys, who told Iglesias he was being replaced. He was not alone. On the orders of the White House, initiated by the Deputy Chief of Staff Karl Rove, 7 U.S. attorneys were fired in 1 week. Iglesias had the dream Republican resume, the child of Southern Baptist missionaries, a naval lawyer who had been an inspiration for Tom Cruise's character in A Few Good Men, the co-chair of Lawyers for Bush in 2000. He was one of only 2 U.S. attorneys to create a special election fraud task force following Ashcroft's anti-fraud initiative in 2002 and taught a voting integrity symposium at the DOJ in 2005. Iglesias' task force received more than 100 complaints of voter fraud prior to the 2004 election. Vote fraud issues are intensifying, and we are looking for you to lead. Alan Way, the chairman of the New Mexico Republican Party, wrote to him. Gore had won New Mexico by 366 votes in 2000, and Republicans were looking for any edge they could get in 2004. I believe the voter ID issue should be used now at all levels. Federal, state legislative races. Michael Rogers, the former counsel for the state Republican Party, wrote to New Mexico Republican activists, including Iglesias. This is the single best wedge issue ever in NM. New Mexico Republicans wanted Iglesias to file indictments against employees of the left-leaning voter registration group Acorn for submitting false registration forms. But after the election, Iglesias told Way there wasn't enough evidence to justify the prosecutions. Way then asked the White House to replace Iglesias. As you are aware, the incumbent, David Iglesias, has failed miserably in his duty to prosecute voter fraud, Way wrote to the Rove deputy Scott Jennings, copying Rove on the email. If we can get a new U.S. attorney that takes voter fraud seriously, we'll make some real progress in cleaning up a state notorious for crooked elections. Before the 2006 election, Bush and Rove complained to Attorney General Alberto Gonzales about Iglesias. Is anything ever going to happen to that guy? Way asked Rove at a White House Christmas party. He's gone, Rove replied. Iglesias wasn't the only U.S. attorney fired for failing to bring voter fraud cases. In 2004, the Democrat Christine Gregoire defeated the Republican Dino Rossi by 129 votes in the Washington state governor's race. After 2 recounts declared Gregoire the winner, Washington Republicans pushed John McKay, the U.S. Attorney for the Western District of Washington, to investigate alleged election irregularities. The chief of staff to the Republican Congressman Doc Hastings called McKay to ask about the status of the investigation. There was no evidence, McKay said, and I am not going to drag innocent people in front of a grand jury. McKay, another Bush appointee, was widely respected in Washington state. A DOJ performance evaluation in 2006 called him an effective, well-regarded, and capable leader. But when McKay interviewed at the White House for a federal judgeship opening, the White House counsel Harriet Miers asked him to explain why he had mishandled voter fraud prosecutions. Soon he was out of a job. Of the 12 U.S. attorneys whom the Bush administration dismissed or considered removing as part of what became known as Attorneygate, 5 worked in places identified by Rove in 2006 as voter fraud hotspots, including Missouri, New Mexico, and Washington. It's like the boogeyman parents use to scare their children, Iglesias said of voter fraud accusations. It's very frightening, and it doesn't exist. U.S. attorneys have better things to do with their time than chasing voter fraud phantoms. Ashcroft's much-hyped Voting Access and Integrity Initiative didn't turn up much new evidence either. The major probe by the Justice Department between 2002 and 2007 resulted in only 86 convictions out of 300 million votes cast during that period. There were a handful of cases of double voting. 30 people were convicted of small vote-buying schemes for local sheriff or judgeship races. A smattering of immigrants and felons mistakenly registered to vote or voted. Rarely did the punishment fit the crime. Usman Ali, a native of Pakistan who owned a jewelry store in Tallahassee, accidentally filled out a voter registration card while renewing his driver's license. Though he never voted, he was deported on misdemeanor charges after living in the United States for more than a decade. In Milwaukee, Kimberly Prude voted absentee in 2004 while on probation, which she didn't think prevented her from voting. She spent over a year in jail for her offense. In Alaska, Rogelio Mejorada Lopez, a Mexican immigrant who managed a gas station, received a voter registration card in the mail after applying for U.S. citizenship. He voted, mistakenly believing he was eligible, and faced deportation after 16 years in the United States. These were minor mistakes, not evidence of a massive criminal conspiracy on the magnitude that Ashcroft, Rove, and many others in the Bush administration alleged. They were sure there was fraud, said Joe Rich, but they could never find it. Not a single voter was charged for going to the polls and impersonating an eligible voter. But that didn't stop voter ID proponents like von Spakovsky from arguing that voter ID laws were urgently needed. In March 2006, Bush gave von Spakovsky a recess appointment to the Federal Election Commission. Von Spakovsky was also appointed to the Advisory Board of the Election Assistance Commission, created by HAVA to analyze the country's election problems. The commission hired 2 well-respected experts, the Republican Job Serebrov and the Democrat Tova Wang, to produce a comprehensive study on voter fraud. There is widespread but not unanimous agreement that there is little polling place fraud, or at least much less than is claimed, including voter impersonation, dead voters, non-citizen voting, and felon voters, a draft of the report stated. After von Spakovsky complained to the Commission's GOP leadership, the wording in the final report was changed to, "There is a great deal of debate on the pervasiveness of fraud." Von Spakovsky's interventions also suppressed the release of a study on voter ID laws by election experts at Ohio State and Rutgers, which found that identification requirements for voters reduced Hispanic turnout by 10% and Black and Asian American turnout by 6% in 2004. No matter how much evidence emerged to the contrary, the voter fraud myth would not die. The University of California, Irvine law professor Rick Hassan dubbed von Spakovsky, Rove, and their ilk the fraudulent fraud squad. In early 2005, the CBC met with President Bush in the White House Cabinet Room. In 2 years, the temporary provisions of the VRA, last renewed in 1982, were set to expire. Do we have your support in extending and strengthening the 1965 Voting Rights Act when it comes up for renewal in 2007? Congressman Jesse Jackson, Jr. asked the president. Bush answered that he didn't know enough about the law to comment on it and would take a position once there was new legislation in Congress. His answer stunned the black members. I thought the president either needs to fire his staff or pay more attention during Black History Month, said Congressman Emanuel Cleaver of Missouri. Given the administration's fixation on voter fraud and dismantling of the Civil Rights Division, the prospects for the VRA's renewal didn't look good. But the administration had also launched a very public effort to court black voters. Following Bush's re-election, the RNC chairman, Ken Mehlman, Bush's campaign manager in 2004, traveled thousands of miles to speak at black churches and civic organizations, trying to rebrand the GOP as the party of Lincoln and Frederick Douglass. At the NAACP's 96th annual convention in Milwaukee in July 2005, he publicly apologized for the Republican Party's Southern strategy. By the 70s and into the 80s and 90s, the Democratic Party solidified its gains in the African American community, and we Republicans did not effectively reach out, Mehlman told 3,000 black delegates at the Midwest Airlines Arena. Some Republicans gave up on winning the African American vote, looking the other way or trying to benefit politically from racial polarization. I am here today as the Republican chairman to tell you we were wrong. 4 days before Mehlman's speech, Congressman James Sensenbrenner, the Republican chairman of the House Judiciary Committee, told the NAACP that he was preparing to reauthorize the VRA. I am here to tell you publicly what I have told others privately, including the head of the Congressional Black Caucus, Representative Mel Watt, that during this Congress we are going to extend the Voting Rights Act, Sensenbrenner announced to a sustained standing ovation punctuated by organ chords. Just like its enactment and its 1982 extension, this bipartisan effort will succeed, he predicted. While we have made progress and curtailed injustices thanks to the Voting Rights Act, our work is not yet complete. We cannot let discriminatory practices of the past resurface to threaten future gains. The Voting Rights Act must continue to exist and exist in its current form. The White House and GOP leadership in Congress, which control the House and Senate, quickly signaled they were on board. Beginning in early 2005, Sensenbrenner and Watt, a member of the Judiciary Committee since 1992 and the new chair of the CBC, began secretly meeting to plot the strategy for the VRA's reauthorization. They were the ultimate political odd couple. Sensenbrenner was an heir to the fortune of the Kimberly-Clark Corporation, which manufactured tampons and represented the wealthiest and most Republican district in Wisconsin, compromising the overwhelmingly white northern and western suburbs of Milwaukee. He had a near-perfect conservative voting record from the American Conservative Union and had been one of the floor managers during Bill Clinton's impeachment. Watt, one of the most liberal members of Congress, grew up in stark poverty and represented the working-class urban areas of the North Carolina Piedmont. He'd endured 4 reconfigurations of his district since the Shaw v. Reno decision, becoming the poster child for VRA litigation. The 62-year-old Sensenbrenner was large and volatile, with a thick Wisconsin accent and a fondness for oversized Cadillacs and mammoth cigars. He is commonly described as prickly, cantankerous, and unpleasant, the New York Times once wrote, and this is by his friends. When Democrats denounced the Patriot Act, which Sensenbrenner introduced during a Judiciary Committee hearing in 2005, Sensenbrenner abruptly stormed out with the gavel. The footage ended up on The Daily Show. Rolling Stone dubbed him the dictator. Despite their very different philosophies and personalities, Watt and Sensenbrenner formed an unlikely bond. Sensenbrenner and I had taken diametrically opposed positions on the Judiciary Committee, Watt said. What I came to understand about him, and what he came to understand about me, is that if we believed in something, we would fight for it. Though Sensenbrenner once described himself as not the most civil-righteous individual in the House of Representatives, he had led the effort to reauthorize the VRA in 1982 as a young member of Congress, taking on the Reagan administration and Senate Republicans. He believed that the GOP could remain the party of Lincoln by embracing the VRA. The Voting Rights Act of 1965 had been the most successful piece of civil rights legislation ever passed by the Congress, he testified before the Senate. He displayed one of the pens Reagan had used to sign the VRA extension in his Capitol Hill office. Watt and Sensenbrenner agreed on three major points. First, the VRA needed to be reauthorized before the 2006 election, after which Sensenbrenner would be replaced as House Judiciary Committee chairman by the Texas Representative Lamar Smith, who did not share Sensenbrenner's affinity for the law. Second, the law had to be reauthorized, not rewritten, in order to assure quick passage. Any attempt to have states with more recent voting problems, like Ohio, approve their voting changes with the federal government would doom the entire effort. Third, Watt would police the left and Sensenbrenner would police the right to maintain a bipartisan consensus. You go and fight off the people who want to do away with the Voting Rights Act, and I'll go and fight off the people who want to dramatically change the Voting Rights Act, Watt told Sensenbrenner. Less than a year after the NAACP convention, Sensenbrenner, Watt, John Lewis, and the congressional leadership of both parties gathered on the steps of the Capitol to introduce the Fannie Lou Hamer, Rosa Parks, and Coretta Scott King Voting Rights Act Reauthorization and Amendments Act of 2006, renewing the VRA for another 25 years. Like other landmark civil rights bills, the renewed and restored bill that we introduced today is good for all Americans, Watt said. It is not a Republican bill, it is not a Democratic bill, it is not a House bill or a Senate bill, and it is not a bill solely for minorities. This is a bipartisan, bicameral bill that unites us as a country by ensuring that all Americans may have their voices heard. Naming the bill after three female pioneers of the civil rights movement allows us to ensure that rights they fought for remain for future generations, Watt said. The reauthorization of the law seemed assured, but opponents of the VRA weren't going to give up without a fight. In 1990, Ed Blum, a 38-year-old stockbroker at Payne Webber, moved from the Houston suburbs to the Museum District downtown into the 18th Congressional District, drawn and once represented by Barbara Jordan. It was known as the Black Seat. When Blum went to vote that year, he realized there was no Republican challenger running against the Democrat Craig Washington, who had succeeded Jordan and Mickey Leland in Congress. So 2 years later, Blum decided to run himself. I believe most of you are asking yourselves, why is this poor son of a bitch doing this to himself? Doesn't he know he can't win? Blum said on the campaign trail. Go ahead and nod your heads. Be honest. He explained, the 550,000 people living in this district should have a choice when it comes time to vote for their representative. Blum's parents were liberal Jewish Democrats, and he had volunteered for the McGovern campaign while attending the University of Texas. But he became a Republican during the Reagan years after reading the neoconservative magazine Commentary, which fervently subscribed to the colorblind conservatism championed by the Reagan administration. My mom and dad were Roosevelt-Truman Democrats, Blum said. Our household was pro-civil rights. I am probably the first Republican that my mother ever met. Blum decided to knock on as many doors as possible. He took one side of the street and his wife, Lark, took the other. Even with detailed street maps, Blum said, it was nearly impossible to determine who was in the district. I couldn't always tell who I was running to represent. Black and Hispanic voters who lived side by side frequently resided in different congressional districts. This didn't happen just once, he said. It happened dozens and dozens of times. After the 1990 census, Texas gained 3 new congressional seats. To create a new majority Hispanic seat in Houston, some Hispanic voters were moved from the 18th district and put into the new 29th district, which fitted together like a jigsaw puzzle. The once compact inner-city 18th now stretched from the Intercontinental Airport in the north to the Astrodome in the south, resembling a broken window with 4 jagged corners. Blum lost the election by 30 points. 6 months later, he read about the Shaw v. Reno case in the New York Times. I thought that if there was a good case in North Carolina, there very well may be a good case in Texas, he said. He recruited 6 other plaintiffs, including a retired high school government teacher named Al Vera, to challenge 3 majority-minority districts in Houston and Dallas, including the 18th, as unconstitutional racial gerrymanders. He paid a lawyer from Monroe, Louisiana, $7,000 a month from his own pocket to represent them. Our guiding philosophy is that you cannot segregate America in order to integrate Congress, Blum said. He used the tactics of civil rights lawyers to challenge civil rights orthodoxy, modeling his new organization after the LDF and MALDEF, which he called the Campaign for a Colorblind America Legal Defense and Educational Foundation. A three-judge district court in Texas, made up of Reagan and Bush appointees, ruled in his favor. The challenged districts bear the odious imprint of racial apartheid, wrote Judge Edith Jones, borrowing Justice O'Connor's infamous language from the Shaw decision. The case, Bush v. Vera, went all the way to the Supreme Court, where O'Connor once again wrote a contentious 5-4 decision upholding the lower court's finding that the district's shapes are unexplainable on grounds other than race, and as such are the product of presumptively unconstitutional racial gerrymandering. Blum attracted high-profile new allies in the conservative legal establishment. Clint Ballot filed an amicus brief on his behalf. Thernstrom praised the decision as a victory for those who favor a colorblind society. The districts were redrawn to become more compact and racially diverse. Blum had found his moral cause. He filed similar lawsuits attacking majority-minority districts in Florida, New York, South Carolina, and Virginia. I didn't really have much fear that Congress would become all white again in the Deep South, he said. In 1997, he underwrote a referendum to end Houston's minority contracting program, which set voluntary goals for minority and women-owned businesses. Houston became the first city to challenge affirmative action following the passage of Proposition 209 in California, a landmark 1996 ballot initiative barring the consideration of race or ethnicity in state government hiring and public university admissions. The polarizing issue brought national attention to Houston. In my judgment, were such a thing to pass at Houston's mayor Bob Lanier, it would send a chilling shock through this diverse community. Blum's hardball tactics, including releasing photos of the homes of black contractors to the media, sparked an unprecedented backlash among black voters, who turned out in record numbers to defeat the ballot initiative and elect Lee Brown, the former chief of police in Houston and drug czar under Bill Clinton, as the city's first black mayor. After the election, Payne Weber asked Blum to end his anti-affirmative action efforts. He resigned in protest. Thernstrom defended him in the New York Times. We're supposed to be having a national conversation on race, and his views fall within the parameter of that discussion, she told the paper. You don't want a society in which people feel intimidated or that their jobs are on the line because of their political views. Blum became a folk hero to critics of racial preferences. Let 1,000 Blums bloom, the New York Post proclaimed. He moved to Washington and became a fellow at the American Enterprise Institute. In 2005, he and Thernstrom co-founded the Project on Fair Representation to lobby against the VRA's reauthorization. They fired the first shot in a Wall Street Journal op-ed on July 15, 2005. Draconian federal intrusion into local elections was justified when it was the only way to enfranchise Southern blacks. But 40 years on, it's an unconstitutional travesty, they wrote. The message was simple. The times had changed, but the VRA had not. They focused their opposition on Section 5, based on their belief that the Department of Justice was forcing states to draw misshapen majority-minority districts to comply with the law. The justification for creating these bizarrely shaped bug-splat districts was that Section 5 of the Voting Rights Act required it, Blum said. If Section 5 was creating this mischief, then Section 5 needed to be updated or struck down. Blum and Thernstrom became a ubiquitous couple. They appeared on panels sponsored by the Federalist Society and the U.S. Civil Rights Commission, and wrote frequently for conservative publications like the Wall Street Journal and the National Review. A study they commissioned on the increase in minority voting power in the South circulated widely on Capitol Hill. Blum testified before the House, and Thernstrom testified twice before the Senate. Bull Connor is dead, Blum told the House Subcommittee on the Constitution, and so is every Jim Crow-era segregationist intent on keeping blacks from the polls. Two Republican representatives from Georgia, Lynn Westmoreland and Charlie Norwood, became Blum and Thernstrom's chief advocates in Congress. Norwood, a dentist from Augusta, entered the House in 1994 as a close ally of Newt Gingrich's. Westmoreland, a conservative Republican from suburban Atlanta who ran his family's construction business before entering politics, joined the House in 2005 and became best known for sponsoring a bill to place the Ten Commandments in Congress. During the VRA debate, Westmoreland played the role of Strom Thurmond. The pre-clearance portions of the Voting Rights Act should apply to all states or no states, he argued. Singling out certain states for special scrutiny no longer makes sense. The opponents of Section 5 found common cause with outspoken critics of illegal immigration, like the Iowa Congressman Steve King, who wanted to end the VRA's protections for language minority voters. Shortly after the new legislation was introduced with much fanfare in Congress, Westmoreland and his allies led a revolt during a meeting of the House Republican caucus, chanting, "Pull the bill! Pull the bill!" The House Majority Leader, John Boehner, who hoped to schedule a quick vote before Memorial Day, postponed consideration of the bill indefinitely. Watt and Sensenbrenner saw the resistance coming. "We knew, coming into the first reauthorization in 24 years, that the argument would be made that the South had changed and that Section 5 was no longer necessary and/or it was an unconstitutional federal encroachment on what has traditionally been the prerogative of the state," Sensenbrenner said. "That's why we held extensive hearings and compiled 12,000 pages of testimony." Beginning in October 2005, the House and Senate held the first of 21 hearings on the VRA, the most since 1965. Both sides conceded that dramatic progress had occurred since 1965. The percentage of black registered voters in the South had more than doubled, from 31% to 73%. The number of black elected officials had skyrocketed from fewer than 500 nationwide in 1965 to 10,500 by 2005. The number of black members of Congress had increased from 5 to 43. Opponents of the VRA, like Bloom and Thernstrom, saw this as evidence that the temporary provisions of the VRA were no longer necessary. Supporters of the VRA, while acknowledging the extraordinary gains, highlighted ongoing instances of voting discrimination, from Georgia's voter ID law to Texas's mid-decade redistricting plan to lesser-known voting changes blocked by Section 5. In fact, the Attorney General had objected to more discriminatory voting changes from 1982 to 2004 than between 1965 and 1982. To break the legislative logjam, the House leadership allowed the Republican dissidents to offer 4 amendments during the floor debate. It was necessary to allow them to offer their amendments, Watt said, and it was necessary to defeat them resoundingly. "This rewrite is outdated, unfair, and unconstitutional," Westmoreland declared on the House floor on July 13, 2006, during the final debate on the VRA. It is true, when the Voting Rights Act was first passed in 1965, Georgia needed federal intervention to correct decades of discrimination. Now, 41 years later, Georgia's record on voter equality can stand up against any other state in the Union. To reinforce his point, Westmoreland boldly quoted John Lewis. Under oath in federal court 5 years ago, Congressman Lewis testified, "There has been a transformation. It's a different state. It's a different political climate. It's a different political environment. It's altogether a different world we live in. We've come a great distance. It's not just in Georgia, but in the American South. I think people are preparing to lay down the burden of race." "Will my colleague from Georgia yield?" Lewis asked across the chamber. "I will not yield any time," Westmoreland responded defiantly. "The House is voting today to keep my state in the penalty box for 25 years based on the actions of the people who are now dead." When Westmoreland finished, Lewis rose to defend himself. "It is true that years ago I said that we are in the process of laying down the burden of race," he said, pointing at Westmoreland, "but it is not down yet, and we are not asleep yet. The Voting Rights Act was good and necessary in 1965, and it is still good and necessary today, so don't misquote me. Don't take my words out of context." An hour later, Lewis returned to the House floor to make his closing argument. "We cannot separate the debate today from our history and the past we have traveled," he said, holding a large black-and-white photo of himself crossing the Edmund Pettus Bridge with Hosea Williams on March 7, 1965. "When we marched from Selma to Montgomery in 1965, it was dangerous. It was a matter of life and death. Sensenbrenner and Watt did the hard work behind the scenes, but Lewis became the public face of the VRA's reauthorization. No one could match the moral force of his testimony." He showed another blown-up image of himself lying on the bridge, preparing to take a blow to the head from an Alabama state trooper. "We must pass this act without any amendment," he said passionately, holding the photo in his right hand. It is the right thing to do, not just for us, but for generations yet unborn. He pounded his left fist on the lectern for emphasis. When historians pick up their pens and write about this period, let it be said that those of us in the Congress in 2006, we did the right thing, and our forefathers and our foremothers would be very proud of us. Sensenbrenner spoke after Lewis. We need the Voting Rights Act, he said, because in the last 25 years the covered jurisdictions have not come clean. Sensenbrenner rattled off the number of DOJ objections to discriminatory voting changes since 1982. 91 in Georgia, 105 in Texas, 112 in Mississippi, 96 in Louisiana, 73 in South Carolina, 46 in Alabama, 45 in North Carolina. Now I think these figures ought to make it very clear that we need this bill, he said. In a theatrical flourish, he took bound copies of the 12,000 pages of House committee hearings out of a cardboard box and tossed them on the table in front of him. Landing with a loud thump, the pages slid off onto the House floor. It is one of the most extensive considerations of any piece of legislation that the United States Congress has dealt with in the 27.5 years that I have been honored to serve as a member of this body, he said. Representative Norwood offered the first of 4 amendments, basing the Section 5 coverage formula on data from the last 3 presidential elections rather than from the 1964, 1968, and 1972 elections. That sounded appealing in theory, but in practice the only state fully covered under Norwood's proposal would have been Hawaii. The amendment not only guts the bill, but turns the Voting Rights Act into a farce, Sensenbrenner responded. The amendment was defeated 318 to 96. Representative Louis Gohmert of Texas offered an amendment to reauthorize the VRA for 10 years instead of 25. It went down 288 to 134. Representative Steve King introduced an amendment to end the VRA's language minority protections. It failed 238 to 185. Westmoreland offered the last amendment to require that the DOJ's voting section review all 900 jurisdictions subject to Section 5 within 3 years to see if they deserve to be released from federal oversight. He noted that his proposal had the support of liberal law professors like Rick Hasson of UC Irvine. This amendment expands federal authority by people who have been complaining about federal authority since the Voting Rights Act was passed 41 years ago, Sensenbrenner replied. Let's not turn the VRA on its head. It was defeated 302 to 118. After 7 hours of debate, the House passed the final bill by an overwhelming vote of 390 to 33, a nearly identical margin to 1982. A week later, the Senate passed the House bill by a resounding vote of 98-0. Ted Kennedy invited Lewis to be his guest on the Senate floor for the final passage. They celebrated in the ornate President's Room, where LBJ had signed the VRA 41 years earlier. This is a historic day, Lewis said. As in 1970, 1975, and 1982, opponents of the VRA on and off the Hill had failed to shatter the bipartisan consensus for the law in Congress. The title of the act alone, containing the names of Fannie Lou Hamer, Rosa Parks, and Coretta Scott King, was politically intimidating, clearly the inspiration of a marketing genius, Thernstrom wrote afterward. For Republicans, uncritical support for the Voting Rights Act has become a way to prove the GOP's race credibility, lamented the National Review's John Miller, who had written the blueprint for the Bush administration's takeover of the Civil Rights Division. Miller's article ignored the good faith efforts of Republicans like Sensenbrenner, but there was some truth to what he was saying. The Bush administration endorsed the law's renewal because it believed that opposing the VRA would damage the Republican Party, especially given the GOP's dismal standing with black voters following Hurricane Katrina and with the midterm elections upcoming. The Bush Justice Department had actively subverted the law and prevented lawyers from working on its renewal, but Brad Schlossman testified in favor of the VRA extension on the orders of the White House. The law's long-standing popularity meant that opponents had to tread carefully. That was why Republicans on the Senate Judiciary Committee bizarrely published a report criticizing the legislation only after they all were on record voting for it. A week after Congress passed the bill, Bush signed it on the South Lawn, surrounded by members of the Hamer, Parks, and King families. The first black mayor of Selma, James Perkins, traveled to Washington for the occasion. Sensenbrenner stood directly behind the president. Despite the prior actions of his administration, the president proclaimed himself a staunch supporter of voting rights. Today we renew a bill that helped bring a community on the margins into the life of American democracy, he said. My administration will vigorously enforce the provisions of this law, and we will defend it in court. The last part of Bush's statement was more prescient than he knew. 8 days after the signing ceremony, Blum filed a case from Texas challenging the constitutionality of Section 5. We needed 218 votes in the House, Westmoreland said, but we'll only need 5 votes on the Supreme Court. 9. Old poison, new bottles. Barack Obama held the final rally of his campaign on the night before the 2008 election in Manassas, Virginia, the site of the first major battle of the Civil War. At 10:30 p.m., he strode on stage at the Prince William County Fairgrounds and saw a sea of 90,000 supporters, black and white, young and old. At the top of the hill, the words, "Vote for Change," shone in bright white letters. What a scene, Obama said. What a crowd. Thank you, Virginia. It was an improbable setting for an improbable campaign. In 1965, only 438 blacks, fewer than 20% of eligible African-American voters, were registered to vote in Prince William County. Virginia hadn't voted for a Democratic presidential candidate since LBJ in 1964. The last time so many people had gathered in Manassas, other than to attend the county fair, had been in August 1862, when Robert E. Lee's Confederate forces routed the Union in the Second Battle of Bull Run. Obama had spent the day campaigning in Jacksonville, Florida, and Charlotte, North Carolina, before arriving in Virginia, targeting 3 southern states where he more than likely would not have been able to vote in 1965, and where his parents could not have married. Tomorrow, at this defining moment in history, you can give this country the change that we need, Obama said. It starts here in Virginia. It starts here in Manassas. This is where change begins. John Lewis couldn't sleep that night. He was up at 4 a.m. and at the polls by 7:15. He shook hands with every one of the 200 voters in line early at Westlake High School in southwestern Atlanta. Historic day, he kept repeating. As a young civil rights activist, Lewis never imagined he would live to see the day when a black man could be elected president. An African-American president wasn't even part of my dream back then, he said. I just wanted black people to vote so we could elect more progressive whites. If someone had told me I was going to be in this position in my lifetime, I would have said, "What have you been drinking or smoking?" Lewis and Obama bonded early. Lewis invited the Illinois senator to give the keynote speech at his 65th birthday party in Atlanta in 2005 and predicted he would one day be president. Lewis had initially endorsed Hillary Clinton on the basis of his longtime friendship with the Clintons, but changed his allegiance after Obama decisively won Georgia's Democratic primary. I think the candidacy of Senator Obama represents the beginning of a new movement in American political history, he said, and I want to be on the side of the people, on the side of the spirit of history. Lewis spent election night with Andrew Young and the King family at MLK's Ebenezer Baptist Church in Atlanta. 2,000 people packed the historic church, watching the returns on 2 giant video screens. Lewis grew emotional when he took the pulpit, reflecting on all he had been through to reach this moment. It is an unbelievable night, he said. It is a night of Thanksgiving. At 11 p.m., when the networks called the election for Obama, the church erupted in delirious celebration. Lewis jumped in the air and yelled, "Thank God! Hallelujah! Hallelujah!" Ebenezer's pastor, the Reverend Raphael Warnock, asked the audience to clap hands and recite, "Lift every voice and sing." "Sisters and brothers, it looks like we have moved from Bloody Sunday to Triumphant Tuesday," Warnock said. Watching the celebration in Chicago's Grant Park, Lewis said, "The struggle, the suffering, the pain, and everything we try to do to create a more perfect union, it was worth it." The 2008 electorate was the most diverse in American history. Of the 5 million new voters in 2008, 2 million were black, 2 million were Hispanic, and 600,000 were Asian. Obama lost white voters to John McCain by 12 points, but won 75% of the combined black, Hispanic, and Asian vote, which increased by 4 points over 2004. Ronald Brownstein of the National Journal dubbed Obama's base of minorities, young voters, women, and college-educated whites the coalition of the ascendant. These electoral changes were particularly dramatic in the South. Not only did Obama carry the 3 southern states where he had campaigned the day before the election, but the biggest increases in voter turnout occurred in Georgia, North Carolina, Louisiana, Mississippi, and Virginia. Unexpected changes were happening across Dixie. 6 months after Obama's election, James Young became the first black mayor of Philadelphia, Mississippi. The 53-year-old Pentecostal minister defeated a 3-term white incumbent by 46 votes in a town that was 56% white. Young was 9 when Cheney, Goodman, and Schwerner were murdered in Philadelphia. He remembered his father sitting in the living room with a gun at night. Young had been the first black student to integrate his 6th grade class a few years later. He became an EMT, working the grounds at the Neshoba County Fair when Ronald Reagan spoke, and a county supervisor before deciding to run for mayor in August 2008, inspired by the Obama campaign. Obama's election sent a message to our people that it was possible, he said. If we can elect a black man as president, we can elect a black man as mayor of Philadelphia. The 44th anniversary of Bloody Sunday, in the wake of Obama's election, was a joyous occasion in Selma. Because of what you did, we got the Voting Rights Act in 1965, Lewis told an overflow crowd at Brown Chapel. Because of what you did, Barack Obama is President of the United States. 2 years earlier, Obama had spoken at the same church and marched across the Edmund Pettus Bridge with Lewis. Don't tell me I don't have a claim on Selma, Alabama, Obama said. Don't tell me I'm not coming home when I come to Selma, Alabama. I'm here because somebody marched. I'm here because you all sacrificed for me. I stand on the shoulders of giants. The featured speaker at the celebration in 2009 was Eric Holder, the first black attorney general. Holder sat next to Lewis, whom he called one of my personal heroes. Peggy Wallace Kennedy, the daughter of George Wallace, introduced the attorney general. It was an unlikely meeting, given the histories of the Holder and Wallace families. Holder's late sister-in-law, Vivian Malone of Mobile, had been one of the first 2 African-American students to enroll at the University of Alabama. In June 1963, Wallace personally blocked her entry to the university. President Kennedy dispatched Nick Katzenbach to tell Wallace to step aside. After a heated, nationally televised standoff, Kennedy federalized the Alabama National Guard to escort Malone into the school. She became the first African-American graduate of the university. She later worked in the DOJ's Civil Rights Division and became director of the Voter Education Project after Lewis. I so wish Vivian had lived to see this moment, Holder said. He hung a portrait of Katzenbach in his office and one of Bobby Kennedy in his conference room. Peggy Wallace Kennedy told her own story of those turbulent years. Watching from behind the gates of the Alabama governor's mansion, I knew in my heart that their cause was just. But unlike them, I did not let my voice be heard, she said. For many years I wandered in the world of indifference until I heard the voice of Barack Obama. He inspired me to believe in myself and to join the millions of others who laid claim once again to faith and pride in America. She introduced Holder with tears in her eyes. The world that existed on Bloody Sunday is all but unrecognizable to us now, Holder said. We are all the beneficiaries of Selma. I am a beneficiary of Selma. The Attorney General had grown up far from Selma, the son of immigrants from Barbados, who settled in the diverse neighborhood of East Elmhurst, Queens, where his neighbors included Louis Armstrong, Dizzy Gillespie, Willie Mays, and Malcolm X. After graduating from Columbia University Law School, Holder found his first job at the LDF. He then rose through the ranks of the DOJ, becoming Deputy Attorney General during the Clinton administration. He called the Civil Rights Division the crown jewel of the Justice Department and planned to make restoring its credibility one of his top priorities. Under my leadership and all that it does, the Civil Rights Division will reflect the spirit of the movement that inspired its creation, he said in Selma. Following his speech, Holder, Wallace, and Lewis locked arms and sang, "We Shall Overcome." In one snapshot, there it was, Civil Rights in America from 1955 to 2009, reported NPR's Nina Totenberg. That day, Holder touted the historic progress that had been made, but warned against complacency in the long fight for civil rights. We stand closer to the dream of Dr. King than ever before, but we've got to keep marching, he said. Some take a view that when it comes to civil rights we have already reached the promised land, but we know better. And some take a view that justice and equality have been achieved for all Americans, but I know better. In particular, longtime critics of the VRA argued that Obama's ascendance signified that constitutional protections for previously disenfranchised minority groups were no longer necessary. It says that the road we started down in 1965 with the Voting Rights Act has come to an end, Abigail Thernstrom told the New York Times in August 2008. We don't need to talk about disenfranchisement in the same way anymore. She called Obama's election victory in the voting rights battle. 2 months after Obama's election, the Supreme Court agreed to hear a challenge to Section 5 of the VRA brought by Ed Blum. We must commit ourselves to continuing to defend the Voting Rights Act, which is under attack, Holder said. Chief Justice Rehnquist died on September 3, 2005, at the age of 80. John Roberts was one of 8 pallbearers at his funeral. 2 days after Rehnquist's death, Bush nominated Roberts to succeed his former boss as Chief Justice. The White House released 15,000 pages of records documenting Roberts' tenure in the Reagan administration, which revealed his extensive efforts to limit the scope of the VRA in the early 1980s. Lewis testified before the Senate Judiciary Committee against Roberts' nomination. Judge Roberts' memos reveal him to be hostile toward civil rights, affirmative action, and the Voting Rights Act, Lewis said. He cited a memo in which Roberts wrote that violations of the VRA should not be made too easy to prove. Had Judge Roberts' narrow reading of the Voting Rights Act prevailed, fewer people of color would be serving in Congress and at both the state and local level today, Lewis continued. We cannot afford to elevate an individual to such a powerful lifetime position whose record demonstrates such a strong desire to reverse the hard-won civil rights gains that so many of us sacrificed so much to achieve. Roberts, Lewis concluded, was on the wrong side of history. Members of the Judiciary Committee pressed Roberts to explain his current views on the VRA. I'm deeply troubled by a narrow and cramped and perhaps even a mean-spirited view of the law that appears in some of your writings, Senator Kennedy told him. It appears that you did not fully appreciate the problem of discrimination in our society. It also seems that you were trying to undo the progress that so many people had fought for and died for in this country. Kennedy asked him, You do agree, don't you, Judge Roberts, that the right to vote is a fundamental constitutional right? It is preservative, I think, of all the other rights, Roberts responded. Without access to the ballot box, people are not in a position to protect any other rights that are important to them. I'm just trying to find out on the Voting Rights Act whether you have any problem at all, and trouble at all in terms of the constitutionality of the existing Voting Rights Act that was extended by the Congress, Kennedy asked. The existing Voting Rights Act, the constitutionality has been upheld, and I don't have any issue with that, Roberts answered. Will you, on the court, fairly apply the Voting Rights Act? The Iowa Senator Charles Grassley followed up. Any issues that come before me under the Voting Rights Act, I will confront those with an open mind and decide them after full and fair consideration of the arguments in light of the precedents of the court and in light of a recognition of the critical role that the right to vote plays as preservative of all other rights, Roberts responded. The nominee told the Senate, I come before the committee with no agenda. I have no platform. He used a baseball analogy to describe his judicial philosophy. Judges are like umpires, he said. Umpires don't make the rules, they apply them. The role of an umpire and a judge is critical. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. The Senate confirmed Roberts 78-22. They had faith that he would continue to do the right thing, Lewis said. But it soon became clear that the Chief Justice's views on voting rights hadn't moderated since the Reagan years. In 2002, Don Zimmerman, a libertarian Ron Paul supporter, won election to the local utility board in an upscale suburb of Austin. When Zimmerman wanted to move the utilities polling place from a neighbor's garage to a nearby school, he had to receive approval from the federal government under Section 5, which covered all voting changes in Texas. Zimmerman complained to Greg Coleman, a former clerk for Clarence Thomas. Coleman contacted Blum, who was looking for a jurisdiction to challenge the 2006 reauthorization of the VRA. Coleman represented the utility, and Blum's Project on Fair Representation paid the legal bills. After the VRA's reauthorization, Blum stopped working with Thernstrom and focused exclusively on challenging the law through the courts, getting funding from a consortium of influential conservative funders called Donors Trust. The utilities' brief called Section 5 an unconstitutional overextension of Congress's enforcement power to remedy past violations of the 15th Amendment. Blum lost in the lower courts and appealed to the Supreme Court, which heard oral arguments in Northwest Austin Municipal Utility District No. 1 v. Holder, Namudno, 100 days after Obama's inauguration. Chief Justice Roberts said almost nothing during the first 30 minutes of the trial when Coleman spoke for the plaintiffs. But he interrupted the Obama administration's Deputy Solicitor General, Neil Katyal, a former National Security Advisor to Holder, within a minute. Roberts: Here, as I understand it, 1/20th of 1% of the submissions from states to the DOJ are not pre-cleared. That, to me, suggests that they are sweeping far more broadly than they need to address the intentional discrimination under the 15th Amendment. Katyal: I disagree with that, Mr. Chief Justice. I think what that represents is that Section 5 is actually working very well, that it provides a deterrent. Roberts: Well, that's like the old elephant whistle. I have this whistle to keep away the elephants. Well, there are no elephants, so it must work. Katyal: I agree that if we were just standing up with no record whatsoever, that's one thing. But Congress heard testimony. They found example after example of voting discrimination. 5 minutes later, Roberts again interrupted Katyal as he spoke about modern-day voting discrimination in Texas. Roberts: Well, let me focus on that historical aspect. Obviously, no one doubts the history here, and that the history was different between states. But at what point does that history stop justifying action with respect to some jurisdictions, but not with respect to others that show greater disparities? Katyal: Congress has said that the court should be particularly worried about trying to predict the future and say that discrimination is now over. Roberts: Well, so your answer is that Congress can impose this disparate treatment forever because of the history in the South? Katyal: Absolutely not. Roberts: When do they have to stop? Katyal: Well, Congress here said 25 years was the appropriate reauthorization period. Roberts: Well, they said 5 years originally and then another 20 years. I mean, at some point it begins to look like the idea is that this is going to go on forever. Roberts sounded far more like an aggressive player than an umpire simply calling balls and strikes. In a case on school integration in Seattle and Louisville a few years earlier, he'd succinctly described his colorblind views on race, writing in the last sentence of his opinion, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." John Lewis, on his first visit to the court since Bush v. Gore, listened anxiously to the oral arguments. "It reminded me of some of the same debate of 1965, he said after. "This act is one of the most progressive pieces of legislation the country ever passed, and it changed America forever. We don't need to go back." His testimony against Roberts now sounded prescient. On the basis of Roberts' questioning, many legal experts expected the court to overrule Congress's overwhelming judgment and strike down Section 5, which would have been unthinkable before Roberts and Samuel Alito, his peer in the Reagan administration, joined the court. Jeffrey Rosen of the New Republic reported that the 4 liberal justices threatened to write a strong dissent that would have accused the majority of misconstruing landmark precedents about congressional power. Roberts, or Justice Anthony Kennedy, the swing vote, got cold feet, and the court eventually punted, exempting the utility from Section 5 oversight, known as a bailout, without resolving the larger constitutional questions. But in a hopeful sign for the plaintiffs, the conservative majority expressed strong skepticism about the continued relevance of Section 5. The historic accomplishments of the Voting Rights Act are undeniable, but the Act now raises serious constitutional concerns, Roberts wrote for the 8-1 majority. The Act imposes current burdens and must be justified by current needs. The Act also differentiates between the states in ways that may no longer be justified. Bloom called the decision an excellent first chop on the log. During the 2000 congressional debate, few Republicans publicly challenged the VRA, and no other jurisdiction covered by Section 5 joined the Namudno lawsuit. The court's opinion emboldened many in the Republican Party to feel more comfortable criticizing Section 5, Bloom said. Roberts' words guaranteed that there would be another challenge to the VRA very soon. Namudno wasn't the first major voting rights case to come before the Roberts Court. 6 days after Obama's surprise victory in the Iowa caucus, the court heard a challenge to Indiana's voter ID law, which had passed at the same time as Georgia's in 2005, brought by the state representative Bill Crawford, Democrat of Indianapolis, the longest-serving black state lawmaker in the country. Indiana's voter ID law was the first of its kind to reach the Supreme Court. Georgia's law was initially blocked by a federal court as a poll tax, then approved after the legislature passed a revised bill providing for a free voter ID. Crawford's brief called the law a severe burden on the fundamental right to vote, particularly for poor, elderly, disabled, and minority voters who lacked the government-issued IDs required to cast a ballot. A 2006 study by the Brennan Center for Justice found that up to 11% of U.S. citizens, 21 million eligible voters, did not have government-issued photo IDs. They included 25% of African Americans, 18% of seniors 65 and over, and 15% of those making less than $35,000 a year. Let's not beat around the bush, wrote Judge Terrence Evans of the Seventh Circuit Court of Appeals. The Indiana voter photo ID law is a not too thinly veiled attempt to discourage Election Day turnout by certain folks believed to skew Democratic. Indiana called its law an eminently reasonable effort to combat in-person voter fraud. The Supreme Court sided with the state. Writing for a 6-3 majority, Justice John Paul Stevens said Indiana had a legitimate interest in deterring and detecting voter fraud and protecting public confidence in elections. He did concede that the record contains no evidence that the fraud the law addresses, in-person voter impersonation at polling places, has actually occurred in Indiana. The only example of voter impersonation cited by Stevens stretched back to New York City in 1868, when operatives for Boss Tweed allegedly paid people to vote multiple times by altering their facial hair. The absence of any recent evidence of voter impersonation led Justices Souter, Breyer, and Ginsburg to dissent. The state responds to the want of evidence with the assertion that in-person voter impersonation frauds is hard to detect, Souter wrote. But this is like saying the man who wasn't there is hard to spot. Just as Namudno encouraged new challenges to the VRA, so the Crawford decision signaled that states could implement new voting restrictions merely by invoking the threat of voter fraud, even if such fraud had not actually occurred. Taken together, the two cases set a chilling precedent for voting rights in the Obama era. The state representative, Debbie Riddle, a horse breeder and a grandmother of 10 from suburban Houston, arrived at the empty Texas Capitol 2 days before the beginning of the 2011 legislative session. She camped out on the cold floor so that she could be the first lawmaker in line to file a new voter ID bill. Riddle had a penchant for attracting controversy. She once said that public education comes from Moscow, from Russia. It comes straight out of the pit of hell. In an interview with CNN, she claimed that pregnant Middle Eastern women were coming to the United States to deliver babies with the nefarious purpose of turning them into little terrorists who will then come back to the U.S. and do us harm. Texas Monthly gave her its Joseph McCarthy Have You No Sense of Decency award. Riddle's bill was one of 10 voter ID measures introduced in the Texas legislature in the 2011 session. Texas's Governor, Rick Perry, declared the voter ID bill an emergency item, which meant it could pass in the first 60 days of the new legislative session. He predicted the legislation would be approved so fast it'll make your head spin. When asked for an example of voter fraud to support her new bill, Riddle said she'd once seen a Latina woman at her polling place who couldn't speak English and needed assistance. She was not only limited in English, she really didn't know any English, Riddle said. Even though the VRA provided help for language minority voters in Texas, Riddle was perplexed how anyone could come in and attempt to vote and have just a complete disconnect of the entire process. In addition to voter ID, Riddle introduced legislation modeled after Arizona's toughest-in-the-nation anti-immigration law, which the Department of Justice denounced as racial profiling. The changing demographics of Texas and the push for voter ID went hand in hand. Texas Republicans had begun pushing for voter ID in 2005, after the census declared Texas the country's fourth majority-minority state, with blacks, Hispanics, Asians, and other minorities narrowly overtaking whites. Democrats in the Texas Senate needed a third of the body to block the bill, but were missing a crucial vote. Senator Mario Gallegos, the first Hispanic state senator from Houston, was recovering at home from a liver transplant that his body was rejecting. When Texas Republicans scheduled a hasty vote on the bill, Gallegos rushed back to Austin against the advice of his doctors. "If not for voter ID, I wouldn't be here. That's how serious the issue is for me," Gallegos said. When Gallegos returned, another Democratic senator, Carlos Uresti of San Antonio, was in bed with a nasty flu. Uresti received a call that he was needed immediately on the Senate floor to vote against the voter ID bill. He sprinted up the steps of the Capitol, arriving moments before his name was called. He voted no, then promptly vomited in the Senate lounge. After the legislature failed to pass the voter ID bill in 2005, the Texas Attorney General, Greg Abbott, announced a major investigation into voter fraud the following year, much as the Bush administration had done in Washington. In Texas, an epidemic of voter fraud is harming the electoral process, and it's time we rooted it out, he declared. His targets were people like Willie Ray, a 69-year-old black city councilwoman in Texarkana, and her granddaughter, Jamila, who were charged with voter fraud for mailing absentee ballots on behalf of homebound elderly voters. They had violated an obscure Texas law mandating that the addresses of those mailing the ballots be included on the envelope, which Ray forgot to do. A lot of blood has been shed for the rights of people to vote, Ray said after pleading guilty to a misdemeanor. I just hope those rights are not taken away or people are frightened so bad they won't vote. Abbott's critics pointed out that of the 22 cases of election fraud prosecuted by his office over a 6-year period, none would have been stopped by a voter ID law. His investigation also had disturbing partisan and racial overtones. All of Abbott's prosecutions involved Democrats, primarily Latinos and African Americans. A PowerPoint presentation developed by his office to educate local officials about voter fraud showed a slide of black voters standing in line to vote. Another slide showed a sickle cell anemia postage stamp featuring a black woman holding a baby. None of the 71 slides included any white voters, suggesting that voter fraud was something that only Democrats of color did. Voter fraud fears went national in 2008. Republicans ratcheted up attacks on Acorn that had begun during the Bush administration, seizing on evidence that Acorn employees had registered fictitious voters like Mickey Mouse. Acorn canvassers in states like Nevada, who made $8 an hour, earned a bonus for submitting more than 21 new voter registration names a day, so they sometimes submitted fake names to make extra money. There was no evidence that Mickey Mouse had actually voted. Under HAVA, new registrants had to provide some type of proof of identity, be it a driver's license, utility bill, or bank statement. But that didn't stop John McCain from alleging in his final debate with Obama that Acorn is now on the verge of maybe perpetrating one of the greatest frauds in voter history. After the 2008 election, one poll found that 52% of Republicans believed that Acorn had stolen the election for Obama. The Republican fixation with voter fraud became a new Southern strategy, the Rutgers University political science professor Laurie Minnitt wrote in her book, The Myth of Voter Fraud. The reddest base of the Republican Party has been energized by the tarring of Democrats as cheaters and the association of Democrats with a radicalized, crime-prone underclass. The relentless focus on Acorn and voter fraud, combined with major GOP gains in the 2010 election, significantly boosted the prospects for passing new voter restrictions, including voter ID in Texas. Republicans picked up 21 seats in the Texas House, giving them a huge majority, and Lieutenant Governor David Dewhurst quickly eliminated the requirement that the bill needed 2/3 support in the Senate, preventing Democrats from filibustering it again. As Texas became increasingly diverse, the GOP caucus grew whiter and more conservative. Of the 120 Republican members of the Texas legislature, there were only 5 Hispanics, 1 Asian, and no African Americans. Democrats, by contrast, had 11 whites, 17 blacks, 32 Hispanics, and 2 Asians in their caucus. This stark racial contrast helped explain the party's radically different views on voter ID. The voter ID bill introduced in 2011, the 4th time the legislature had tried to pass the measure, was significantly tougher than the legislation debated in prior sessions or the laws adopted by Georgia and Indiana. Whereas Riddle's bill required one form of government-issued ID or 2 types of non-photo ID to cast a ballot, legislation brought to the floor by Senator Troy Fraser, a childhood friend of Governor Perry's, allowed only 5 forms of government-issued ID to vote: a driver's license, a personal ID card issued by the Department of Public Safety, a U.S. military ID card, a U.S. passport, and a U.S. citizenship certificate. Unlike Indiana's and Georgia's laws, Texas's bill did not allow student IDs or expired driver's licenses. The Texas legislature did, however, adopt an amendment adding a concealed handgun permit to the list of accepted voter IDs. As in Georgia, Fraser's bill did not require voter IDs for absentee ballots, which Republicans used more frequently than Democrats, and which was the form of voting by which voter fraud was far and away most likely to occur. Abbott's investigation turned up no instances of voter impersonation, but more than half of his prosecutions involved absentee ballot fraud. During the House debate, Representative Rafael Anchia, a Hispanic Democrat from Dallas, aggressively quizzed the bill's sponsor, Representative Patricia Harless, about the purpose of the bill. Anchia was a rising star in Texas politics whom the press dubbed El Gobernador and the Hispanic Obama. He represented a district that was nearly three-fourths Hispanic, where a quarter of his constituents lived below the poverty line. Harless, a conservative evangelical Christian and member of the Texas Tea Party caucus, ran a used car dealership with her husband in suburban Houston. Anchia, describe how voter impersonation works. Harless, someone shows up to the poll with a voter's registration card that may not be theirs and casts a vote with that card. Anchia, how often does that happen in the state of Texas, do you think? Harless, I'm not advised. Anchia, why does the bill ignore mail-in ballots? Harless, this bill is only addressing one type of voter fraud, in-person voter fraud. Anchia, but that's really interesting to me because we've got a bill that addresses a narrow type of fraud that you even acknowledged you have no cases of. Harless, I did not say I have no cases of. Anchia, give me a case. Harless, I said that they were not part of our testimony. Anchia, so there's no cases on the House floor of impersonation. You are yet very, very concerned about the integrity of elections, correct? Harless, uh-huh. Anchia, yet this bill doesn't deal with the type of voter fraud that we've seen most prevalently in the state of Texas, which is mail-in ballots, correct? Harless, there are other pieces of legislation that... Anchia, have you filed a bill on mail-in ballots? Harless, no, sir. Under sustained questioning from Anchia, Harless admitted this is about restoring confidence in the election process and to get off on the fraud argument of how often it happens or if it even happens. We will never agree on that. We can stay here all day long discussing the fraud, but that is not what this bill is about. This bill is about protecting, deterring, and detecting possible fraud in the elections. The goalpost has moved, Anchia responded in a passionate speech against the bill, because, as the authors pointed out, this is no longer about voter impersonation. This is about the integrity of elections. Really? Do we really believe that? Because if this was about the integrity of elections, then we would clearly be focused on the place where 70% of all the Attorney General's investigations and prosecutions have been, which is in mail-in ballots. Yet this bill specifically ignores mail-in ballots. And my fear is, members, that the way this bill is crafted, it's going to have a disproportionate impact on the poor. It's going to have a disproportionate impact on African Americans and Hispanics. And I hope that this is not what it's about, because we know it's not about voter impersonation. We still don't have one case here on the House floor. And we know it's not about the integrity of elections, because if it was about the integrity of elections, it would be about mail-in ballots. So we know it's not about those things, and I fear, members, that it's about something else, and it's about fewer people voting. 5 months after the Texas legislature convened in Austin, Perry signed Texas's voter ID law, the strictest in the country, at the state capitol. 30 Republican legislators packed the small reception room. This is what democracy is really all about, Perry said. A rare Republican dissent came from Royal Bassett, the former executive director of the Texas Republican Party. Bassett supported voter ID laws until he began taking care of his invalid 91-year-old mother, a registered voter in Austin who did not have a driver's license, a passport, a handgun permit, or any of the documentation required to vote or needed to obtain the correct ID. He accused Texas Republicans of using sheer racism to pump their own political points by attempting to suppress Democratic voters. Anyone who says all legal voters under this bill can vote doesn't know what he is talking about, Bassett wrote on his blog, and anyone who says that a lack of IDs won't discriminate against otherwise legal minority voters is lying. Texas was far from alone in pushing to restrict access to the ballot. In 2011 and 2012, 180 new voting restrictions were introduced in 41 states, with 27 new laws taking effect in 19 states, nearly all of them controlled by Republicans. The right to vote had become deeply politicized. The country hadn't seen anything like it since the end of Reconstruction, when every southern state placed severe limits on the franchise. The election of the first black president and the resurrection of new barriers to the ballot box were not a coincidence. The proposal of restrictive voter access legislation has been substantially more likely to occur where African Americans are concentrated and both minorities and low-income individuals have begun turning out at the polls more frequently, reported a study from the University of Massachusetts, Boston. As minorities grow in the political process, "It's in the interest of one of the parties to tamp down voter turnout," said Millwatt. "It's the same system that other people went through when there were poll taxes and literacy tests. This is just another iteration of that." Before 2010, only Indiana, Georgia, and Missouri had passed strict voter ID laws. 9 states controlled by Republicans adopted them following the 2010 election: Alabama, Kansas, Mississippi, Pennsylvania, South Carolina, Tennessee, Texas, Virginia, and Wisconsin. The accelerated push for voter ID laws didn't emerge from nowhere. In 1980, Paul Weyrich, the tart-tongued first director of the Heritage Foundation, convened a gathering of 15,000 evangelical Christians for Ronald Reagan. Acolytes described Weyrich as the Lenin of social conservatism. He said in his speech, "I don't want everybody to vote. Elections are not won by a majority of people. They never have been from the beginning of our country, and they are not now. As a matter of fact, our leverage in the elections quite candidly goes up as the voting populace goes down." Weyrich was also a key founder of a group called the American Legislative Exchange Council, ALEC, which paired conservative state legislators with large business interests to draft model legislation for states. For many years, ALEC was the most influential organization that no one had ever heard of. In the summer of 2009, ALEC drafted model voter ID legislation based on Indiana's voter ID law. A cover story in ALEC's magazine praised voter ID laws as a strong step toward the prevention of fraud at the polls. The group also launched an initiative called Cracking Acorn, featuring a graphic of a hammer smashing an acorn, which urged states to defund the group. ALEC's Public Safety and Elections Task Force adopted the voter ID measure during a meeting in Atlanta in July 2009. The drafting and discussion were led by 3 conservative state legislators, including the Arizona State Senator Russell Pierce, the author of Arizona's controversial anti-illegal immigration law, which the Supreme Court later struck down. A mix of 50 state legislators, corporations, and conservative advocacy groups, including the NRA, overwhelmingly approved the measure. Of the 62 voter ID bills introduced in 37 states in 2011 and 2012, more than half were sponsored by members of ALEC, including in Texas. The bills were virtually identical. "We're seeing the same legislation being proposed state by state by state," said Heather Smith of Rock the Vote. The new restrictions went well beyond voter ID. They were designed to impede voters at every step of the electoral process, targeting the very methods that the Obama campaign had used so successfully in 2008 to expand the electorate, like intensive voter registration drives and early voting. During the 2008 election, the number of registered voters in the United States increased by 5%, from 177 million to 187 million. In the 29 states that recorded party affiliation, roughly 2/3 of new voters registered as Democrats. Obama won nearly 70% of the country's 15 million first-time voters. GOP-controlled states responded by making voter registration more difficult. Alabama, Kansas, and Tennessee required proof of citizenship to register. Maine repealed Election Day voter registration. Florida and Texas added stringent requirements for third-party registration groups. Florida required that anyone who registered new voters had to hand in the forms to the State Board of Elections within 48 hours and comply with a barrage of onerous bureaucratic requirements. Those who submitted late forms would face a $1,000 fine, as well as possible felony prosecution. The measure was drafted by Bucky Mitchell, the elections official who had overseen Florida's disastrous voter purge in 2000. The law turned civic-minded volunteers like Dawn Quarles, a public school teacher from Pace, Florida, into inadvertent criminals. She was the first person fined by the state for failing to turn in 76 registration forms from her students within 48 hours, even though she hadn't even heard about the new law. "We have the worst voter turnout of any Western democracy, and this is the reason why," Quarles said. The normally mild-mannered League of Women Voters denounced the law as good old-fashioned voter suppression and shut down voter registration drives in the state for the first time in 70 years because its volunteers were unable to comply with the state's stringent requirements. Black and Hispanic citizens in Florida were twice as likely as whites to register through such drives. Florida's registration law took effect one day after it passed, under an emergency statute, as in Texas, designed for an immediate danger to the public health, safety, or welfare. Sponsors of the bill invoked Acorn to justify the law, even though there had been only 31 suspected cases of voter fraud in Florida during the previous 3 years, resulting in 3 arrests statewide. There were more shark attacks in Florida than cases of voter fraud. No one could give me an example of all this fraud they speak about, said Mike Fasano, a Republican state senator who bucked his party and voted against the registration law. In addition to making it harder to register to vote, 5 states, Florida, Georgia, Ohio, Tennessee, and West Virginia, cut short their early voting periods. After the recount debacle in Florida in 2000 and the long lines in Ohio in 2004, allowing voters to cast their ballots before Election Day had emerged as a popular bipartisan reform. I think it's great, Florida's Governor Jeb Bush said in 2004. It's another reform we added that has helped provide access to the polls and provide a convenience. And we're going to have a high voter turnout here, and I think that's wonderful. Early voting was particularly important for lower-income and minority voters who had a harder time taking off work on Election Day and were more likely to vote at under-resourced polling places with fewer poll workers and voting machines, which led to longer lines and more frequent problems. But Republican support for early voting receded after the Obama campaign utilized the reform as a key part of its strategy in 2008. Nearly 30% of the electorate voted early, and those voters favored Obama over McCain by 10 points. The strategy proved especially effective in Florida, where blacks outnumbered whites by 2-1 among early voters, and in Ohio, where Obama received fewer votes than McCain on Election Day, but ended up winning the state because of his advantage among early voters in cities like Cleveland and Columbus. After 2008, early voting was shrunk from 14 to 8 days in Florida and from 35 to 11 days in Ohio. Both states also banned voting on the Sunday before the election, when black churches held Souls to the Polls rallies. In the races I was involved in 2008, when we started seeing the increase of turnout and the turnout operations that the Democrats were doing in early voting, it certainly sent a chill down our spines, said Wayne Birch, a Republican campaign consultant in Florida. Ex-felons who had paid their debt to society also lost their right to vote in Florida and Iowa. Charlie Crist, Florida's Republican governor from 2007 to 2011, had repealed the state's felon disenfranchisement law and restored the voting rights of 154,000 former prisoners who had been convicted of nonviolent crimes. But in March 2011, after only 30 minutes of public debate, Florida's Governor Rick Scott overturned his predecessor's decision, instantly disenfranchising 97,491 ex-felons and prohibiting another 1.1 million prisoners, nearly 20% of African-American voters in Florida, from being allowed to vote after serving their sentences. In record time, Florida's cabinet brought us back to Jim Crow-era laws, the Miami Herald editorialized. In total, the new restrictions made it more difficult for more than 5 million Americans to vote, a larger number than the margin of victory in the 2000 and 2004 presidential elections. States with new voting restrictions accounted for 218 of the 270 electoral votes needed to win the presidency. This new attack on voting rights had an unprecedented breadth and depth. It wasn't just concentrated in the South as during Jim Crow, nor did it target only one segment of the population. Young voters, African Americans, Hispanics, the elderly, and the poor all were impacted by this massive restructuring of the country's voting rules. Since the VRA outlawed literacy tests and poll taxes, states had focused on diluting the power of the growing minority rather than denying access to the ballot. In the decades after 1965, the fight over voting rights had centered on the value of the vote, not on the right to vote itself. But after Obama's election, the climax of decades of struggle to win greater representation, vote denial efforts returned with a vengeance. The high point of the Second Reconstruction spawned a Second Redemption backlash. The new measures were more sophisticated and less obvious than the poll taxes and literacy tests of yesteryear, but they had the same intended effect: to control who could participate in the democratic process and to once again make voting a privilege, not a fundamental right. As the demographics of the country became younger, more diverse, and more progressive, the Republicans who took power after 2010 wanted the electorate to be older, whiter, and more conservative, as it had been in 2010, compared with 2008. Of the 11 states with the highest African-American turnout in 2008, 7 have new restrictions in place, reported the Brennan Center for Justice. Of the 12 states with the largest Hispanic population growth between 2000 and 2009, 9 passed laws making it harder to vote. There has never been, in my lifetime, since we got rid of the poll tax and all the Jim Crow burdens on voting, the determined effort to limit the franchise that we see today, Bill Clinton told a group of student activists in July 2011. Why is all of this going on? This is not rocket science. They are trying to make the 2012 electorate look more like the 2010 electorate than the 2008 electorate. A few unusually candid Republican leaders eventually admitted that fraud wasn't the real issue, race and political power were. The Pennsylvania House Majority Leader told GOP activists that the state's voter ID law would allow Governor Romney to win the state of Pennsylvania. The GOP chairman in Columbus, Ohio, defended cutbacks in early voting hours by telling the Columbus Dispatch, "I guess I really actually feel we shouldn't contort the voting process to accommodate the urban, read African-American, voter turnout machine." The author of South Carolina's voter ID law distributed packets of peanuts to his constituents with cards that read, "Stop Obama's nutty agenda and support voter ID." In February 2011, Obama awarded the Presidential Medal of Freedom to John Lewis. Generations from now, when parents teach their children what is meant by courage, the story of John Lewis will come to mind, the president said. 2 months later, Lewis was honored during the 50th anniversary of the Freedom Rides. Despite these accolades, Lewis did not feel like celebrating that July when he delivered an impassioned speech on the floor of the House of Representatives about the right to vote. "Voting rights are under attack in America," Lewis said, his voice echoing through the nearly empty chamber. "There's a deliberate and systematic attempt to prevent millions of elderly voters, young voters, students, minority and low-income voters from exercising their constitutional right to engage in the democratic process." Much to his dismay, Lewis said, no one seemed to be listening. He pleaded with his friends in the Obama administration to urgently take up the fight. In December 2011, Holder traveled to the LBJ Library in Austin, Texas, to deliver a major speech on voting rights. Before his talk, the Attorney General looked up at a video screen in the library's auditorium and saw a picture of his sister-in-law standing next to Rosa Parks and Martin Luther King as LBJ handed out the pens he'd used to sign the VRA. He'd never known Vivian had been present on that historic day. "I am concerned about some of the legislation that has been passed that recently goes against that arc of history and is tending to restrict, in ways subtle and not so subtle, the ability of the American people to cast their ballots," Holder said. He quoted Lewis's speech from the House floor and warned, "We are failing to live up to one of our nation's most noble and essential ideals." The LBJ Library was a fitting setting for Holder's speech, not just for its history, but because Texas had recently embodied how conservative officials were trying to limit the power of an increasingly diverse electorate. The state's redistricting plan for Congress and the State House initially drew the ire of the Justice Department. Texas gained 4.3 million new residents from 2000 to 2010, and 90% of that growth came from minority residents. Because of the population increase, the state gained 4 congressional seats following the 2010 census. Yet under the redistricting maps drawn by Texas Republicans in 2011, the number of majority-minority districts actually declined from 11 to 10. 3 of the 4 new seats went instead to white Republicans. The League of Women Voters called the plan the most extreme example of racial gerrymandering among all the redistricting proposals passed by lawmakers so far this year. Even though Texas had to clear its election changes with the federal government, the counsel to the state's congressional Republicans referred to key sections of the VRA as hocus pocus. The Justice Department objected to the new maps in fall 2011. 6 months later, the DOJ objected to Texas's voter ID law. Texas's own data showed that between 600,000 and 795,000 registered voters lacked government-issued IDs, and Hispanic voters were anywhere from 46% to 120% more likely than white voters to not have one. The state submitted no information on how many blacks and Asians lacked IDs. Even using the data most favorable to the state, Hispanics disproportionately lack either a driver's license or a personal identification card issued by the state, and that disparity is statistically significant, wrote Tom Perez, the Assistant Attorney General for Civil Rights. There were other, less noticeable burdens attached to the new law. To obtain the free voter ID provided by the state, prospective voters had to provide supporting documentation confirming their identities, the cheapest option being a birth certificate for $22. Getting to a Department of Motor Vehicles office in Texas could be a trying affair. There were no DMV offices in 81 of the 254 counties in Texas, and some voters would have to travel up to 250 miles to get to one. Not surprisingly, counties with significant Hispanic populations were less likely to have a DMV office, while Hispanic residents in such counties were twice as likely as whites to not have the right ID, nor to have a car. Public transportation was virtually non-existent outside major cities in Texas, making getting a voter ID all the more difficult. Victoria and Nicole Rodriguez, 18-year-old twins from San Antonio and freshmen at St. Mary's University, were two of the hundreds of thousands of registered voters without acceptable voter IDs. The Rodriguez sisters never had driver's licenses because it was too expensive for their mother to add them to her car insurance. Their father worked during business hours, and their mother took care of their grandmother, meaning they'd have to get the bus to the closest DMV office, which took an hour round trip. Victoria testified for the Justice Department when a federal court in Washington heard the Texas voter ID case in June 2012. I was able to use my student ID on the airplane when they flew us out to D.C., she said, and I was able to get into the hotel just with my student ID. And I was able to get into the district court just with my student ID. But I wasn't able to use it to vote. In June 2012, the GOP-controlled House of Representatives voted to hold Holder in contempt of Congress for allegedly failing to provide documents in the Operation Fast and Furious gun-running scandal, a first for a sitting cabinet member. The Congressional Black Caucus walked out of the House chamber in protest. The word embattled stuck to Holder like gum on a shoe. The New York Times had described Holder as mild, self-deprecating, even eager to please in a profile after Obama's election, but that was not how he was regarded in Washington. He'd been a controversial attorney general from the start, a target for the right since he'd said during Black History Month in 2009 that America had been a nation of cowards when it came to discussing race. He was also under siege from the left for failing to reverse the Bush administration's erosion of civil liberties or to prosecute Wall Street banks for fraud. To the right, he might as well have been a member of the Black Panther Party. Indeed, foes like Hans von Spakovsky accused him of killing an investigation into the new Black Panther Party that had begun in the waning days of the Bush administration. During a congressional hearing on the case, the Texas Representative John Culberson, a Houston Republican, told him, "There's clearly evidence, overwhelming evidence, that your Department of Justice refuses to protect the rights of anybody other than African Americans to vote." I would disagree very vehemently with the notion that there's overwhelming evidence that is in fact true, Holder responded. Holder returned to Texas the day after the state's voter ID trial had begun to defend his department's efforts to protect voting rights, speaking at the NAACP convention in Houston. He singled out Texas for particular scrutiny, noting that a handgun permit was an acceptable voter ID in the state, but a student ID was not. Especially in recent months, Texas has in many ways been at the center of our national debate about voting rights issues, Holder said. He explained why the DOJ had objected to the law. Many of those without IDs would have to travel great distances to get them, and some would struggle to pay for the documents they might need to obtain them. He then added a much-discussed line that was not in the prepared text of the speech. We call those poll taxes. Audience members applauded loudly. Let me be clear, Holder continued. Let me be very clear. We will not allow political pretexts to disenfranchise American citizens of their most precious right. Holder's poll tax comment set off a barrage of debate, but it was technically accurate. A poll tax in Alabama in the 1960s cost roughly $10 adjusted for inflation, while the birth certificate needed to obtain an allegedly free voter ID in Texas cost twice as much. In the late summer of 2012, the federal district court in Washington sided with the DOJ in the Texas redistricting and voter ID cases. On August 28th, the court found that Texas's redistricting maps were enacted with discriminatory purpose. 2 days later, the court rejected Texas's voter ID law for 3 reasons. 1, a substantial subgroup of Texas voters, many of whom are African American or Hispanic, lack voter ID. 2, the burdens associated with obtaining ID will weigh most heavily on the poor. And 3, racial minorities in Texas are disproportionately likely to live in poverty. Notably, the court found that the law did in fact amount to a modern-day poll tax. A law that forces poorer citizens to choose between their wages and their franchise unquestionably denies or abridges their right to vote, the court wrote. Federal courts also blocked South Carolina's voter ID law for 2012 and overturned Florida's restrictions on early voting in the 5 counties in the state subject to Section 5. These victories for Holder's DOJ signaled a major shift in the voting wars. Suddenly, Republicans pushing new voting restrictions found themselves on the defensive. In states not subject to Section 5, civil rights groups like the NAACP and ACLU successfully filed suit to halt restrictive voting laws in crucial swing states like Ohio, Pennsylvania, and Wisconsin. On the eve of the election, state or local courts had blocked 10 major voting restrictions, including voter ID laws, Missouri, Pennsylvania, Texas, and Wisconsin, limits on voter registration drives, Florida, cutbacks to early voting, Ohio, partisan voter purges, Iowa, hurdles to student voting, New Hampshire, and the disqualification of provisional ballots, Ohio. 2 Sundays before the election, Lewis traveled to Florida to speak at an Empowerment Sunday rally at Bo Diddley Plaza in Gainesville, urging black voters to cast their ballots after attending church. He told the story of Bloody Sunday and linked it to the present day. There are forces in America that are trying to make it harder, more difficult for people to cast a vote, he said. We must not let that happen. A week later, Lewis was in Ohio on the Sunday before the election. The Ohio GOP had tried to prevent early voting 3 days before the election, but the Obama campaign had successfully sued to reinstate those days. As he approached the Hamilton County Board of Elections in Cincinnati, Lewis saw the line of voters stretching for nearly a mile around multiple blocks, with thousands waiting for hours in the damp cold. This is very, very moving, Lewis said as he walked the line. This is living testimony that people who tried to make it hard and difficult and who put up stumbling blocks and roadblocks, it's just not working. In Texas, with the voter ID law blocked, Victoria and Nicole Rodriguez were able to vote for the first time in their lives. Despite the perseverance of many, the barriers and confusion resulting from the push to restrict voter rights turned the 2012 race into a case study of how not to run an election. Floridians had 6 fewer days to vote, which led to much longer lines at the polls. Dessalines Victor, a 97-year-old Haitian immigrant, had no problems voting for the first time in her life in 2008, but when she went to her polling place in North Miami in 2012 on the first day of early voting, she waited for 3 hours before being told to return later in the day. When she returned that evening, poll workers moved her to the front of the line and said she was able to cast a ballot. I was happy when I finally cast my ballot, she said, but I was also upset. In this great nation, why should anybody have to stand in line for hours and make 2 trips to vote? Richard Jordan wasn't so lucky. He worked as a painter and went to his polling place in East Orlando at 4:30 p.m. on Election Day after finishing a 10-hour shift. After he had waited for 3 hours, the line had barely moved. His back hurt and he needed water. Though he'd voted for more than a decade, Jordan reluctantly left without voting. The polls didn't close at his precinct until 11 p.m. Jordan was one of an estimated 200,000 Floridians who didn't vote in 2012 because of long lines. I want to thank every American who participated in this election, Obama said during his victory speech in Chicago, whether you voted for the very first time or waited in line for a very long time. He then added, by the way, we have to fix that. The last voter in Florida cast his ballot at 2:03 a.m. in Miami, 7 hours after the polls closed and 4 hours after Obama's victory speech. Across the country, blacks and Hispanics waited twice as long as whites to vote. Still, voting rights activists greeted the election results with great relief. The new restrictions hadn't swung the election and, if anything, seemed to have backfired on the GOP. Compared with 2008, 1.7 million more blacks, 1.4 million more Hispanics, and 550,000 more Asians went to the polls versus 2 million fewer whites. The turnout rate among black voters exceeded that of whites for the first time on record, according to the Census Bureau. While the turnout rate fell among nearly every demographic group, the largest increase came from blacks 65 and over. Those, like Lewis, who had lived through the days when merely trying to register could get you killed, were the ones most determined to defend their rights in 2012. A year after his visit to the LBJ Library, Holder traveled to Boston following the election to give another major speech about voting rights at the JFK Library. The fight was far from over, he warned. The unfortunate reality is that even today, too many citizens have reason to fear that their right to vote, their access to the ballot, and their ability to have their votes counted is under threat, he said. Just 3 days after Obama's re-election, the Supreme Court agreed to hear a new challenge to Section 5, which Holder called the keystone of our voting rights. It all started with a two-vote election in Alabama. Before local elections in 2008, the town of Calera in central Alabama redrew its city boundaries. Locals used to call the once sleepy area 55 miles north of Selma, Pineville. It had one main road, US 31, and a quaint two-block downtown surrounded by woods. Its main attraction was the Heart of Dixie Railroad Museum. But over the past decade, Calera had become the fastest-growing city in the state, increasing from 3,000 to 12,000 people and adding new businesses like Walmart and Cracker Barrel off the busy I-65 highway running from Birmingham to Montgomery. The black voting age population in Calera had also grown from 13% in 2004 to 16% in 2008. But the new maps eliminated the city council's lone majority black district, represented by Ernest Montgomery since 2004. Montgomery was only the second black office holder in the town's history. Calera decreased the black voting age population in Montgomery's district from 71 to 30% by adding 3 overwhelmingly white subdivisions while failing to include a large surrounding black neighborhood. A day before the election, the DOJ objected to the change. Calera could have preserved the majority black district, the city's demographer told officials in Washington, but the city council chose not to. Calera held the election in defiance of Justice Department orders, and Montgomery lost by 2 votes. I had no knowledge of any of this until after the election, he said. Montgomery was a soft-spoken precision machinist who built water valves for companies and municipalities. He held the same job since graduating from technical school and had been married to his high school sweetheart for 34 years. He spent all his time at work with the city council or helping out at his church. Montgomery was born in 1957 when 85% of whites but only 17% of blacks were registered to vote in Calera's Shelby County. He grew up going to segregated schools until junior high when he was bused to a predominantly white school. I can remember a lot of violence, a lot of talking, he said. White parents said they would be dead before they'd allow their children to go to school with black children. The Klan had an active presence in Shelby County, shooting up the church of a preacher who was involved with the civil rights movement and castrating a black man accused of impregnating a white lady. Still, Montgomery didn't think race was as big an issue in Calera as it was in other parts of the state. That changed in 2008 when he knocked on doors in the lily-white subdivisions of his new district, which he knew well from his time on the City Planning Commission, and was told by residents that they were supporting his opponent, an office manager for a food supply company who'd lived in the town for only 3 years. When he asked why, they couldn't give him a good reason. Montgomery could come to only one conclusion. They voted against me because of the color of my skin. The DOJ negated the 2008 election results, and after a year of negotiations, Calera moved from single-member districts to an at-large election plan for the city council. Montgomery was easily elected under the new system, winning the largest number of votes of any candidate, while his opponent from 2008 received the second fewest. After the 2 elections, I realized how important Section 5 is, Montgomery said. That would have been the end of it if Ed Bloom hadn't read the objection on the DOJ's website and called Shelby County's lawyer, Frank Butch Ellis, urging him to challenge Section 5. Ellis had been the county's lawyer since 1964. He had a long history in the area. His father, Handy, had been chairman of the Alabama delegation at the 1948 Democratic Convention that walked out in protest after Harry Truman endorsed a civil rights platform. Shelby County, a wealthy white flight exurb of Birmingham, was one of those southern counties that moved from solidly Democratic to deeply Republican after the 1960s. Romney won 76% of the vote there in 2012. The Alabama Republican Party held its election night party at a gun range in Shelby County, where attendees fired away while awaiting election returns. Its 9-member county commission consisted of 8 white men and 1 white woman. It wasn't the type of place that much liked the VRA, especially under the control of a black president and black attorney general. Bloom and Ellis filed the suit in early 2010. The brief claimed that Section 5's federalism cost is too great and the statute had accomplished its mission. Civil rights groups found it highly ironic that a county in Alabama, of all places, would make such a claim. The Voting Rights Act is Alabama's gift to our country. Debu Adegbala, counsel for the NAACP Legal Defense Fund, said at a mass meeting in Shelby County. The disputed election in Calera was a textbook example of why you need Section 5, said Sam Bagenstos, the Deputy Assistant Attorney General for Civil Rights under Holder. The DOJ had objected to 4 other discriminatory annexations in Shelby County since 1975 under the Ford, Carter, Reagan, and Clinton administrations. Kevin Miles, Southeast Regional Director for the NAACP, compared the challenge with a fox filing a lawsuit saying the chicken coop is too secure. Yet Bloom called Shelby County the ideal plaintiff because they are unable to bail out of Section 5. Unlike in the Namudno case, the Supreme Court would be forced to consider the constitutionality of Section 5 head-on. Bloom's suit became a cause célèbre in the conservative movement, attracting support from Republican attorneys general in Alabama, Alaska, Arizona, Georgia, South Carolina, South Dakota, and Texas. The rhetoric used by outspoken critics of the VRA was reminiscent of the Civil War. When asked about Section 5 at a Republican presidential debate in South Carolina, Rick Perry declared, "Texas is under assault by the federal government. I'm saying also that South Carolina is at war with this federal government and with this administration." Shelby County lost in the district court and appeals court, but by the time the lawsuit reached the Supreme Court, the bipartisan consensus that supported the VRA for nearly 50 years, including in 2006, had collapsed. There had been more lawsuits challenging the constitutionality of Section 5 in 2011 and 2012 than during the previous 4 decades combined. Shelby County v. Holder pitted the traditionalists in the GOP, who had long backed the VRA, against the ascendant counter-revolutionaries. The counter-revolution's most influential players in the Reagan and Bush II administrations, Brad Reynolds, Chuck Cooper, Hans von Spakovsky, and Brad Schlossman, filed an amicus brief supporting Shelby County. It faulted the DOJ for refusing to approve voter ID laws in Texas and South Carolina in 2012. Rather than heed this court's repeated calls for restraint, Congress's and DOJ's recent actions have only worsened the grave constitutional flaws of Section 5. The brief drew a heated response from Dick Thornburgh, the Attorney General from 1988 to 1991, and the heads of the Civil Rights Division under Clinton, Bush I, Carter, and Ford. Far from raising constitutional concerns, the recent enforcement of Section 5 demonstrates its continued necessity and vitality, they wrote. The Supreme Court heard oral arguments on the morning of February 27, 2013, a day after the 144th anniversary of Congress's passing the 15th Amendment. Ernest Montgomery sat in the packed courtroom alongside civil rights icons like John Lewis. Bloom was there, too, hoping for an entirely different outcome. History had come full circle. Shelby County's lawyer, Burt Rain, had once clerked for Justice John Harlan, one of 2 justices to dissent in the Allen v. State Board of Elections case, which established Section 5 as a centerpiece of the VRA in 1969. Rain began by referring to the Namudno case. Those justices recognized that the record before the Congress in 2005 made it unmistakable that the South had changed, he said. They questioned whether current remedial needs justified the extraordinary federalism and cost burdens of preclearance. Justice Sotomayor interjected, "Assuming I accept your premise, and there's some question about that some portions of the South have changed, your county pretty much hasn't," she said. "Why would we vote in favor of a county whose record is the epitome of what caused the passage of this law to start with?" "Well, I don't agree with your premises," Rain responded, "but let me just say, number one, when I said the South has changed, that is the statement that is made by the 8 justices in the Northwest Austin case." As with the prior challenge to the VRA, Roberts said nothing during Rain's presentation, but he interrupted Solicitor General Donald Verrilli, who argued the case for the United States, within a minute. "Roberts, do you know which state has the worst ratio of white voter turnout to African American voter turnout?" Verrilli, "I do not." Roberts, "Massachusetts." Do you know where African American turnout actually exceeds white turnout? Mississippi. Really, yes, Mr. Chief Justice, but Congress recognized that expressly in the findings when it reauthorized the Act in 2006. It said that the first-generation problems had been largely dealt with, but there persisted significant Roberts. Which state has the greatest disparity in registration between white and African American? Really, I do not know that. Roberts. Massachusetts. Third is Mississippi, where again the African American registration rate is higher than the white registration rate. Really, Congress wasn't writing on a blank slate in 2006, Mr. Chief Justice. It faced a choice, and the choice was whether the conditions were such that it could confidently conclude that this deterrence and this constraint was no longer needed. Congress made a cautious choice in 2006 to keep the constraint and to keep the deterrence in place. The Chief Justice had his facts wrong. In 2008, Mississippi ranked 8th in black voter turnout, and Massachusetts 26th. Despite this disparity, the comparison was highly misleading. Massachusetts, 8% black, had elected the first black senator since Reconstruction in 1966 and currently had a black governor, while Mississippi, 37% black, had never elected a black official to statewide office. Obama won 56% of the white vote in Massachusetts in 2012, but only 10% in Mississippi. Massachusetts was hardly a racist backwater, and Mississippi was far from a post-racial utopia. Nevertheless, confident in his argument, Roberts returned to interrogating Verrilli a few minutes later. Roberts. General, is it the government's submission that the citizens in the South are more racist than citizens in the North? Verrilli. It is not, and I do not know the answer to that, Your Honor, but I do think it was reasonable for Congress. Roberts. Well, once you said it is not, and you don't know the answer to it. Verrilli. As an objective matter, I don't know the answer to that question, but what I do know is that Congress had before it evidence that there was a continuing need, based on Section 5 objections, based on the purpose-based character of those objections, based on the disparate Section 2 rate, based on the persistence of polarized voting, and based on a gigantic wealth of jurisdiction-specific and anecdotal evidence that there was a continuing need. Roberts. A need to do what? Verrilli. To maintain the deterrent and constraining effect of the Section 5 pre-clearance process in the covered jurisdictions. Roberts. And not impose it on everyone else? To Roberts and his conservative colleagues, those states with the longest histories of voting discrimination were now the ones being discriminated against. If Alabama wants to have monuments to the heroes of the civil rights movement, if it wants to acknowledge the wrongs of its past, is it better off doing that if it's an independent sovereign, or if it's under the trusteeship of the United States government? Justice Kennedy, the ostensible swing vote, asked Verrilli. Of course, this is aimed at states, Justice Breyer responded. What do you think the Civil War was about? To rebut the conservative justices, Verrilli repeatedly invoked Congress's overwhelming reauthorization of the VRA in 2006. But to critics of the VRA, the legislation's popularity paradoxically served as evidence of its unconstitutionality. I think it is attributable, very likely attributable, to a phenomenon that is called perpetuation of racial entitlement, Justice Scalia said 51 minutes in. It's been written about. Whenever a society adopts racial entitlements, it is very difficult to get out of them through the normal political processes. I don't think there is anything to be gained by any senator to vote against continuation of this act, and I am fairly confident it will be reenacted in perpetuity unless a court can say it does not comport with the Constitution. You have to show, when you are treating different states differently, that there's a good reason for it. This is not the kind of a question you can leave to Congress. After the courtroom murmured with shock, Justice Sotomayor asked Rain, "Do you think that the right to vote is a racial entitlement in Section 5? No, he responded. Why should we make the judgment and not Congress about the types and forms of discrimination and the need to remedy them? Sotomayor followed up. I think the problem to which the Voting Rights Act was addressed is solved, Rain said. You said the problem has been solved, Justice Kagan interjected, but who gets to make that judgment really? Is it you? Is it the court? Or is it Congress? I think the question is Congress can examine it. Congress makes a record. It is up to the court to determine whether the problem indeed has been solved, Rain responded. Well, that's a big new power that you are giving us, that we have the power now to decide whether racial discrimination has been solved, Kagan said. I did not think that fell within our bailiwick. The argument was most notable for what was not said. Remarkably, there was no discussion of the new voting restrictions in 2012 that, as Lewis put it, dramatized the need for Section 5. The justices did not hear, for example, that 6 of the 9 fully covered states under Section 5 had passed new voting restrictions since 2010, including voter ID laws: Alabama, Mississippi, South Carolina, Texas, and Virginia; limits on early voting, Georgia; and restrictions on voter registration, Alabama and Texas, compared with only 1/3 of non-covered jurisdictions during the same period. Nor did they hear that the Justice Department and federal courts had blocked 4 major discriminatory voting changes from becoming law in 2012 under Section 5. What had changed in recent years wasn't so much the South as the fact that states like Kansas and Ohio and Pennsylvania and Wisconsin had adopted Southern-born barriers to the ballot box. But when the potent remedy of the VRA was needed the most, a majority on the court seemed to believe that the illness of voting discrimination had been cured. A law that 8 justices had praised as a valid effectuation of the 15th Amendment in 1966 had been transformed into a racial entitlement that only the Supreme Court was brave enough to end. Scalia's comment captured the headlines, but he was only stating in more graphic form the prevailing views of the Roberts Court. When the court recessed at 11:30, Lewis hurried across the street to catch the unveiling of the new statue of Rosa Parks at the U.S. Capitol. Congressman Jim Clyburn of South Carolina was the only speaker at the ceremony to note the irony of Congress's honoring Parks at the same time that the Supreme Court was hearing a challenge to the legislation bearing her name. "1 hour ago, I sat across the street witnessing the opening arguments of a voting rights case before the United States Supreme Court, a case that many feel could turn the clock back on much of the progress that has been made, and for which we pause today to honor Rosa Parks," he said. Lewis got to the Capitol at the tail end of the ceremony, but his mind was elsewhere. He said he almost cried when Justice Scalia compared the VRA with a racial entitlement. "So what happened to the 14th and 15th Amendments?" he asked, shaking his head. "What happened to the whole struggle to make it possible in the 20th century, and now the 21st, for every person to be able to cast a free and open vote?" He was also deeply disturbed by the conservative justices' preoccupation with the sovereign dignity of states like Alabama. "You heard it all those years in the South. Why you picking on the South? Why you selected the South? Why you select Alabama?" Lewis exclaimed. "Alabama selected herself. It's history. Alabama and Georgia and the 11 states of the old Confederacy, they did it. Places like Georgia, Alabama, Mississippi, they forget recent history. We're not talking about something that took place 100 years ago, but a few short years ago, and some of it is still going on right today. And if you get rid of Section 5 of the Voting Rights Act, many of these places will slip back to the habits of the past." On May 20th, 1961, Lewis and 24 Freedom Riders traveling through the South were assaulted by a frenzied mob at the Greyhound bus station in Montgomery, Alabama. Lewis was struck over the head with a Coca-Cola crate and left lying unconscious in a pool of blood. The Freedom Riders sought refuge at the First Baptist Church, pastored by Ralph Abernathy, disguising themselves as members of the choir to avoid police scrutiny. 3,000 white supremacists surrounded the church the next night and hurled Molotov cocktails through the stained glass windows. "That night was unbelievable," Lewis remembered. "I thought some of us would die." After tortured deliberation, President Kennedy sent in federal marshals to escort the Freedom Riders to safety. On March 2, 2013, when Lewis returned to the First Baptist Church on a civil rights pilgrimage to Alabama with 200 guests, including 30 members of Congress, Chief Kevin Murphy, head of the Montgomery Police Department, unexpectedly apologized to him. "We enforced unjust laws," Murphy said. It was the first apology Lewis had ever received from a law enforcement official in the Deep South, after 40 arrests and countless near-death experiences. They embraced as the congregation cheered and wept, and Murphy gave Lewis his badge. "Chief Murphy, my brother, I accept your apology," Lewis responded. "I don't think I'm worthy of this." Then he joked, "Actually, do you think I could get another?" Lewis kept the badge in his pocket for days. "I want to say to all of you here, it shows the power of love, the power of peace, the power of nonviolence," he said. The Montgomery Advertiser featured Murphy's apology on its front page. Next to it, however, was a story about how, if the Supreme Court overturned Section 5, Republicans might dismantle the majority black legislative districts protected under the law, which illustrated the South's continuing racial divide. Obama, the article noted, won 95% of the black vote in Alabama in 2012, but only 15% of the white vote. Whites won't vote for blacks in Alabama, said the state Senator Hank Sanders of Selma. That's the state of race relations. The next morning, Lewis rode from Selma to Montgomery, following in reverse the route he'd marched 48 years earlier. Selma was now a stronghold of black political power, with a black mayor, a black congresswoman, and 6 black city council members. But economically, it was like so many other poor towns across the country, with too few jobs and too much crime. Lewis's bus passed scores of dilapidated houses on its way to Brown Chapel, a sobering reminder of the gains yet to be won. He embraced Holder when he walked into the historic red brick church. Lewis asked to be a regular pew member and listened intently as the Reverend James Forbes of Riverside Church in New York animatedly told the story of Cain and Abel, linking the blood of the brothers to Bloody Sunday. "Y'all need to know that God watches voting," Forbes said. "It doesn't matter what kind of voter suppression method." After the service, Holder spoke at the foot of the Edmund Pettus Bridge, behind a giant American flag draped over an old brick building. "Although our nation has indeed changed, although the South is far different now, and although progress has indeed been made, we're not yet at the point where the most vital part of the Voting Rights Act, Section 5, can be deemed unnecessary," he said. The large crowd began chanting at what had to be a first, "Section 5, Section 5." 3 months later, on June 25, 2013, John Roberts calmly read the highlights of his majority opinion in Shelby County v. Holder from the bench. The Chief Justice noted the dramatic increase in black registration and examples of progress more poignant than the numbers, such as black mayors in Selma and Philadelphia, Mississippi. "Any racial discrimination in voting is too much, but our country has changed in the past 50 years, Roberts said. When taking such extraordinary steps as subjecting state legislation to pre-clearance in Washington and applying that regime only to some disfavored states, Congress must ensure that the legislation it passes speaks to current conditions. The coverage formula, unchanged for 40 years, plainly does not do so, and therefore we have no choice but to find that it violates the Constitution." In a shrewd political maneuver, Roberts and the 4 concurring conservative justices had invalidated not Section 5 of the VRA, but instead Section 4, the formula devised in 1965 that eliminated literacy tests in the states with the worst histories of voting discrimination and instructed them to approve their voting changes with the federal government to prevent future discrimination. These states had now been freed from federal oversight. Roberts' opinion turned Section 5 into a zombie, a body with no life in it. The same court that had upheld the constitutionality of Section 5 on 4 previous occasions had finally accomplished what longtime opponents of the VRA in the legislative and executive branches, including a young Roberts in the 1980s, had failed to do. 8 years earlier, Roberts told the Senate that the constitutionality of the VRA had been settled. In fact, curbing the VRA and similar laws aimed at remedying historic discrimination had become his signature project as Chief Justice. The court's 5 conservative justices all had been appointed by Reagan or served in his administration. The Shelby County decision showcased how the counter-revolution against civil rights had captured the highest echelons of power in the United States. After Roberts finished, 81-year-old Ruth Bader Ginsburg, the oldest member of the court, read a 10-minute summary of her fiery dissent. The court points to the success of Section 5 in eliminating the tests and devices extant in 1965 and in increasing citizens' registration and ballot access, she said in her high-pitched New York City accent. Does that provide cause to believe Section 5's potent remedy is no longer needed? Her 37-page written dissent with Justices Breyer, Kagan, and Sotomayor was much more scathing. In the court's view, the very success of Section 5 of the Voting Rights Act demands its dormancy, read the first line. It continued, throwing out preclearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet. The scope and longevity of the VRA were a decision best made by Congress, not the courts, Ginsburg said. It was the judgment of Congress that 40 years had not been a sufficient amount of time to eliminate the vestiges of discrimination. That judgment of the body empowered to enforce the Civil War amendments by appropriate legislation should garner this court's unstinting approbation. She viewed the Shelby decision as a radical act of judicial activism by 5 justices appointed to the court, on the basis of their stated belief in judicial restraint. Congress approached the 2006 reauthorization of the VRA with great care and seriousness, her written dissent read. The same cannot be said of the Court's opinion today. Hubris is a fit word for today's demolition of the VRA. She closed her remarks from the bench by invoking the pivotal events that led to the passage of the VRA. The arc of the moral universe is long, Ginsburg said, quoting King's famous line at the end of the march from Selma to Montgomery, but it bends toward justice if there is a steadfast commitment to see the task through to completion. That commitment has been disserved by today's decision.
This is the end of the CD. The audiobook continues on the next CD.
Armand Dürfner, who argued the Allen case in 1969, was among the spectators sitting in the hushed courtroom. Everybody was just kind of numb, he said. The VRA's formula was far from perfect. It covered only 5 counties in Florida and 40 counties in North Carolina and did not apply to recent violators like Ohio. But Dürfner knew from 4 decades as a voting rights lawyer that a flawed Section 5 was far better than none. By chance, he'd sat next to Bloom on the plane from Charleston to Washington for the oral arguments in the case. He asked Bloom the same question a conservative white Southerner on the Richmond City Council had asked him decades earlier. How can a nice man like you do such awful things? Bloom celebrated on the steps of the Supreme Court following the ruling. This decision restores an important constitutional order to our system of government, which requires that all 50 states are entitled to equal dignity and sovereignty, he said. Elected officials across the South who were prevented from implementing discriminatory voting changes under Section 5 swiftly praised the decision. Eric Holder can no longer deny hashtag voter ID in hashtag Texas after today's hashtag SCOTUS decision, the Texas Attorney General Greg Abbott tweeted minutes after. The Supreme Court did itself proud, Abigail Thernstrom wrote in the Wall Street Journal. The court's ruling Tuesday will benefit Black America. The first Black Attorney General and first Black President strenuously contested Thernstrom's prediction. This decision represents a serious setback for voting rights, Holder said at the Department of Justice, and has the potential to negatively affect millions of Americans across the country. Obama was in Senegal, touring Gorée Island, where Africans had been sent as slaves to board ships to the Americas, when he commented on the decision. I might not be here as president had it not been for those who courageously helped to pass the Voting Rights Act, he said. Alvin Holmes of Montgomery, the longest-serving black legislator in the Alabama House of Representatives, remarked, I know Dr. Martin Luther King, Jr. is turning over in his grave. In Calera, Ernest Montgomery couldn't believe the decision. Disappointed isn't even the word for it, he said. Lewis stayed away from the Supreme Court that day. He couldn't bear to be in the courtroom when the justices struck down his signature achievement. It would have been too much, he said. He watched the news in his congressional office, a shrine to the civil rights movement. The walls were lined with black and white photos of Lewis speaking at the March on Washington, marching in Selma, conferring with LBJ, and touring the South with Julian Bond. He received the news from 2 TVs mounted above busts of LBJ and RFK. I'm shocked, dismayed, disappointed, he said that morning. I take it very personally. He felt like crying, but put on a brave face for the cameras. Since the 1950s, the Supreme Court had been an ally to civil rights activists like Lewis. Now it was his greatest foe. These men never stood in unmovable lines, Lewis said. They were never denied the right to participate in the democratic process. They were never beaten, jailed, run off their farms, or fired from their jobs. No one they knew died simply trying to register to vote. They are not the victims of gerrymandering or contemporary unjust schemes to maneuver them out of their constitutional rights. A year earlier, Lewis learned from the PBS show Finding Your Roots that his great-great-grandfather, Tobias, had registered and voted in Alabama after becoming an emancipated slave following the Civil War, something that Lewis and his family could not do until nearly 100 years later. He wept when he heard the news. It underscored how fragile the right to vote had been throughout American history. History did not end in 1965, Roberts wrote in the Shelby decision, but to Lewis, the Chief Justice's opinion ignored the long history of voting discrimination that led to the VRA and the persistent attempts to restrict voting rights after 1965 that made the law, particularly Section 5, so essential. Between 1965 and 2013, more than 3,000 discriminatory voting changes had been blocked by the courts and the Justice Department under Section 5. Roberts emphasized only the progress that had been made since 1965, disregarding the history in the decades after that told a much more complicated and somber story. Lewis's amicus brief before the court highlighted the unfounded belief that our history of voting rights has been one of consistent progress. In fact, the narrative of voting rights, as evidenced by the story of Congressman Lewis's own ancestors, is one of a cycle of retrenchment and reconstruction. Roberts' opinion was a striking product of the states' rights federalism doctrine championed by his mentor, Justice Rehnquist, who had wanted to return America to the principles of the pre-Civil War Constitution. Roberts based the Shelby decision on what he called a fundamental principle of equal sovereignty among the states, which he first cited in the Mudno case. It was a doctrine rooted in the darkest chapter of American history. In the infamous 1857 case Dred Scott v. Sanford, the Supreme Court ruled that African Americans, whether free or enslaved, could not be full citizens of the United States because to do so would violate the equal sovereignty of the slave states. Shelby County is the first decision since Dred Scott to invoke the doctrine of equal sovereignty where the right to vote was involved. The civil rights lawyers Jim Blackshear and Lonnie Guinier wrote in the Harvard Law and Policy Review following the decision. The Reconstruction Amendments were passed after the Civil War to give full citizenship to black Americans and to make clear that the federal government's interest in prohibiting racial discrimination trumped the sovereignty of the former slave states. The Supreme Court, however, refused to aggressively administer the amendments and to protect the voting rights of newly enfranchised black Americans like Tobias Lewis. Jackson Giles, the president and founder of the Colored Men's Suffrage Association of Alabama, had registered and voted in Montgomery for 30 years before he was disenfranchised by the poll tax and literacy test requirements of the 1901 Alabama Constitution. Giles had taken the case to the Supreme Court on behalf of 5,000 black residents of Montgomery, alleging that Alabama's new voter registration laws violated the 14th and 15th Amendments. In a 6-3 decision in 1903, Justice Oliver Wendell Holmes stated that the Supreme Court did not have the authority to invalidate the disenfranchising provisions of Alabama's Constitution. Holmes told Giles that relief from a great political wrong, if done, as alleged, by the people of a state and the state itself, must be given by them or by the legislative and political department of the government of the United States. Lewis and civil rights activists sought that relief 6 decades later by appealing to the Congress and the President to pass the VRA. Perhaps no statute in American history has been the subject of more sustained consideration by Congress than the VRA, wrote Congressmen Sessenbrenner and Watts in their amicus brief. Now the Supreme Court was overruling that extensive judgment of Congress, whose power Holmes had conferred on the legislative body instead of the courts, once again failing to protect voting rights by invoking states' rights as it had done after the Civil War. This court's expansive reading of state sovereignty, Lewis's brief stated, led to the end of Reconstruction. The Supreme Court's failure to enforce the 15th Amendment doomed the first Reconstruction. Would the gutting of the VRA curtail the second one? 10. After Shelby. A week after the Shelby County decision, 300 people in Raleigh packed into the white-columned Christian Faith Baptist Church on an overcast Monday afternoon. Supporters on the right, civil disobedience on the left, they were told. The racially and socioeconomically diverse crowd had the feel of an Obama campaign revival. 80 people took the left side of the pews, wearing green armbands to signal their intention to get arrested at the Legislative Building downtown, nearly all of them for the first time. It was the 9th week of the Moral Monday protests, as they came to be known, which started when Republicans in North Carolina, who controlled the legislature and the governorship in 2013 for the first time since the McKinley era, introduced the toughest voting restrictions in the country. The proposed voting changes included requiring strict voter ID, cutting early voting by a week, eliminating same-day registration during the early voting period, ending the $2,000 child dependency tax deduction for parents whose college students vote where they attend school, and rescinding the automatic restoration of voting rights for ex-felons. Pro-democracy groups dubbed the legislation the Screw the Voter Act of 2013 and the Longer Lines to Vote bill. When I say, "What do you want?" you say voting rights, the Reverend Curtis Gatewood, Vice President of the North Carolina NAACP, instructed the crowd, "What do you want? Voting rights. What do you want? Voting rights." The activists held clear, simple signs: "Protect every American's right to vote. Stop voter ID and fight voter suppression. Do not penalize parents and college students for voting." Gatewood passed the microphone to the Reverend William Barber II, President of the North Carolina NAACP and the leader of the Moral Monday protests. He was a charismatic preacher in the MLK mold, a big man with a soaring voice who was built like an offensive lineman. He wore pinstriped pants and a matching vest over his clerical collar, leaning his large frame on a ratty cane, which he'd used since suffering from a rare form of debilitating arthritis. "What do we do when they try to take away voting rights?" he asked. "We fight, we fight, we fight," the crowd shouted, standing and punching their fists in the air. Barber was born in Indiana 2 days after the March on Washington. "Civil rights is in my DNA," he said. When he was 4, his parents, native North Carolinians, uprooted the family from Indianapolis to the tiny rural town of Roper, North Carolina, 2 hours east of Raleigh, so that Barber could integrate the schools. Barber went to a segregated kindergarten and first grade until North Carolina integrated the schools in 1971, 17 years after Brown v. Board of Education. His father taught science at a previously all-white high school. His mother became the school's first black office manager. "My parents could have stayed out of the South," he said. "They could have stayed in the Midwest and done quite well, but they made a decision to come back." Barber became president of the North Carolina NAACP in 2005 and transformed the organization from a social club to an activist movement, as it had been in the 1960s, with 100 branches and 24,000 members. His brain trust included veterans of the civil rights movement like Bob Zellner, the first white field secretary of SNCC. Zellner had grown up at East Bruton, Alabama, near the Florida border. His grandfather and father were in the Klan, but Zellner rebelled and joined John Lewis on the Freedom Rides. He first met Barber on SNCC's 50th anniversary in Raleigh. Barber and Zellner were among the first wave of arrestees in early April. The House passed a strict voter ID bill that month, but it languished in the Senate along with the other proposed voting restrictions. Then, on the day of the Shelby decision, Tom Apodaca, the chairman of the Senate Rules Committee, announced, "Now we can go with the full bill." North Carolina, where 40 counties had previously been subject to Section 5, no longer had to endure the legal headaches of having its voting changes approved by the federal government, Apodaca said. "That's not only historically insensitive, that's racially insensitive," Barber said in church, to cries of "Amen." He rattled off the names of Evers, Cheney, Goodman, Schwerner, Liuzzo, King, the martyrs in the fight for voting rights. "We come here to say that if you think you're going to take away our voting rights, you're going to have a headache," he announced to loud cheers. When he arrived at the Legislative Plaza downtown, Barber was met by 2,000 supporters who formed a long row as the protesters walked into the North Carolina legislature. "Why do we come here?" he asked. "Justice," the crowd yelled. Inside the lobby of the legislature, activists packed into 2 floors as Barber led a rousing rendition of "Ain't Gonna Let Nobody Turn Me Around." Protesters could see the state Senate chamber through the glass, its members seemingly oblivious of what was happening right outside. The next day, in a perfect encapsulation of state politics, the Senate abruptly attached new abortion restrictions to a bill banning Sharia law. "You have 5 minutes to disperse or you will be arrested," announced the chief of police through a bullhorn. 81 people were arrested in the peaceful protest, bringing the total number of arrests to 616 since April. A large crowd gathered across the street to cheer the arrestees as they were herded on buses to the county detention center. Cars honked in solidarity. Barber sang his favorite gospel song, "I've Got a Feeling Everything's Gonna Be All Right." "Why are people going to jail?" a young boy asked his father. "Because they're standing up," his dad answered. 2 hours later, the arrestees began to return to the church. Mary Lucas, a retired physical therapist from Pittsburgh, entered to cheers, clutching a manila envelope with her arrest papers and wearing an "I Went to Jail with Reverend Barber" pin. It was her first protest and first arrest. "I skipped the civil rights movement, and I wish I hadn't," she said. She described her arrest as really liberating. "As a retired person, what do I have to lose?" Barber viewed the protests as a model for resistance across the country. "We believe North Carolina is the crucible," he said. "If you're going to change the country, you've got to change the South. If you're going to change the South, you've got to focus on these state capitals." That's where the new voting restrictions originated after 2010. A new wave of civil rights activism became especially important after the Shelby decision. The silver lining of that ruling is, we now know, we must build movements like we did in the 1960s, from Montgomery up, from Raleigh up, from congressional districts up, Barber said. States now become national battles. The Moral Monday movement started in the same place where the 1960s civil rights movement began, in Greensboro on the campus of North Carolina A&T University. At 4:30 p.m. on February 1, 1960, 4 freshmen at A&T, Joseph McNeil, Franklin McCain, Ezell Blair Jr., and David Richmond, sat down at the lunch counter at Woolworth's and refused to leave until they were served. 20 students came the next day, 300 2 days later. The sit-in spread to Winston-Salem, Durham, Raleigh, and Charlotte. 2 months later, SNCC was founded at Shaw University in Raleigh. 53 years later, after studying the VRA and the civil rights movement in his state and local government class, Tyler Swanson, a 19-year-old political science major at A&T, proposed a similar demonstration. He wanted to march to the local DMV office and chain himself to the door to protest the voter ID bill. His government professor, Derek Smith, a veteran activist, thought that would be too radical and urged Swanson and his classmate, Namdia Gooding, to march from the A&T 4 statue on campus to the government plaza instead. Barber traveled to Greensboro on April 12th and marched downtown with 50 students and NAACP members who chanted, "We don't need no voter ID." Swanson, who had grown up 15 minutes away in the small town of McLeansville, put on his Sunday best for the occasion, wearing a khaki baseball cap, gold sunglasses, a navy blazer, and a plaid tie. "I've got news for this General Assembly today. We don't approve of this voter ID law," he said through a bullhorn. "That's right," Barber affirmed. "We will not stop until everybody has the right to exercise their vote without being disenfranchised," Swanson continued. "Don't take off your marching shoes, because we're going to need them again." The modest protest soon led to something much bigger. Smith called Swanson, Gooding, Keisha Walker of Bennett College, and the A&T NAACP's president Kyle Keith, the Greensboro 4 of 2013. "There's a lot of history here," Swanson said. "We were continuing that legacy." North Carolina Republicans used the same rhetoric to argue for voter ID as in Texas. "We call this restoring confidence in government," said the North Carolina Speaker of the House, Tom Tillis, an ALEC Legislator of the Year in 2011. "There is some evidence of voter fraud, but that's not the primary reason for doing this. There are a lot of people who are just concerned with the potential risk of fraud." But unlike in Texas, which ranked 48th in voter turnout in 2012, North Carolina had the most progressive election laws in the South. It didn't always used to be that way. In 1996, North Carolina ranked 43rd in voter turnout. To expand voter participation, the state adopted electoral reforms like early voting in 2000, the counting of out-of-precinct ballots in 2005, and same-day registration during the early voting period in 2007. As a result, North Carolina had skyrocketed from 37th in voter turnout in 2000 to 11th by 2012. These reforms had a particularly beneficial impact on African American voters. In March 1965, when LBJ introduced the VRA, 46.8% of black North Carolinians were registered to vote, compared with 96.8% of whites. Decades after the passage of the VRA, the gap had narrowed but remained significant. But between 2000 and 2012, black turnout increased by 65%, and in 2008 and 2012, African Americans registered and voted at a higher rate than whites for the first time in state history. North Carolina has the best election laws in the country, Barber testified before the House Elections Committee. "We've had elections for 237 years without voter ID, and only after the massive turnout of African Americans, Latinos, progressive whites, students, and the elderly fundamentally changed the electorate in the South did false witness and distortion about fraud begin." 10 days after the Greensboro protest, the North Carolina House of Representatives stripped student IDs from private colleges from the list of acceptable voter IDs, affecting 89,000 students at 36 institutions. Students from across the state, with tape over their mouths, packed the House gallery in protest. "We will be heard," said the black tape over Swanson's lips. "Dr. King said that our lives end the day we become silent about things that matter," said Shemia Curry of Bennett College in Greensboro. "So I think this is a perfect opportunity to stand up for something we believe in." "What type of legacy are you really leaving?" Representative Rodney Moore, Democrat of Charlotte, asked his Republican colleagues during the House debate. "See those children up there?" He turned and pointed at the gallery. "Those children have been here for the last 3 hours with tape around their mouths because they understand what this bill has the potential to do, which is take their voice away." After the House passed the voter ID bill 8136, Barbara led the students in singing, "Ain't Gonna Let No Vote Turn Me Around." The next day, a picture of the students ran on the front page of the Raleigh News and Observer under the headline, "Voter ID Takes Closer Step to Law." The changes enacted by the North Carolina legislature extended far beyond voting. Since January, the new Republican majority had adopted the most rigidly conservative agenda in the country, eliminating the Earned Income Tax Credit for $900,000, declining Medicaid coverage for $500,000, ending federal unemployment benefits for $170,000, cutting pre-K for 30,000 kids, shifting $90 million from public education to voucher schools, and slashing taxes for the top 5% while raising taxes on the bottom 80%. For decades, North Carolina had a reputation as a moderate oasis amid a sea of deep red. It had largely avoided the turbulence of the civil rights years and had become known for good schools and sensible governance. Now it was giving Mississippi a run for its money. "The legislature is filled with lawmakers who view Jesse Helms as a role model," wrote the News and Observer columnist Rob Christensen. Barbara decided enough was enough. "At that point we had to go moral civil disobedience to dramatize how extreme, how immoral, and how shameful this was," he said. On April 29th, Barber, Zellner, and 50 protesters marched into the legislative building singing freedom songs, blocked the tall gold doors to the Senate, and refused to leave. "Voter ID is the first of the voter suppression bills they're planning," he said. "What the voter ID represents is a line in the sand. People of conscience must draw a line somewhere." He called it a peaceful pray-in. 17 preachers, academics, activists, and students were arrested for failure to disperse. The crowd outside chanted the name of each arrestee as he or she was loaded onto a white school bus and sent to jail. Most were held for 8 hours and released at 2:15 a.m. "It's a whole new beginning for the movement," said a bleary-eyed Zellner. The NAACP leaders Barber and Gatewood weren't released until 4:15 a.m. "I was never more proud to be with my brothers and sisters from all different backgrounds than I was today," Barber said. "It's 4:15 in the morning. I am tired in my body, but not a bit tired in my soul." The arrestees published an open letter titled "Why We Are Here." "We will become the trumpet of conscience and the beloved community that Reverend Dr. Martin Luther King Jr. called upon us to be," they wrote. There were 30 arrests a week later, 49 a week after that, including Swanson and Smith, 57 a week later, and 115 arrests in the 5th week of protests. "It really caught on like in the old days," Zellner said. "We've been waiting for a renewal of the civil rights movement, and this is it." The protests were building something the South hadn't seen since the 1960s, a multiracial, multi-issue movement centered on social justice. On June 24th, 92-year-old Rosanelle Eaton showed up at the protests and told Barber she wanted to be arrested. "Rosanelle, you don't have to do this, you know," Barber told her. "I know what I have to do," she replied, pushing aside her walker and marching into the legislative building in a black hat and matching pantsuit. Inside the building, she told her story to the packed crowd. She was born in Franklin County in the piney woods outside Raleigh, the youngest of 8. Her father was the only black man to own his farm in the area, but died on Christmas Eve after a mule accident. The landlord ripped off her mother, and the family lost the land. "That made me want to be independent," she said. When she turned 21, she told her mother she wanted to register to vote, which was nearly unthinkable for African Americans in North Carolina at the time. "I was interested in registering people, so I would be able to lead others or help others," she said. She and her mother rode a mule-pulled wagon 7 miles to the county seat of Lewisburg, where 3 white male registrars were sitting in the courthouse. "What can I do for you, little lady?" a registrar asked her. "I came down to see if I could register to vote," she replied. The registrar told her to stand up straight, look straight ahead, keep her arms by her side, and recite the preamble to the Constitution. After she did that, word for word, they gave her a written literacy test, which she also passed. "Ma'am, you ought to be proud of this little lady," the registrar told her mother. Eaton was one of the first black registered voters in Franklin County, which later became one of 40 North Carolina counties covered under Section 5. She cast her first ballot for FDR in 1944. When the civil rights movement took off, she registered voters for the SCLC and the NAACP and joined the march from Selma to Montgomery. "I knew John Lewis," she said. "He was young. I was always the oldest." She traveled to Washington and watched from the gallery when LBJ signed the VRA. Her activism didn't go unnoticed. A cross was burned on her lawn. Shots were fired at her house. She worked as a third-grade teacher and a librarian, bringing voter registration forms with her everywhere she went. She personally registered over 4,000 voters before losing count. On the 30th anniversary of the VRA, she was honored alongside Rosa Parks and Jesse Jackson in Selma, receiving the Invisible Giant Award from the National Voting Rights Museum. "I'm 92 years old," she said in the legislature. "I've been in the movement for 75 years. I marched with Martin Luther King. Now I am just disgusted." Barbara repeated her speech and the crowd cheered loudly. "I can't stand and let these bills be passed and not have a voice." She was arrested with 120 others for the first time in her life. "I never had a ticket or nothing," she said. "It was very exciting. It was worth going to jail to speak out against the voter ID bill." The next day, the Supreme Court handed down the Shelby decision. 3 weeks after Shelby, the North Carolina Senate significantly toughened the House's voter ID bill, eliminating student IDs from public universities, out-of-state driver's licenses, and county, municipal, and public employee IDs from the list of acceptable voter IDs. The bill was stricter than the Texas voter ID law, blocked by the courts in 2012 under Section 5. 4 days later, the North Carolina Senator Josh Stein, a Democrat from Raleigh, checked his legislative email at 9 p.m. and saw that the Senate's voter ID bill, already the most restrictive in the country, had been drastically expanded. He posted a summary of the new bill on his Facebook page. "I just received a proposed committee substitute on the voter ID bill that turns a 14-page bill into a 57-page elections bill monstrosity. It will keep tens of thousands of registered voters from participating in their democracy because of 2 instances of in-person voter fraud out of more than 20 million votes cast over 6 past elections in NC. If anyone had any doubt about the bill's intent to suppress voters, all she has to do is read it. The bill now does the following: shortens early voting by 1 week, eliminates same-day registration and provisional voting if at wrong precinct, prevents counties from offering voting on last Saturday before the election beyond 1 p.m., prevents counties from extending poll hours by 1 hour on Election Day in extraordinary circumstances like lengthy lines, eliminates state-supported voter registration drives and pre-registration for 16, 17-year-olds, repeals voter-owned judicial elections and straight-party voting, increases number of people who can challenge voters inside the precinct, and purges voter rolls more often. We will debate the bill in Rules Committee tomorrow at 2 p.m. This is a sad day for our democracy." Stein was stunned. The legislature was due to leave town at the end of the week, and Senate leaders had just proposed eliminating or curtailing nearly every single reform in the state that encouraged people to vote. The bill even eliminated Citizens Awareness Month, which the State Board of Elections used to promote voter registration. Millions of North Carolinians would be affected by the new restrictions. More than 2.5 million voted early in 2012, nearly 100,000 used same-day registration, 50,000 registered in high schools through pre-registration in their civics classes, and 300,000 registered voters didn't have government-issued IDs. At a packed Senate Rules Committee meeting the next afternoon, Stein, who taught election law at Campbell University's law school, pressed the bill's Republican sponsor, Bob Rucho, to explain the many controversial provisions of the new bill. He began with early voting. The first week of early voting, about 900,000 people voted, Stein said. Something like 85% of the state thinks early voting is a good thing and shouldn't be shrunk. 75% have voted early at one point or another. Why are we eliminating a week of early voting? Senator Rucho was a 65-year-old dentist from Matthews, North Carolina, born in Worcester, Massachusetts, who spoke in a Boston by way of Wilmington accent. He'd made national headlines during the 2012 election when he tweeted after the Supreme Court upheld Obama's health care law, "Justice Roberts' pen and Obamacare has done more damage to the USA than the swords of the Nazis, Soviets, and terrorists combined." Rucho said he had supported early voting when the concept was first introduced. It was designed to open up the opportunity for voter access. It's been altered over the years, maybe tainted in one direction. Rucho didn't elaborate on how it had been tainted, but said in another interview, it got abused. It was never designed to give one group an advantage over another. He was likely referring to the fact that Democrats used early voting more often than Republicans in North Carolina, and blacks at a greater rate than whites. 70% of African Americans voted early in 2012, compared with half of white voters. That's 900,000 people that need to vote another time, Stein responded, referring to the first week of early voting. The likely result will be longer lines on Election Day. He moved on to the statistics on voter fraud he'd received from the Board of Elections, which showed just 2 cases of voter impersonation from 2000 to 2012, when 21 million votes were cast, totaling 0.000095% of total votes. What evidence of in-person voter fraud is compelling you to impose the ID requirement? He asked. Senator Stein, you can't live in this society without identification, Rucho responded. Everyone has a form of ID. The notion that everyone has a photo ID is just wrong, Stein said to applause. Senator Apodaca, who presided over the meeting, told the gallery to be quiet. Stein asked why the state had eliminated pre-registration for 16 and 17-year-olds. My son turned 18, went through the school process, and was pre-registered and the like, and it was very confusing as to when he was supposed to do that, Rucho explained. What this does is offer some clarity and some certainty as to when that child or that young person is eligible to vote and registered to vote. That's what it's designed to do. Did your son not know he was 17 on Election Day? Stein said to laughs. The debate continued on the floor of the Senate. Why are you making it harder for seniors, young people, and minorities to vote? Stein asked. Might it be because these folks disproportionately vote Democratic? He noted that, as in Texas, North Carolina exempted absentee ballots from the voter ID requirement, even though the State Board of Elections found 24 times as many cases of absentee ballot fraud, compared with cases of voter impersonation. He suggested that was because Republicans constituted 31% of registered voters in 2012, but cast half of all absentee ballots. After the Senate passed the bill on a party-line vote that evening, Swanson and a dozen young activists staged a sit-in in Tillis's office, urging him to stop the bill. Today, we witness the most morally backwards voter suppression law in the United States so far, Joshua Vincent, a graduate student at North Carolina Central University, told Tillis's staff. We're not here to get arrested, but to instruct House Speaker Tom Tillis and elected officials, as is our constitutional right, to kill House Bill 589. The young activists sat and waited for Tillis, chanting, "I believe that we will win," the anthem of the Dream Defenders in Florida, who had occupied the Florida Capitol after George Zimmerman had been acquitted in the death of Trayvon Martin in July 2013. Tillis never showed. After half an hour, Vincent and 5 others were led out in handcuffs, bringing the total number of Moral Monday arrests to 951. The next day, the bill was sent from the Senate to the House by a special messenger for immediate consideration. The first to rise in opposition was 83-year-old Mickey Michaud, who had been elected in 1972 as Durham's first black representative and appointed in 1977 as the South's first black U.S. attorney since Reconstruction. He was now the longest-serving member of the North Carolina General Assembly. "I want you to understand why this means so much to so many people," he said on the House floor with tears in his eyes. "In 1965, when the Voting Rights Act was passed, that gave us a great deal of hope. We began to come into the halls of the legislature, city councils, and the mayor's races. All of these things happened. Had it not been for the Voting Rights Act, you would not see some of us sitting here today." He looked at his Republican colleagues and told them, "Now you're putting back what many of us fought our lives for and gave our lives for. Forget all the gains of the 20th century. That's what you're doing with the bills you are trying to pass tonight. I would ask you to take these 57 pages of abomination and confine it to the streets of hell for the rest of eternity. Every member of the Democratic minority, including 5 Democrats who'd voted for the House's less restrictive voter ID bill in April, spoke against the bill. Only one Republican member, the House Elections Committee's chairman David Lewis, a tobacco farmer from Dunn, North Carolina, defended it. When the voter ID proposal was first introduced in March, Tillis had promised a deliberative, responsible, and interactive approach. That pledge was thrown out the window after the Shelby decision. It was the most emotional 2 hours I've ever spent in public office, said Representative Rick Glazier, a Democrat from Fayetteville. This was, for many of our members, a feeling that their life's work was being rolled back in one 2-hour session. After the bill passed at 10:39 p.m., Democratic House members locked arms, bowed their heads, and observed a moment of silence. Swanson watched from the nearly empty gallery. He'd used the very reforms the legislature was targeting, registering when he got his driver's license at 16 and voting early for President Obama during his first election in 2012. It was a very gloomy day in the General Assembly, he said. Not since the end of Reconstruction had a state adopted so many voting reforms and then repealed them just a few years later. I have been trying to think of another state law passed since the 1965 Voting Rights Act to rival this law, but I cannot, wrote the law professor Rick Hazen of UC Irvine. North Carolina became the immediate case study for what a post-Section 5 world would look like, a striking refutation of Roberts' belief that voting discrimination was largely a thing of the past and that Section 5 was no longer needed. By chance, Attorney General Holder announced that same day that the Justice Department was suing to block Texas's redistricting maps, which had been found intentionally discriminatory under Section 5. This is the department's first action to protect voting rights following the Shelby County decision, he said, but it will not be our last. 2 days later, North Carolina's governor, Pat McCrory, announced he would sign the bill. Just because you haven't been robbed doesn't mean you shouldn't lock your doors at night or when you are away from home, he said. An AP reporter asked him how 3 parts of the bill, cutting early voting, eliminating same-day registration, and ending high school registration, would help prevent voter fraud. There is plenty of opportunity for voter registration, online, offline, through many methods, McCrory responded. He seemed unaware that North Carolina did not allow voters to register online. The reporter asked again why the legislature had eliminated pre-registration for high school students. I don't know enough, I'm sorry. I haven't seen that part of the bill, McCrory replied. After the press conference, Rosanelle Eaton and hundreds of Moral Monday members marched to the governor's office with blown-up copies of the bill for McCrory to read. The North Carolina NAACP filed suit against the law the day McCrory signed it. Eaton was one of the lead plaintiffs. A few weeks later, Eaton traveled to Washington for the 50th anniversary of the March on Washington. A large North Carolina contingent made the trip, carrying signs that said, NC needs the VRA. John Lewis was a featured speaker that Saturday at the Lincoln Memorial. 50 years earlier, he'd been the youngest speaker at the March on Washington, delivering an emotional plea about the need for the federal government to intervene on behalf of black Southerners. His prepared text had been so controversial, I want to know which side is the federal government on, that the older leaders of the movement, including King, asked him to tone it down. Now he was the only surviving speaker from that day. I gave a little blood on that bridge in Selma, Alabama, for the right to vote, Lewis said. I am not going to stand by and let the Supreme Court take the right to vote away from us. Eaton saw Lewis after his speech and urged him to convince Holder to sue North Carolina. The Justice Department had filed suit against Texas's voter ID law 2 days earlier under Section 2 of the VRA. He'd do what he could, Lewis told her. At the end of September, on the day of the government shutdown, Holder announced the department would intervene to block North Carolina's voting changes. I stand here to announce this lawsuit more in sorrow than in anger, the Attorney General said. It pains me to see the voting rights of my fellow citizens negatively impacted by actions predicated on a rationale that is tenuous at best and on concerns that we all know are not, in fact, real. As 2014 arrived, tens of thousands of activists in North Carolina from all backgrounds, races, and causes marched from Shaw University to the state capitol to kick off a new year of Moral Monday protests. Just like Dr. King sent out the call and said, "Come to Selma" in 1965, we're saying, "Come to Raleigh" in 2014, Barber said. 100 buses arrived from across the country on the chilly February morning. One particularly illustrative sign read, "Welcome to North Carolina. Turn your watch back 50 years." An estimated 80,000 people gathered on Jones Street for the mass gathering, the largest civil rights rally in the South since the Selma to Montgomery March in 1965. As bad as the past few years had been, 2014 got off to a promising start for voting rights. In early January, a day after King's 85th birthday, Congressmen Sensenbrenner and Lewis introduced the Voting Rights Amendment Act of 2014 to restore Section 5. It was a modest bill covering states with 5 voting rights violations in the past 15 years, which applied to only Georgia, Louisiana, Mississippi, and Texas, but it represented a promising start for a post-Shelby legislative fix. Nancy Pelosi suggested the law be named the John Lewis Voting Rights Act. A week later, Obama's Presidential Commission on Election Administration, chaired by the Obama campaign lawyer Bob Bauer and the Romney campaign lawyer Ben Ginsberg, released a comprehensive report advocating new voting reforms to ensure that no voter wait longer than 30 minutes to vote. Despite the long lines in states like Florida and the backlash in 2012 against efforts to make it harder to vote, the effort received no bipartisan support in Congress. "I don't think it's the federal government's role to make sure there are no long lines," said Representative Candace Miller, Republican of Michigan, chairwoman of the House Administration Committee, which had jurisdiction over election reform. The VRA fix didn't fare any better. Lewis and Sensenbrenner testified on the bill's behalf before the Senate Judiciary Committee. "The Voting Rights Act is needed now more than ever before," Lewis said. But neither could convince GOP supporters of the 2006 reauthorization to back the new bill. "They're finding now how difficult it is to find a formula that people will support," said Mel Watt, who left Congress in early 2014 to become director of the Federal Housing Finance Agency. "Politically, it's very difficult." There were 19 Republican senators still serving who had voted for the VRA in 2006, but none stepped forward to sponsor the new bill. They included the Mississippi Senator Thad Cochran, who narrowly defeated a Tea Party challenger by urging blacks to vote for him in the Republican primary. Like his Republican colleagues, Cochran praised the Shelby County decision, saying, "I think our state can move forward and continue to ensure that our democratic processes are open and fair for all, without being subject to excessive scrutiny by the Justice Department." Sensenbrenner's clout had also waned in the House. The new chairman of the House Judiciary Committee, Bob Goodlatte of Virginia, had voted for the 2006 reauthorization, but also for every amendment to weaken it. The Arizona representative, Trent Franks, chairman of the Subcommittee on the Constitution, had been one of the 33 House Republicans to vote against the 2006 law. Neither was eager to see the legislation resurrected. Hans von Spakovsky testified against the bill in the House. "There is no evidence of widespread, systematic discrimination in the covered states, or that they are any different from any other states, and there's no reason for Congress to take any action," he said. Thernstrom testified against it in the Senate on the one-year anniversary of the Supreme Court's decision. "The decision in Shelby County was absolutely right," she said. "The statute had become a period piece." For many years, critics of the VRA were a minority of congressional Republicans. Now, for the first time, the likes of von Spakovsky and Thernstrom had a majority of Republicans on their side. The Southernization of the Republican Party that had begun when LBJ signed the VRA and accelerated following the 1994 election reached a pinnacle after 2010. With Congress unwilling to fix the VRA, the fight to protect voting rights shifted from the legislative body to the courts. In early July, 72-year-old Carolyn Coleman pushed her wheelchair up the steps of the federal courthouse in Winston-Salem to testify against North Carolina's voting law. The Justice Department and advocacy groups like the North Carolina NAACP and ACLU were asking the District Court Judge Thomas Schroeder for a preliminary injunction blocking key parts of the law, specifically the cuts to early voting, the elimination of same-day registration, and the prohibition on counting a ballot cast in the wrong precinct before the midterm elections in 2014. The first hearing was held a year after the law passed. Coleman had grown up in Savannah, Georgia, and joined the youth division of the Alabama NAACP in 1964. She had concentrated on voter registration and had participated in the last day of the march from Selma to Montgomery. After the passage of the VRA, Coleman had spent a year registering voters in Mississippi, where her friend Wallace Jackson, an NAACP leader in Natchez, was killed by a car bomb after receiving a promotion at the local tire plant. A year later, Coleman was in Memphis organizing striking sanitation workers when King was assassinated. She served as president of the North Carolina NAACP and Southern Voter Education Director of the NAACP before winning election to the county commission in Greensboro's Guilford County in 2002. She had lobbied hard for reforms like early voting and same-day registration to expand North Carolina's electorate. When the legislature passed House Bill 589, I was devastated, Coleman testified. I felt like I was living life over again. Everything that I had worked for the past 50 years was being lost. Rosanelle Eaton testified after Coleman. She was the first one in the courtroom, looking resplendent in her trademark pantsuit and matching hat. Voting should be free and accessible to everyone and give everybody a chance, she said. Mrs. Eaton, why have you dedicated so much of your time and effort over the years to helping people vote and to voting-related activities? Bridget O'Connor of Kirkland and Ellis, who represented the North Carolina NAACP, asked her. Well, I think it is because my foreparents or forefathers didn't have the opportunity of registering and voting, Eaton answered. So when I was young, I read the history, and then I decided it was just my intention to try and help people to reach the point that they could do something. Lawyers for the plaintiffs argued that the voting restrictions had been passed to silence black voters like Coleman and Eaton. The sequence of events leading up to the bill show that HB 589 was intended to target the very reforms that had expanded opportunities for African Americans for over a decade, the Justice Department lawyer Catherine Meza argued in court. African Americans in North Carolina, Meza pointed out, were twice as likely to vote early, use same-day registration, and vote out of precinct compared with whites. They were also disproportionately less likely to have government-issued IDs, but the voter ID provision didn't go into effect until 2016 and wasn't discussed much in court. Under Section 5, North Carolina would have had a very difficult time proving that the law did not leave African American voters worse off than before. But showing a violation of the VRA under Section 2 was a much tougher job for the Justice Department and civil rights lawyers. Section 2 had primarily been applied to vote dilution cases like Mobile v. Bolden and Thornburg v. Jingles, in which blacks were prevented from being elected to office, not to voting changes that restricted access to the ballot, like voter ID or ending same-day registration. The standard here is the totality of the circumstances test, that as a practical matter, African American voters will have less opportunity to participate in the political process as compared to white voters in their ability to register, to cast a ballot, and to have that ballot counted, Bert Russ of the Justice Department argued. But as a practical matter, there were few relevant precedents for the DOJ to point to, and the federal government, not the state, now had the burden of proof. This was uncharted territory. Like the Allen and Jingles cases, the North Carolina case could set an important legal precedent. Lawyers for North Carolina portrayed the voting law as a mere policy dispute, not a case of voting discrimination. The fact that they prefer them, the fact that they think same-day registration, out-of-precinct provisional balloting, these things are good policy, does not mean that they are legally entitled to them, argued Alexander Peters from the State Attorney General's office. The new law puts North Carolina in the mainstream of other states with regard to election laws, argued Butch Bowers, a South Carolina-based lawyer representing Governor McCrory. Because other states, like South Carolina, did not have expanded early voting or same-day registration, Bowers suggested there was nothing wrong with curtailing or eliminating those reforms in North Carolina. The defense presented little evidence of voter fraud to justify the law. At one point, the plaintiff showed a videotaped deposition of the North Carolina State Board of Elections director, Kim Strach, who was married to one of the state's lawyers in the case. I am not aware of specific instances of voter impersonation, Strach said on tape. The video showed the plaintiff's lawyers handing Strach a chart showing just one case of voter impersonation in the 2004 and 2008 elections when 7.8 million people voted. I think the number speaks for itself, she said. Stratt sat in the courtroom, mortified as she watched herself on tape. The defense lawyers were furious afterward. "Why did we let them show that edited video? Did we know they were going to show it?" one lawyer asked. "No," the other responded. But Chris Coates, the former head of the voting section during the Bush administration, who argued in defense of North Carolina, said the state was under no obligation to present specific evidence of voter fraud because of the Supreme Court's Crawford voter ID decision. Crawford also says that before a state enacts a voter ID or any other type of voting procedure, that if the interest that they are trying to achieve is combating fraud, that there does not have to be evidence that fraud has been committed in the state, Coates said. 2 days after the 49th anniversary of the VRA, Judge Schroeder, a George W. Bush appointee, denied the preliminary injunction in a lengthy 125-page opinion. A preliminary injunction is an extraordinary remedy to be granted in this circuit only upon a clear showing of entitlement, he wrote. Even assuming plaintiffs are likely to succeed on the merits, they have not demonstrated they are likely to suffer irreparable harm, a necessary prerequisite for preliminary relief, before trial in the absence of an injunction. The trial to consider the full merits of the voting law, including the voter ID provision, wouldn't occur until the summer of 2015. Schroeder concluded that even if African American voters disproportionately used the state's voting reforms, they would still be able to openly participate in the electoral process and would not face an inequality of opportunity to vote. The past success of Section 5 paradoxically made the case harder to win under Section 2. As Schroeder noted, vote denial claims under Section 2 have thus far been relatively rare, perhaps due in part to the fact that since 1965, many jurisdictions, including many North Carolina counties, were under federal control and barred from enacting any new voting procedure without first obtaining preclearance under Section 5. What would have been a slam-dunk case for the Justice Department and civil rights groups before Shelby had now become a long shot. The law was already preventing people from voting. Craig Thomas of Granville County, North Carolina, registered to vote before he deployed to Afghanistan with the U.S. Army. After serving abroad for 18 months, he went to vote early in the state's primary on April 30th. He had returned from Afghanistan to the same house in the same precinct, but was told at the polls that there was no record of registration for him. In the past, Thomas could have re-registered during the early voting period and cast a regular ballot using same-day registration, but he now had to cast a provisional ballot, which was not counted. Thomas was one of 454 North Carolina voters who would have had their ballots counted in 2012, but did not have them counted in the 2014 primary because of North Carolina's elimination of same-day registration and prohibition on counting a provisional ballot cast in the wrong precinct. These new restrictions disproportionately burden black and Democratic voters. While black voters make up 22% of all registered voters, they were 39% of those who lost their votes because of the two rule changes, according to a review by Democracy North Carolina after Schroeder's opinion. Democrats are 42% of the state's registered voters, but 57% of those disenfranchised by the new rules. This new evidence came before the Fourth Circuit Court of Appeals in Charlotte. On October 1, 2014, just weeks before the election, 2 of 3 judges overruled parts of Schroeder's opinion, reinstating same-day registration and out-of-precinct voting for the midterms. Judge James Wynn, an African-American Obama appointee, pointedly asked the state's lawyers, "Why doesn't North Carolina want people to vote?" It was a small yet important victory for voters in North Carolina. Nearly 100,000 North Carolinians, including twice as many blacks as whites, used same-day registration in 2012. States with same-day registration and early voting, like North Carolina, had the highest voter turnout in the country. 9 days later, less than a month before the midterms, the Supreme Court overrode the Fourth Circuit and restored the new voting restrictions. The appeals court had erred by reinstating the voting reforms so close to the election. There was a cruel irony behind the court's last-minute intervention. If it had not been for the Shelby decision, Justice Ginsburg noted in her dissent, these measures likely would not have survived federal preclearance. Elizabeth Golar was born in rural southwestern Louisiana in 1938 in the small town of Jennings, the county seat of Jefferson Davis Parish. After growing up in the Jim Crow South, she felt voting was always important. "Because I've earned it," she said, "because it simply wasn't allowed and it should be now forever." In 2013, after retiring as a school cook, she moved to Texas to live with her daughter in Austin. She had a driver's license and birth certificate from Louisiana, but ran into problems when she tried to get a driver's license in Texas, which she needed to vote. She was told that the name on her birth certificate, which had been incorrectly filled out by the midwife who had delivered her at home and listed her mother's maiden name, had to match her current name. Golar returned to a Department of Public Safety office to apply for a voting-only ID, but was once again told she needed a matching birth certificate. She then hired a lawyer in Louisiana to get her an amended birth certificate. She didn't know when or if that would happen, and couldn't vote in her new home state in the meantime. She called the cost and time of getting a new birth certificate another form of a poll tax. At that point, she got mad and called the NAACP. That's how Golar became a key witness in the trial to block Texas's voter ID law for a second time, which took place in early September 2014 in the sleepy coastal town of Corpus Christi. Lawyers for the NAACP Legal Defense Fund played a video of Golar's deposition in the packed federal courtroom. "Voting is a right that everybody else had, and it's a celebration," she said, "and it's been taken away again." Judge Nelva Gonzalez Ramos of the Southern District of Texas became visibly emotional during Golar's testimony. Golar was one of 17 witnesses who testified about the difficulties of getting a voter ID in the state. Another was Floyd Carrier. During the state's municipal elections in November 2013, Carrier, an 83-year-old who had been an Army paratrooper in the Korean War, brought his expired driver's license, VA card, and voter registration card to the polls in China, Texas, where he'd lived and voted for 60 years. The poll workers immediately recognized Carrier, but would not let him vote because they said he didn't have a valid voter ID. "I felt terrible," Carrier told the court, "because all I did for the country and they turned me down, so I just felt like I wasn't a citizen anymore." His son, the deputy chief of the fire department in Beaumont, had visited 3 counties in a futile attempt to find his father's birth certificate. He'd waited 4 months after submitting an application for a new birth certificate, only to find his father's name misspelled when it finally arrived. Margarito Lara, a 77-year-old from Sebastian, Texas, shared a similarly agonizing story. Lara began voting when Texas still had a poll tax. Like Carrier, he was born at home, and there was no record of his birth. He'd been trying to get a birth certificate for over a decade, traveling to 4 different counties with his daughter, and could no longer vote with his expired driver's license or voter registration card. The stories of long-time voters like Golar, Carrier, and Lara did not reflect positively on Texas. Nearly 800,000 registered voters lacked acceptable voter IDs in the state, Elizabeth Westfall of the Justice Department said in her opening statement, and Hispanics and African Americans make up a disproportionate share. Texas had issued just 279 new voter IDs by the beginning of the trial. 9 plaintiffs in the case, twice as many potentially disenfranchised voters as there were cases of voter impersonation presented by Texas officials, lacked voter IDs. The state conceded at trial that it had successfully prosecuted only 4 instances of in-person voter fraud over the past 12 years. Representative Todd Smith, the Republican chairman of the House Elections Committee from 2009 to 2010, testified that legislators knew that minority voters would be most affected by the new law. If the question is, are the people that do not have photo IDs more likely to be minority than those that are not, I think it's a matter of common sense that they would be, he said. I don't need a study to tell me that. But given the politics of voter ID in Texas, even Republican skeptics were forced to vote for the bill known as SB 14. I think every Republican member of the legislature would have been lynched if the bill had not passed, Smith admitted. 3 weeks after the trial ended, Judge Ramos, an Obama appointee, struck down the law under Section 2 of the VRA in a searing 147-page decision. The court holds that SB 14 creates an unconstitutional burden on the right to vote, has an impermissible discriminatory effect against Hispanics and African Americans, and was imposed with an unconstitutional discriminatory purpose, Ramos wrote. The court further holds that SB 14 constitutes an unconstitutional poll tax. Ramos's decision was the most extensive rebuke of voter ID laws issued by a federal court to date, debunking the myths that everyone had a voter ID, that it was easy to get one, that there was an epidemic of voter fraud necessitating the new laws and that such laws were always constitutional. She concluded that 608,470 registered voters in Texas, 4.5% of the electorate, lacked voter IDs, with African Americans 3 times as likely as whites not to have one, and Hispanics twice as likely. To call SB 14's disproportionate impact on minorities statistically significant would be an understatement, she wrote. The judge asserted the law was passed not to combat voter impersonation in Texas, which the record showed was virtually non-existent, but to make it harder for blacks and Hispanics to vote. This court concludes that the evidence in the record demonstrates that proponents of SB 14 within the 82nd Texas legislature were motivated at the very least in part because of, and not merely in spite of, the voter ID law's detrimental effects on the African American and Hispanic electorate, Ramos wrote. Most important, Ramos's finding of intentional discrimination meant that Texas could be bailed in under a little-known provision of the VRA, Section 3, becoming the first state since the Shelby decision to once again have to submit its voting changes to the federal government under Section 5. In contrast with North Carolina, the decision represented a majority victory for the Department of Justice and Eric Holder, who had recently announced he was stepping down as Attorney General. 2 years earlier, he'd been widely ridiculed for calling Texas's voter ID law a poll tax. Now a federal court had used those same words. Even after the Voting Rights Act was seriously eroded last year, we vowed to continue enforcing the remaining portions of that statute as aggressively as possible, Holder said. This ruling is an important vindication of those efforts. The discussion around voter ID laws had shifted significantly since the Crawford decision. Judge Richard Posner, who wrote the 2007 opinion upholding Indiana's voter ID law in the Seventh Circuit, said 6 years later that such laws were now widely regarded as a means of voter suppression rather than of fraud prevention. Justice John Paul Stevens, the author of the Crawford decision, admitted that he now agreed with Justice Souter's dissent in the case. The impact of the statute is much more serious on poor, minority, disabled, and elderly voters than he'd initially recognized, Stevens conceded. A day before the Texas and Wisconsin decisions, the nonpartisan Government Accountability Office released a lengthy study showing that strict voter ID laws in Kansas and Tennessee decreased voter turnout by 2 to 3 points from 2008 to 2012, compared with similar states without voter ID laws, leading to 122,000 fewer votes. Turnout dropped most sharply among the newly registered, the young, and African American voters. It can no longer be disputed as mere assertion that voter ID laws are obstacles to citizens who wish to exercise their fundamental right to vote. As this report shows, it is clearly a fact, Holder wrote. This information should help us move past the ideological arguments that too often dominate the debate on these voting laws and understand them for what they really are. But the victory didn't last long. The U.S. Court of Appeals for the Fifth Circuit, one of the most conservative courts in the country, overruled Ramos 5 days later, reinstating Texas's voter ID law for the 2014 election. The lower court's judgment substantially disturbs the election process of the state of Texas just 9 days before early voting begins, wrote Judge Edith Brown Clement. The Supreme Court reaffirmed the appeals court ruling on October 18th, less than 3 weeks before the election. It was the first time since 1982 that the court had approved a voting law deemed intentionally discriminatory by a trial court. Justice Ginsburg stayed up all night writing her dissent and released the opinion at 5:05 a.m. on Saturday. She disagreed with the appeal court's finding that striking the voter ID law before the election would confuse voters and election officials. The greatest threat to public confidence in elections in this case is the prospect of enforcing a purposefully discriminatory law, one that likely imposes an unconstitutional poll tax and risks denying the right to vote to hundreds of thousands of eligible voters, Ginsburg wrote. 10 days earlier, the Supreme Court had upheld a voting law in North Carolina that Ginsburg believed would have very likely been blocked under Section 5. Now it was upholding a law that in fact had been blocked under Section 5. Indeed, the Texas voter ID law had been struck down by 2 different trial courts under 2 different sections of the VRA, yet remained in effect. It is a major step backward to let stand a law that a federal court, after a lengthy trial, has determined was designed to discriminate, Holder said. 4 major voting rights cases came before the Supreme Court in the month before the election, from North Carolina, Ohio, Texas, and Wisconsin, and in 3 of 4 instances the court refused to block laws restricting voting rights. The post-Shelby voting rights landscape most closely resembled the period before 1965, which the VRA was meant to end, when the blight of voting discrimination could only be challenged on a tortuous case-by-case basis. The loss of Section 5, combined with an often hostile judiciary, created perpetual uncertainty when it came to protecting voter rights. Roberts' long-held view that violations of the VRA should not be made too easy to prove was finally being put into practice. Voters in 14 states faced new restrictions at the polls for the first time in 2014, in the first election in nearly 50 years without the full protections of the VRA. In Texas, Elizabeth Golar couldn't vote for the first time in 60 years because of the state's voter ID law. She was not alone. Betty Thorne, an 84-year-old grandmother who lived in an assisted living facility in Austin, had voted in every major election in her lifetime. Days before the election, Thorne's granddaughter, Amy Gautreaux, took her to a Department of Public Safety office to get a new ID because her driver's license had expired. But Thorne didn't have the correct proof of address documents to get a new driver's license, nor did she have the birth certificate required to get a voting-only ID. When the voter ID law was announced, I didn't understand the big deal, Gautreaux said. I figured most people have ID. Now that it's happened to me, I'm devastated. This is what happened to an elderly person who has family to help her. I can only imagine how many don't have any help. Despite a high-profile governor's race between the Republican Greg Abbott and the Democrat Wendy Davis, voter turnout dropped by 270,000 votes compared with 2010. Only 28% of eligible voters went to the polls, the second lowest turnout rate in the country. Nationally, voter turnout plummeted to the lowest level since 1942. In Texas and across the country, the electorate was older, whiter, and more conservative than in 2008 and 2012. That is what Republicans wanted. Nearly twice as many Americans chose not to vote as voted in 2014. Although turnout was down, voting problems were up. Voting rights groups fielded 18,000 calls at the 1-866-OUR VOTE hotline, a 40% increase over 2010. Some of the biggest problems occurred in North Carolina. Brian McGowan spent 22 years in the U.S. Marine Corps, including 4 tours in Afghanistan and Iraq. When he was stationed at Camp Lejeune in North Carolina from 2005 till 2010, McGowan used same-day registration to register and vote during the early voting period in the state. He relocated to Georgia in 2010 because of his military service and returned to North Carolina in 2014. On October 23rd, the first day of early voting in the state, McGowan arrived at his new polling place in western North Carolina to update his registration and vote, as he had done in the 2008 presidential election. But this time he was turned away. Because North Carolina had eliminated same-day registration and the state's registration deadline had passed, McGowan was unable to update his registration and vote. All I want to do is cast my vote, he said. McGowan's story was not atypical in 2014. As a result of the state's new voting restrictions, voters like McGowan were not able to register during the early voting period. Many voters arrived at the wrong polling location where they could no longer cast a regular ballot out of precinct. There were longer lines during early voting because the state cut early voting by a week, and there were longer lines on Election Day because of the shorter early voting period, particularly in heavily Democratic urban areas like Durham, Raleigh, and Charlotte, where wait times stretched up to 3 hours at some polling places. Leslie Culbertson of Charlotte arrived at her polling place at Eastover Elementary School expecting to quickly cast her ballot. The last time I voted here, the line was nothing, she said, but this time the wait was an hour, and Culbertson had to leave the polls without voting to pick up her children from school. Despite the best efforts of the Moral Monday Coalition to mobilize voters, the new restrictions affected the outcome of the election. In a fiercely contested U.S. Senate race, the Republican Tom Tillis, who, as Speaker of the North Carolina House of Representatives, had overseen the state's voting law, defeated the Democrat Kay Hagan by 48,000 votes. Nearly 5 times as many voters in 2010 used the voting reforms eliminated by the North Carolina GOP. 200,000 had voted during the eliminated first week of early voting, 21,000 had used same-day registration, and 6,000 had cast out-of-precinct ballots. Democracy North Carolina estimated that 30,000 to 50,000 voters were kept from the polls because of the new law. The number of voters potentially affected by new barriers to the ballot box exceeded the margin of victory in close races for Senate and governor in North Carolina, Kansas, Virginia, and Florida, according to the Brennan Center for Justice. It was a grim election for voting rights advocates. Republican officials who led the effort to make it harder to vote, such as Tillis in North Carolina and Abbott in Texas, won election to higher office. The GOP tightened its grip on state governments, controlling more states than at any time since the 1920s, meaning that voters would face more restrictions at the polls in the coming years. The hurdles to participating in the political process kept getting higher. 4 months before the election, 800 people attended a Moral March to the Polls rally in Winston-Salem on the first day of the district court hearing in July 2014. Tyler Swanson and Derek Smith stood behind Reverend Barber on stage, holding signs that said, "Organize, register, vote, and repeal attacks on voting rights." Let us not forget that this bill was passed after Shelby. Turn to your neighbor and say, "After Shelby had destroyed Section 5 pre-clearance by annihilating Section 4, Barber told the crowd. America, you better look at North Carolina, because this bill shows the nation what these extreme right-wingers, especially in the South, are willing to do to suppress the vote without having to go through pre-clearance. To combat the Supreme Court decision, the North Carolina NAACP had placed 50 young organizers in 50 counties to focus on registering new voters. They called it Moral Freedom Summer 2014, a tribute to the 50th anniversary of Freedom Summer, when Lewis and thousands of young activists went to Mississippi and Goodman, Cheney, and Schwerner lost their lives. "How many of you are going to leave here and remember the blood of the martyrs?" Barber asked. Hundreds of hands went up. Swanson spent the summer of 2014 organizing in Catawba and Iredell counties in western North Carolina, heavily Republican areas where Obama had won only 30% of the vote in 2012. A lot of African Americans had given up on voting, he said. Many of his peers had lost faith in the justice system after the shootings of black teenagers like Trayvon Martin and Michael Brown. But sitting in the courtroom in Winston-Salem for the first time in his life, Swanson was inspired by the testimony of voting rights activists like Rosanelle Eaton. Hearing what they had to go through, that inspired me to fight even harder. He registered 115 new voters in a month. It wasn't flashy work, but Swanson felt as if he were making a difference. The North Carolina NAACP registered 5,000 new voters that summer. The activists of the past had inspired the activists of the future. Swanson said his goal was to move to Georgia and one day represent the congressional seat of his hero, John Lewis. This concludes Give Us the Ballot by Ari Berman, narrated by Tom Zingarelli. Copyright 2015 by Ari Berman. This unabridged audiobook is produced by arrangement with Farrar, Straus & Giroux, LLC, and was produced in the year 2015 by Tantor Media Incorporated, which holds the copyright thereto. Please visit Tantor.com for more information on our growing library of unabridged audiobooks and to take advantage of special offers.